Good morning, everyone. My name is Charles Allen. I'm the Ward 6 Council member and chair of the Council's Committee on the Judiciary and Public Safety. Today is Thursday, November 4th, 2021. We're convening this public hearing over the Zoom virtual platform. The time is now 9:35 a.m. and I'm calling to order this public hearing of the committee. Today, the committee will be considering Bill 24-0416, the Revised Criminal Code Act of 2021, which was introduced by Chairman Mendelson at the request of the Criminal Code Reform Commission on October 1st of this year. The bill would comprehensively overhaul the district's criminal code to improve its clarity, completeness, consistency, and proportionality. And when I say comprehensively overhaul, I'm not being hyperbolic. The bill we're considering is more than 300 pages long, and it would transform the district's criminal code from its current state, which is, frankly, a messy patchwork of laws written by different legal bodies over the district's history and different legislatures over the many decades, to a modern criminal code accessible to the general public and practitioners alike. So how do we get here? Let's walk through that quickly. As background, the district's criminal code was first enacted by Congress back in 1901, well before the district had any local control of its criminal justice system. Congress continued to impose its own criminal law on the district until passage of the Home Rule Act in 1971, when the council was granted the authority to enact its own criminal laws. Following Home Rule, the council has, in fits and starts, amended the criminal code, but has never undertaken a holistic modernization effort. As a result, our criminal code reflects the criminal law as it existed in the early 20th century, uninformed by best practices and emerging science. This stands in stark contrast to the majority of states that have comprehensively modernized their criminal codes during the 1970s and 1980s. The district's current criminal code suffers from three fundamental flaws. First, it isn't clear. This is in part because the behavior or conduct that constitutes a crime isn't clearly spelled out. Let's look at how murder in the second degree is defined under the current code. Quote, whoever with malice aforethought kills another is guilty of murder in the second degree, end quote. Malice aforethought. If you heard that and thought it meant something like the general ill will that someone might have, you'd be wrong. To fully understand the meaning of malice aforethought, you'd need to consult a whole body of case law. Some crimes, even serious ones, are undefined altogether. For example, the district's current manslaughter statute simply states, whoever is guilty of manslaughter shall be sentenced to a period of imprisonment not exceeding 30 years. Nowhere does the statute state what elements must be proven in order to find a person guilty of manslaughter. The practical effect is that it's often unclear what constitutes a crime. And sure, while clarity is important in all laws, it is especially important with criminal laws, since even a suspected violation authorizes the government to exercise its greatest power over its residents, to stop and question them, search them, detain or arrest them, or imprison them. The second big problem with the district's criminal code is that it uses disproportionate penalties. For many offenses, the penalty is too severe for the prohibited conduct, but for other offenses, the penalty is too lenient. Disproportionate penalties are one result of the piecemeal changes that have been made to the district's criminal code over multiple decades. For example, in the 1980s and 1990s, the DC Council completely revised the district's theft and fraud laws and penalties and the district's sex offense laws and penalties. However, there's never been a comprehensive review of all the penalties in the current criminal code and how they relate to each other. This produces bizarre results and undermines the legitimacy of our laws. The third problem is the current code doesn't reflect the values of the district residents. It's worth repeating again here. Much of our criminal code that we have in the district was enacted by Congress over a century ago. For example, for much of this time, those members included ardent segregationists. It's hard to imagine that the legislative body reflected the values of district residents even then, and it certainly doesn't reflect our values today. While the council still doesn't have full autonomy, I believe we must use the authority that we do have to ensure that our criminal code is actually our own. It's also important to realize that failing to resolve ambiguities in the criminal code functionally cedes some of the legislative branch's authority to the courts, who have to interpret the code as best they can in the state it's in. The Revised Criminal Code Act presents an opportunity for the council, informed by our constituents and our stakeholders, to address these issues. In 2006, the council realized the poor state of our criminal code and expanded what was then the DC Sentencing Commission to become the Sentencing and Criminal Code Commission, tasked with making recommendations to improve the clarity, consistency, and proportionality of the criminal code. In 2016, the Criminal Code Reform Commission, or what we call as the CCRC, was spun off as its own independent agency with a mandate developing comprehensive recommendations for revising the district's criminal code. The CCRC worked with an advisory group composed of subject matter experts, prosecutors, public defenders, to develop the recommendations before us today. So importantly, let me thank the CCRC, all of its staff members, and the members of the agency's advisory group, the Office of the Attorney General, the United States Attorney's Office, the Public Defender Service, and our 2 law professor members for their 15 years of work on each and every element of each and every offense. It has been, frankly, a monumental task to even get to this point, with a lot of discussion and compromise to get the package to the council. Today is the first of several hearings the committee will be convening on the bill. Our first panelist today will be Richard Smeckel. He has served as executive director of the CCRC since its founding. Our other panelists include a variety of subject matter experts and practitioners, including several current and former members of the American Law Institute, the body of judges, lawyers, and scholars that adopted and promulgated the modern penal code in 1962. And many thanks to all of you for joining us. And we're looking forward to your testimony. Very briefly, let me go over some logistics for this morning's hearing. After Director Smeckel, our public witnesses will be joining us on Zoom as attendees about, I think, around 11:30, and committee staff will be promoting you as panelists when we turn to your panel. You're also welcome to watch the hearing on our office's Facebook page and jump in and out of the attendee room. If at any time you need some assistance, just use our chat function to reach out to our committee staff. The committee will hold its second hearing on this bill on December 2nd from 9:30 a.m. to 4 p.m. This hearing will be reserved exclusively for members of the public to testify. It's a great opportunity to ensure that your views and perspectives on criminal law are considered. And anyone who wishes to testify can do so by emailing the committee at judiciary@dccouncil.us by the close of business on Friday, November 26th. The committee will also hold a third hearing dedicated to government witnesses and members of the advisory group on December 16th. And finally, if you have any written testimony on the bill, you can email it to the committee at judiciary@dccouncil.us, and the record will close at the close of business on December 24th, I believe. And we'll double check and make sure we share all of that. So with that, I believe we will have some colleagues. Some of my colleagues will join us during the day, and I'll turn to them for any opening statements when they're here. But what we will do next is turn to Executive Director Richard Smeckel. So, Mr. Smeckel, welcome. Good morning. Again, I know this has been years and years and years and a lot of people's hard work to get us to today. And of course, we still have a lot of hard work ahead of us, but we appreciate you taking the time today. Look forward to hearing your testimony. And then I have a lot of questions that we'll walk ourselves through after that. So let me turn it over to you, Mr. Smeckel.
Thank you. Good morning, council members, Chairman Allen. Thank you for holding this first hearing on the Revised Criminal Code Act of 2021. I'll refer to it as the RCCA. I also want to thank the full council and the mayor for initiating this process for us 5 years ago by creating the CCRC, our agency, and charging it with modernizing the district's criminal code. To start my testimony today, let me summarize the basic case for supporting this bill. The need for the RCCA is great. I am here because the district's current criminal code has not undergone a comprehensive revision since its creation by Congress in 1901. It still uses a 19th century structure that relies heavily on past court opinions to articulate what the elements of crimes are and what the defenses to crimes are. Per this 19th century model, offenses typically have few or no penalty gradations to distinguish more and less serious conduct. 1 or 2 high statutory maximums are authorized for all forms of an offense, typically, with maximums that usually far exceed what judges today apply. More recently, mandatory minimum penalties were added, even though research now shows they do not deter crime effectively. The right to a jury in misdemeanor cases was limited in the 90s because of concerns about court resources, even though about 40 states managed to provide access to juries for any charge carrying incarceration time. In sum, the district's current criminal code fails to meet the basic legislative function of fully and specifically articulating what the laws are, and is out of sync with current public norms and best practices. This failure requires prosecutors and judges to decide which of many overlapping charges to bring, what elements establish criminal liability, and which of the wide-ranging penalties are merited. Even with the best of intention, such vast discretion is subject to errors, arbitrariness, and bias. This failure undermines the legitimacy of the criminal law and erodes public trust and confidence in the criminal justice system. Realizing the need to go beyond what piecemeal legislative efforts accomplished in the past, the district has invested, as you said, considerable time and resources to develop a plan for comprehensive reform of the criminal code. The council created the CCRC 5 years ago and directed it to provide recommendations that improve the clarity, consistency, completeness, organization, and proportionality of criminal statutes. The CCRC was directed to examine model codes, best practices in other jurisdictions. The agency's statute also designated an advisory group. They held years of monthly meetings with staff, gave continuous feedback on drafts, and in the end voted unanimously to approve submission of the CCRC recommendations to the mayor and the council. It has been a multi-year, transparent, research-driven process to develop the RCCA now before you. The proposed legislation would comprehensively modernize not only individual criminal offenses, but the entire design of the code. It adopts the basic structural features of the American Law Institute's Model Penal Code, or MPC, the standard for contemporary criminal codes that has been adopted by most states and tested and validated for decades. For the first time in the district, the RCCA specifies all the elements that must be proven for each offense, including the required culpable mental states. For the first time, the RCCA defines common terms, codifies defenses, and implements a uniform system of penalty classes. Offenses and penalty enhancements are reorganized, sometimes combined, sometimes broken out, so the organization is logical and gaps and overlap between offenses is reduced. Individual offenses have been graded to distinguish more and less serious conduct of the same type. Penalties across different offenses now account for how multiple charges and penalties can apply to one real-life event and are updated to reflect some of our recent survey results on how district voters rank the relative seriousness of offenses. The RCCA is not just a broad updating of criminal statutes, it is arguably the district's first criminal code. And by that, I mean, it's the first time that, like other states, the district's various criminal laws have been reviewed and redesigned to function together as a clear, consistent, complete, organized, and proportionate system of laws. Now, let me step back a bit and explain the state of the current criminal code for those who haven't spent the last 5 years or so immersed in it. To do that, I'll try to pull up some slides here. Just a moment, I'll share my screen. All right. I will discuss some of the current statutory language and say a bit about the bill's development and highlight some of the legislation's main features. And to start with, what is a criminal code? When I use the term criminal code today, I'm referring to so-called substantive criminal law. That is, the statutes that name, establish liability requirements, and authorize punishments for criminal acts. That substantive law has been the primary focus of the CCRC's work to date. The CCRC has not addressed statutes about policing, the powers of the judiciary, or other criminal procedure matters, except as necessary to reform these substantive law provisions. Now, the DC Code Title 22 is the heart of the district's criminal code, and it's the core of what the CCRCA is doing. It creates a new Title 22A that replaces most all of the current Title 22. The RCCA's Title 22A would replace murder, assault, theft, most of the crimes and penalties in use and in current Title 22. The RCCA also addresses a number of major firearm, drug, and other offenses that are located outside of Title 22, revising the language, but leaving them where they are in the current DC Code. Now, when was the district's criminal code last revised? As you pointed out, never, at least not as a whole. The criminal code dates back to Congress's passage of the DC Code in 1901. Since that time, there's never been a comprehensive update to district statutes. In fact, dozens of the crimes codified in 1901, complete with their references to stables, canal boats, and steamboats, have not been amended at all or have had only their penalties updated somewhat. These 1901 holdover offenses include many of the most common and serious crimes still prosecuted in the district, such as murder, manslaughter, robbery, burglary, and assault. Now, you might ask, what's the problem with having these unrevised offenses? I would say references to steamboats are not the problem. Practically, the fact that district offenses, even some of the most common and serious, continue to have anachronistic features and references to steamboats or being placed in the workhouse of the 1800s doesn't matter, to the extent that those referenced provisions don't affect how the statutes can be used today. What matters is that the unrevised offenses are frequently unclear, inconsistent, and incomplete in ways that do affect how the statutes are used today. What does matter is that they carry disproportionate penalties and are organized in a way that artificially multiplies liability. These defects lead to a host of real problems with real consequences for those who work in and interact with the district's justice system today. For example, prosecutors, judges, defense attorneys waste hours litigating unclear district statutes. Jurors are confused at what they're being asked to decide, asked to make such consequential decisions with scant guidance. Prosecutors have to choose among a profusion of overlapping offenses that address the same behavior with sharply different penalties. Ordinary behavior and speech protected by the First Amendment appears to be criminalized by many of the statutes. Judges must apply mandatory minimums that don't suit the person before them. Convictions have been overturned because the statutes leave out critical elements. These are just some of the problems. My time's limited, but to make these defects and the problems that they can cause less abstract, I want to discuss 3 current DC Code statutes. All right, first up is the district's current simple assault statute that states whoever unlawfully assaults or threatens another in a menacing manner shall be subject to a fine of $1,000 or imprisonment up to 180 days or both. So this provision is called the simple assault statute to distinguish it from an array of other felony assault type statutes in the code that punish more severe types of assaults. For example, if a dangerous weapon is involved or there's an injury that requires hospitalization. So there's several points to make here. First is that this is one of the most foundational and most common of district offenses. It constitutes 11 to 12% of all criminal charges in recent years. And it hasn't changed, as you can see, since 1901, except for the authorized imprisonment, which in that case was lowered to be below the threshold where defendants have a right to a jury trial. Second point here is that while there's a bit of content about threatening, the statute says nothing at all about what constitutes an assault. The statute is incomplete to the point of being vacuous, giving only a name and a punishment. Of course, we all have intuitive ideas about what an assault is, perhaps some kind of violent interaction in which one person strikes and harms the other. The problem with intuitive definitions, however, is that while they might fit some common scenarios, they leave unresolved many other variations. Consider, is it an assault to gently but offensively touch another person in a non-sexual manner when the person has clearly said they don't want to be touched? In other words, is pain or injury necessary for assault liability? Or is it an assault to punch another person, perhaps in a backyard fight, when the injured person freely consented to engaging in that fight, consented to being struck? Rephrase, what is the role of consent in assault? And can one consent to any degree of harm? Lastly, is it an assault to accidentally knock a person down when, say, running down a sidewalk, aware that running in that area was likely to cause someone injury? What mental state is necessary to be guilty of assault? This last question bears emphasis and some more explanation. For centuries in Anglo-American criminal law, 2 main kinds of elements have been required to be held guilty of an offense: engaging in prohibited conduct, what is often described as the actus reus in legalese, and a culpable mental state, or mens rea. Now, for all but a very few so-called strict liability crimes, crimes for which the legislature said there are no culpable mental state requirements, and these are mainly regulatory type crimes where people are held to a higher standard, the Supreme Court has said, no, there has to be a culpable mental state. Otherwise, if we didn't have it, people could be imprisoned for ordinary, reasonable mistakes that happen every day. Now, obviously, the district's assault statute doesn't say anything about the necessary mental state or any of these other issues. Perhaps more surprisingly, though, you might assume that the courts have stepped in to resolve these matters in the more than 100 years since the statute was codified, but they haven't. In fact, a recent case raised the question whether a single, non-violent, non-sexual, but clearly unwanted touch constituted an assault. And there was so much disagreement within the DC Court of Appeals that the full court took the extraordinary step of immediately throwing out a decision by a smaller group of its judges so that all appellate judges could consider the even more fundamental question of what are the elements of simple assault? Now, that was 2 years ago, so we still don't have an answer. 2 years after the case was taken to the full court, and 120 years, more than 120 years, after the simple assault statute was codified by Congress. We still have no answer. Despite this fundamental legal uncertainty, in particular cases, police, prosecutors, trial judges continue to decide whether to arrest, bring or allow assault charges that turn on these very questions we've been talking about. They do their best to exercise their discretion wisely and may develop their own norms on how to handle common situations in a consistent manner. But without clear laws, that consistency and even the legitimacy of enforcement and charging decisions can be called into question. All right, a second example I want to look at is the district's robbery statute. Now, robbery is one of the most common felony charges in the district. Here's both the 1901 and the current language. It says, whoever by force or violence, whether against resistance or by sudden or stealthy seizure or snatching or by putting in fear, shall take from the person or immediate actual possession of another anything of value is guilty of robbery. Goes on. Again, there's been no change if you look at the 1901 compared to the current, no change to the elements or the maximum penalty since 1901. Unlike assault, though, the robbery statute does list many of the required elements that must be proven. But if you scratch the surface a bit, similar problems emerge. For example, like assault, there is no culpable mental state or mens rea requirement in the statute. However, unlike assault, the Court of Appeals has ruled on the matter, rejecting a government argument that there is no culpable mental state based on their looking at the plain language of the statute. And the court read in an intent to steal requirement. In doing so, it overturned a conviction and said plainly on the record that, quote, mere reading of the statute was plainly inadequate, end quote, to communicate to jurors what robbery requires. That's the situation we're in. The statute can't even be read to jurors because it's misleading. Unfortunately, over 50 years since that first robbery ruling where they said that, the statute still hasn't been changed or updated legislatively to either reject or adopt what the court said is this additional element. A different kind of flaw evident in the robbery statute is the lack of gradations. This is a little different than assault. In the assault statutes, collectively, we have many assault statutes which provide for different levels of punishment, some more severe than the simple assault, which we saw earlier. But here there's only one robbery statute with one penalty. Conduct as minimal as pickpocketing or stealthily taking a coffee mug or any object from a desk or a table near the owner, a purse, is subject to the same robbery charge and penalty as a brutal, violent crime that leaves the victim hospitalized. Same robbery charge. There might be other charges as well. The vastly different experience of victims in these cases is just ignored by the current robbery statute's breadth. Whether or not a 15-year maximum penalty is proportionate for the more severe forms of robbery is something reasonable minds can disagree on and talk about, but it depends on an array of considerations. What other crimes and penalties are available for those most severe forms? But regardless, it seems clear that a 15-year maximum penalty for pickpocketing is disproportionate, especially when the same maximum penalty applies to all robberies that include serious injuries. All right, final example for statutes I want to look at is talks about overlap more. The district has two main threat statutes. One is a misdemeanor, unchanged from 1901, that simply states whoever is convicted in the district of threats to do bodily harm, and then his penalty is subject to up to 6 months in prison. The second was created by Congress in 1968. It became law just months after the assassination of Dr. King, and it states, whoever threatens within the District of Columbia to kidnap any person or to injure the person of another, or physically damage the property of another or of another person, in whole or in part, is subject to up to 20 years in prison. In recent years, the misdemeanor charge has been charged about 10 times more frequently than the felony charge, but both are common. Now, looking at these statutes, put aside the other drafting problems, the fact that there's no culpable mental states mentioned, defects that have been the subject of a lot of litigation in both DC courts, and threat statutes in other jurisdictions have gone to the Supreme Court on similar matters. Ignore too that there are other district crimes that appear to also criminalize threats or something very similar, such as the simple assault statute we just discussed, which referred to someone who, quote, threatens another in a menacing manner. All right, so put those aside. Just looking at these two statutes as they are, it appears they squarely overlap. Courts examining the issue have agreed that there isn't any real difference between the injury described in one and bodily harm in the other. They're essentially identical. And either a 6-month misdemeanor or a 20-year felony, that's 40 times higher than the 6-month penalty. Either one can be charged. Although one judge dissented from the court's analysis when this was challenged and called the result an absurdity, the overlap has survived due process and equal protection challenges, and the choice of charges which to bring remains purely a matter for prosecutorial discretion. Moreover, while ordinarily a robbery based on a threat to hit the victim would be considered just one bad act, because the threats and the robbery statutes use different wording, the DC Court of Appeals has held that a person can be convicted of both crimes based on the same occasion, same event. So beyond the overlap between the felony and misdemeanor threats, there's also overlap with other offenses involving a threat and increased liability. A robbery that includes a threat of bodily injury, but no actual bodily injury, is authorized under the current DC code to be sentenced to up to 35 years of imprisonment, 15 for the robbery and 20 for the threat if the judge decides to make the sentences run consecutive, which is allowed. The problems with such overlap are many and include undue pressures to plead when facing very high penalties and the possibility of disproportionate or inconsistent sentences being imposed. A more subtle and pernicious problem, however, is that when there are so many charges to choose from, it creates opportunities for unintended errors, arbitrariness, and bias, whether it's unconscious or conscious, to affect the criminal justice process. In a criminal code with widespread overlap, these are just a few examples. And even with all actors acting with the best of intentions, inconsistent and unjust outcomes can result. The last point I want to make about the current state of the DC code is to note that while many jurisdictions have challenges keeping their criminal statutes up to date, the district really is an outlier. Some years back, Professor Paul Robinson, Michael Cahill, now Dean Cahill, who'll be, I believe, testifying later today, and Usman Mohammed, conducted a national review of the district, federal, and 50 state criminal codes. The ranking was in terms of things we've been talking about: clarity, consistency, organization, proportionality. Their results, published in a top law journal, were particularly grim for the district. It ranked 45th among the 52 jurisdictions analyzed. All right, let me say a little bit more now about the development of the RCCA. The problems with criminal statutes that kind of just discussed have been known and discussed for decades. To develop comprehensive recommendations, the council created the CCRC as an independent agency in late 2016. The statute specifically directed to look at these values of clarity, consistency, completeness, organization, proportionality. I keep repeating that because that has been our mission. That's what we've been focused on. And while there may be disagreement, reasonable disagreement on what laws best manifest these values, I don't think those values themselves are controversial at all. That said, I want to stress some of the things that were not part of the agency's focus in its work. The primary goals of the CCRC were not to achieve certain desirable outcomes, such as fewer crimes committed, reductions in financial costs, reduced incarceration levels, racial equity in the district's criminal justice system, or speedy courtroom administration. Of course, these are all critical goals for the criminal justice system as a whole that the criminal code must support. And I assure you that the CCRC and its stakeholders have kept a keen eye on the potential implications of the revised statutes for these larger goals and outcomes. In fact, there's good, though by no means definitive, reason to believe that the RCCA may improve outcomes on all of these broader goals and measures. Psychological research and social science has shown that people are more likely to follow the law and cooperate with legal authorities when they perceive the law to be legitimate, including accurately reflecting beliefs about what is criminal and how serious a crime is. Such perceptions of legitimacy can affect behavior as much as or more than concerns about the risk of punishment, according to research. But while good laws may be necessary for progress on these larger criminal justice goals, they're not going to be sufficient. Success will often depend on factors that have little or nothing to do with the drafting of the criminal code. In particular, research shows that how effective police are at enforcement is the most important factor in deterring crime, not penalties. In addition to specifying the primary goals for criminal code reform, the agency was directed in statute to consult with an advisory group that included council-appointed local law school faculty, designees of the U.S. Attorney for DC, the DC Attorney General, and the Director of the Public Defender Service, also designees of this committee and the Deputy Mayor for Public Safety were on the advisory group. And throughout the nearly 4.5 years in which the agency developed its recommendations, the agency held monthly meetings with the advisory group. They were open to the public. Literally thousands of pages of legal research and draft documents were circulated. Comments were received back. All these materials were posted publicly online at the time of their exchange. Through multiple iterations, the agency developed its recommendations and also an accompanying legal commentary. On March 31st, this year, 2021, the 5 voting members of the advisory group voted unanimously to provide those recommendations and commentary to the council and mayor. The RCCA before you today presents the statutory language from the March 31st recommendations in bill form with only non-substantive changes to the numbering system and style. And I can't emphasize enough what a serious sustained commitment the advisory group members gave to this process. The district's 2 prosecutors, federal and local, and the Public Defender Service often took differing positions, particularly with respect to penalties. But throughout the process, it was a constructive and civil discourse. And I really want to take this opportunity to thank all the advisory group members. It was a lot of work over a lot of years. Their commitment has made this bill possible, and modernization and reform hopefully will move ahead because of their work. The CCRC statute specified multiple sources, authorities to consult during the revision process. The advisory group's comments were obviously a major input, but the CCRC also examined code reforms in other jurisdictions. The Model Penal Code, again, issued by the American Law Institute, and other best practices. We also used data that was shared by the Superior Court, showed current charging and sentencing practices. Finally, it's worth stating explicitly that the agency's recommendations are based primarily on existing district law. This whole project was not a matter of starting with a blank slate or adopting and doing some minor tweaks to the Model Penal Code or some other jurisdiction's law. The foundation of the RCCA is the existing district statutory and case law. Changes to existing statutes or case law were recommended only in furtherance of the agency's statutory mandate, and the commentary that we put together goes into a lot of detail about how current district law has changed. All right, let me turn to talk about the main features of the legislation before us, the RCCA. The bill adopts the basic structural features of the American Law Institute's Model Penal Code. which has been the standard for contemporary American criminal codes. Since its creation, the Model Penal Code's main features have been adopted by most states and tested and validated for decades. There's a lot of case law out there that helps to explain any ambiguities in it. Most of the bill, the RCCA, concerns a new proposed Title 22A that would replace nearly all the current Title 22. The new Title 22A is divided into two main parts, a general part and a special part. Now, the general part provides basic definitions, rules of liability, defenses, and penalty classes applicable to most or all crimes. And then the special part, chapters 2 to 5 of the title, codify particular offenses. They're ranged by the social harm implicated, for example, crimes against persons or property crimes. The RCCA separately provides revised language for various offenses located outside of another titles of the DC code, outside of Title 22A. Now, since the provisions of the general part are nearly all new to district criminal law, I want to focus on them a bit. And among the most important is the codification of extensive standardized definitions that are then used throughout all the revised statutes. These include standardized culpable mental state definitions that hew closely to the definitions recommended in the MPC, ones that have been adopted by most jurisdictions and are frequently referenced even here in the DC Court of Appeals decisions. New rules of construction ensure that a culpable mental state or strict liability apply to every element of every offense, consistent with the approach of the MPC. We've looked at the complex case law on accomplice liability, intoxication, accidents, mistakes, solicitation of crimes, conspiracy liability, attempted crimes. All that is codified now for the first time too. The RCCA general part also codifies for the first time common defenses, self-defense, defense of others, defense of property, execution of a public duty, exercise of a parental duty of care, duress, entrapment, excusing mental disabilities. The fact that to date, neither Congress nor the Council has ever addressed these fundamental matters leaves the district an outlier nationally. The proposed language in the RCCA is largely consistent with current district case law that has developed in the absence of statutory guidance, and it reflects the modern approach that we see in other jurisdictions as well. Another major change in the RCCA is the adoption of a new standardized system of penalty classes. The RCCA provides for 9 felony classes, number 1 through 9, and 5 misdemeanor classes labeled A through E. Each revised offense and offense gradation in the RCCA is assigned to one of these 14 classes with their corresponding authorized maximums and fines. The RCCA proposes elimination of indefinite life and life without parole sentences in favor of a set term of years. The most severe felony penalties in the RCCA, classes 1 and 2, are recommended to carry maximum imprisonment sentences of 45 and 40 years, respectively. Given the district's lack of parole and a maximum sentence reduction of 15% for what's called good time credit in prison, such lengthy terms of years for any single charge roughly approximate to a sentence of life with a meaningful possibility of release. That approach is in line with the recent MPC sentencing recommendation for a jurisdiction's most severe penalty. That is, providing a maximum penalty that has still a meaningful possibility of release. While these maximum numbers are lower than some of the current criminal code, they more realistically take into account the realities of life expectancy and how public safety concerns sharply drop as people age. Given that the average age of offenders committing homicides, the only class 1 and 2 offenses, is in their early or mid-20s, and that about 90% of those convicted are Black men, and the very grim reality that life expectancy for non-Hispanic Black men in the district is under 69 years. These new penalty classes just about match the life expectancy of those who will be sentenced under them. Authorities vary, but recent case law from state high courts indicates that a term of 50 years is an effective life without the possibility of release sentence for juvenile offenders. As adult offenders are older at the time of entry into incarceration, a sentence of life with the possibility of release for adults logically would be shorter than 50 years. In fact, the Federal Bureau of Prisons considers persons incarcerated for a life sentence, including district persons in BOP custody, as those serving a 470-month or 39-year and 2-month sentence. The RCCA penalty classes also eliminate mandatory minimums for all revised offenses, consistent with the recent MPC sentencing recommendations and longstanding positions of the Judicial Conference of the United States and the American Bar Association. Mandatory minimum sentences are antithetical to principles of individualized sentencing, and due to variance in charging, can result in inconsistencies and disproportionality in penalties. As Attorney General Merrick Garland stated at his confirmation hearing, quote, "We should do as President Biden has suggested, seek the elimination of mandatory minimums so that we once again give authority to district judges and trial judges to make determinations based on all of the sentencing factors that judges normally apply." Lastly, the RCCA general part codifies revised penalty enhancements, including narrower and less severe repeat offender enhancements. While rarely charged and even more rarely affecting judges' sentences, the district currently authorizes repeat offender enhancements that double, triple, or even provide life imprisonment penalties, much like other jurisdictions' so-called 3 strikes statutes. Now, the RCCA changes to particular offenses in the special part of the Title 22A are really numerous. They're diverse in kind and not easy to summarize, but let me just talk about a couple of the updates to simple assault, robbery, and threats, since we discussed those earlier. The most prominent changes are to the organization, grading, and penalties of these statutes. For example, under the RCCA, simple assault is no longer a separate offense. Instead, simple assault is the lowest gradation in a new assault statute that addresses the whole spectrum of bodily injuries that involve some degree of pain or physical harm at the very least. Non-sexual unwanted touching that doesn't cause pain or bodily injury, an issue in a current case, is criminalized as a new offensive physical contact offense rather than an assault, distinguished. In contrast to the current criminal code's complete lack of grading for robbery, in the RCCA, there are 3 grades for robbery, and nonviolent pickpocketing is criminalized as a form of theft instead of robbery. The different degrees of robbery depend primarily on what harm the victim suffered, a threat, a minor bodily injury, or major bodily injury, and whether a dangerous weapon was involved. Regarding overlap in the threat statute that we looked at, in the RCCA, there is just 1 threats offense, which has gradations depending on whether the threat is of death, serious bodily injury, or sexual act or confinement. That's all 1st degree. A lower 2nd degree for whether any bodily injury is threatened, or 3rd degree, a mere threat to property damage. Penalties in the RCCA were updated using these standardized penalty classes. The proposed penalties are based chiefly on current law, the CCRC's review of current court sentencing practices, a survey of district voters' views of the relative seriousness of offenses, and looking at the availability of other charges and penalties in the RCCA that could be brought against a person for a particular incident or event. Once reorganization and grading are accounted for, the RCCA does very little to change the scope of what is criminal under the current assault, robbery, and threat statutes. That is, there are very few clear changes to what is criminalized by these statutes under existing district law. However, as described before, there are many aspects of these offenses that are simply undefined or unsettled in current law. And the RCCA does fill in those missing elements and defenses, and in that sense, changes these laws considerably. Culpable mental state requirements are specified using the new standardized definitions. Consent defenses to bodily injury are codified for the first time, drawing a line at serious bodily injuries, which cannot be consented to except for healthcare reasons. More generally, there are places in the RCCA where new criminal liability is imposed or existing liability is decriminalized. For example, the public nuisance law is expanded to include interference with persons' enjoyment of their home, but to include lights, smells, other means of distraction, not just sound. Conversely, asking persons for money at a public bus, train, or subway station or stop, which is now criminalized as a quote panhandling offense, is decriminalized under the RCCA to the extent that there is no threat or any other bodily injury or criminal behavior. Notably, the RCCA does not propose decriminalization of prostitution or personal possession of controlled substances, although the penalties for these offenses are reduced. Decriminalization of these offenses merits further review, but would require more time for research and consultation with a different set of stakeholders, especially social service providers, than the CCRC was able to manage under its statutory timeframe. The RCCA proposes two other notable changes outside Title 22A that I want to note. First, it would restore and expand the right to a jury trial for persons accused of committing misdemeanors. In 1992, the district restricted the right to a jury trial up to the constitutionally permitted limit in an effort to free more court resources for the spike in crime that was happening then. That restriction, though, continues today, even though the number of court cases is a fraction of those in the 1990s. The district is a national outlier in this policy. Only 9 other jurisdictions have jury trial rights that, like the districts, set jury demandability at the constitutional minimum. The issue isn't just a matter of procedural justice and bringing more community voices into the courtroom, as important as that is. For decades, this is kind of less known, whether an offense is jury demandable or not has had really dramatic effects on how offenses are charged. It incentivizes choices based on whether there's a right to a jury for the person accused, rather than focusing on the nature of the alleged crime and letting that dictate what charge is brought. All right, the other piece that's, again, outside of Title 22A that I think deserves special mention is that the bill provides an expansion of eligibility for the judicial review process in current DC Code 24-403.03. The RCCA would provide a judicial sentence review to any person after they have served at least 15 years of their sentence, regardless of their age at the time of the offense. Identical to the current procedure, the review would consider whether the person presents a danger to the safety of any person or the community, and whether the interests of justice warrant a sentence modification. Such a judicial review process that's accessible to all defendants has been recommended by the recent Model Penal Code sentencing update and a number of other expert recommendations. Now, as I said, there are many other aspects to the RCCA that I just don't have time to describe today. However, as I said, the CCRC and its advisory group developed and with the March 31st recommendations, provided an extensive commentary describing the changes that the revised statutes would make to current district law. This commentary it's publicly available. It's up on our website to anyone who wants to dig in and learn more. In closing, let me just say a few words about what I hope will happen as this bill is considered by the committee and the public in the hours and months ahead. While the vast majority of the bill's changes to the current law are common sense, uncontroversial, and frankly, probably boring to most everyone who hasn't worked on code reform for many years, some of the RCCA changes reflect policy choices where there will be disagreement. And that's as it is and should be. On a matter in which so many institutions and money are involved, nearly $2 billion collectively are spent each year on the district's criminal justice system in different ways. Vested professional interests on all sides are going to have something to say about how power and money are allocated, what's affected. More importantly, on matters in which so many individuals are personally involved, any changes in criminal liability, punishment, or the labels that are used for crimes are going to trigger strong opinions based on those deeply personal experiences. I have no doubt that these many voices and perspectives will be heard, and there may be some significant changes to the bill going forward to adjust. And it's foundational to the whole work of the RCCA that it's this council, right, the district's current elected lawmakers that will establish current criminal laws. Not institutional special interests, not the executive, not the courts, not Congress, not the CCRC. Per our responsibilities by statute, the CCRC is created a comprehensive, deeply researched, evidence-informed blueprint for updating the criminal code. And given the sheer volume of the work that had to be done, there was just no way to do it other than setting up an independent agency and giving it time and resources. But now it's out of our hands. It's up to the council to weigh the bill's language and make necessary amendments and take action. My hope is that going forward, the council and the public keep in mind this legislation's overarching purpose: improving clarity, consistency, completeness, organization, and proportionality. Whatever particular disagreements may arise about a proposed provision or policy choice, I hope those discrete issues don't overshadow the broader points of agreement. And there are very, very many on this bill. And one last point, to facilitate resolving differences of opinion, I'd encourage reviewers of the bill to identify their concerns as precisely as possible. In particular, ask if the concern is about liability, whether conduct should be criminal or not, whether the concern is about labeling, whether the name of a crime is appropriate, or whether the concern is about punishment in the end, whether the penalty for a certain action is right. Last, I'll share some, the common wisdom that keeps coming back to me is, in thinking about all of these issues, is what was said to me by 2 district judges at the start of our work. They said, be careful not to let the perfect be the enemy of the good. Common wisdom, and I suspect what they were trying to tell me is that there simply aren't going to be perfect solutions to some of the issues addressed by the RCCA. There are limits to the precision of language and the ability of the law to set up rules prospectively covering future scenarios. There are aspects of criminal law that are extremely complicated. There are also, though, fundamentally different values and perspectives on criminal justice that often are in tension. For many of the most consequential questions that criminal laws impose, what behavior is so unacceptable as to be deemed criminal? How much punishment is fair? And what will improve public safety? There's often no social science or other evidence that can provide a definitive answer when there are differences arise. But regardless, these difficulties can't stop change from happening. There's so much improvement that can and should be made. While modernizing the criminal code alone is not sufficient to improve public safety or create a fairer and more equitable justice system, it is a necessary piece and a necessary step forward. With that, I thank you again for consideration of this bill, the Revised Criminal Code Act of 2021. Look forward to your questions.
Absolutely. Thanks, Mr. Schmeckel. And I know that there's simply no way that you can take the years and years and years worth of work and adequately be able to put that into that type of presentation, but you did a great job at helping lay it all out. So thank you very much for doing that. I guess I'll tee this up as I kind of move into some questions, and that is, we're having 3 hearings, over the next 2 months. I have no doubt the work related to this is also going to span probably the bulk of next year, 2022 as well. Like, this is going to be, you have put in years and years and years worth of work. Now it's at the council. It will still take, hopefully not years and years, but months and months of work to then be able to put something in front. So we're not going to be able to do everything in one hearing. One of my major goals for today's hearing is to really make sure that we best understand the process that you've undertaken. Essentially make sure we get an overview of our reform package, its major themes, policy recommendations, and importantly, the why behind this project and the why behind the decisions. It is a massive undertaking. And again, we're not going to be able to fully explore everything in one single hearing, but I almost kind of want folks to think about this hearing as a bit of an orientation to all the work that's going to come. I have a hunch that at some point down the road, we'll have people that want to kind of relitigate every decision that got made by the advisory group. And I'm not looking to do that right now. I have no doubt there will be, again, lots of good input from people that think you got it right and you got it wrong. And we'll make sure we hear all those perspectives. But we're trying to make sure we have a solid orientation and a framework by which we then have those discussions that'll continue, they'll come. I'm probably gonna have a few questions that also try to draw out things that you talked about in your opening comments, but just be able to expand on them a little bit. I think we need to make sure we fill out our record our legislative record today. And then also because I know we have a lot of members of the public that are going to be watching, to make sure that we can help best explain in as lay terms as possible the work that's taking place here, so that everyone can have a better understanding of what those major features are. So with that, let me just jump right in. All right, as policymaker, lawmaker, I'm always interested in how other jurisdictions fare on whatever that given issue is. When we legislate, we try to create uniformity among our states and jurisdictions to promote best practices. We try to learn from other jurisdictions, both what has worked and what has not. So you've spoken to this somewhat in your testimony, but I want to dig a little bit deeper. You talked about how we rank and compare, which is not good compared to other states. You've talked about how other states went through comprehensive criminal code revisions in the 70s and 80s. To the extent you can, how have other jurisdictions approached criminal code reform? And then how does our process compare to that process?
Sure. So there are many ways that different states have handled this, right? Again, a lot of these, we're talking about historic efforts. The 60s, 70s, 80s were when virtually all states that adopted the model penal code framework did their work. The political, a lot of other dynamics shifted into the 80s, and the feasibility of large-scale criminal justice reform stopped. So when we're talking about how other jurisdictions have done comprehensive criminal code reforms, we're really talking about this time period, 60s, 70s, 80s. And some of them worked in a legislative process that it was operated, designed, the restructuring came out of years of work headed directly by a legislative committee. In others, there was, again, a kind of a separate commission model, right, that queued up recommendations that were then undertaken by and reviewed and eventually passed by the legislature. So different models in how they went about this process, but in each one, one thing I'd emphasize is, the model penal code, those unfamiliar, it was put together by this body of jurists, a wide spectrum of judges, legal practitioners, many of the most well-respected jurists in the country, formed the ALI, and they went through this multi-year process and reviews and votes to issue it. It is in the end still a model. And there have been some subsequent models put out for particular pieces of legislation, be it sex offenses, be it human trafficking. And some are distributed by advocacy groups. Some have been distributed by other government organizations. And all of those over time have been part of the background for code reform in other jurisdictions, but never, with few exceptions, the more particular some of the bills are, if they're just focusing on a new crime, sometimes one of those models is just grabbed and adopted and stuck into a criminal code without much consideration of how it works with other offenses, how it works with other definitions. That's usually, it's not a good process. The typical way of doing this, and certainly what's been done in all the large scale reforms, is to look at these best practices and models and really try to adapt it and meld it with existing law and practice. Feasibly, to start over with a clean slate, it would be incredibly disruptive, right? Already with something like the RCCA and its scope, there's going to have to be a great deal of retraining on particular pieces. But if the case law, which again will continue to do a lot of work, right? Like discretion is always has to be used, and language is always going to be a little bit fuzzy on the edges. So the case law and the judicial function is always going to be important. Hopefully we can move it from reliance to say what the core elements are to being little questions about interpretation and how to apply a law. But going forward, that's still going to be important. And we're going to want to carry a good bit of that past case law, 100 years of work of litigants and experience and trained lawyers in the district. We're going to want to bring most of that forward. And again, change it as necessary per mandate, but that's the goal for reform. So I just really want to emphasize there's no way to just kind of take and jump forward without huge costs in terms of the ability of the system to function. We instead want to cut out the pieces that have to be cut out, that are clearly outdated or inappropriate. We want to shift the others bit by bit, and we want to change the framework for the criminal code so that in the future, as the council drafts future legislation and criminal laws continue to change, there's a consistent way that future laws are also brought in and fit into this whole system. So, I think that's the experience from other jurisdictions that we kind of looked at and brought forward. More recently, I would add that a number of jurisdictions have tried to do some work around sentencing or particular places, and that is valuable and useful too. But most of those jurisdictions are working from a framework, a criminal code that has at some point in the past 60s, 70s, 80s, had this comprehensive reworking and modernization. For us, the districts never had that, and it makes any changes to the criminal code now really difficult to even get control. As you know, years ago, the district's assault on a police officer statute was changed in some significant ways, including making that offense jury demandable, so that a person accused of assaulting a police officer in some manner could go before the community, right, to have their case heard. That decision by the council was done and affected by changing the assault on police officer law, but it didn't, again, address the core simple assault law, which we talked about earlier. And as a result, what's happened, much of the charging is after the change to make assault on a police officer jury demandable, a lot of those charges appear to have been shifted over, and instead they're being charged as simple assault. Basically the same penalty, 180 days versus 6 months, but without the jury demandability. And I just highlight that because that was the council trying to assert its authority, and in doing so, it was unable to succeed because of the way that the larger code was set up.
Yeah, that's a great point. All right, well, let's start digging in on one aspect here. I want to make sure we tease out a bit more, and that has to do with culpable mental state. So one of the major weaknesses in the district's current criminal code is that it does not specify the requisite culpable mental state for various offenses. All right, for the general public, for our lay viewers, can you describe what a mental state is and why is that important? How widespread of a problem is this throughout the district's current criminal code?
Sure. A culpable mental state refers to the purpose or knowledge with which a person commits a crime or about a certain circumstance. So let me give a couple examples, right? Talked before with respect to the assault statute of somebody who is running down a sidewalk and knocks another person to the ground. And in that case, what really matters is, this question of mental state. Was that act deliberately done? Was the person, as we would say, purposefully, was it their conscious object and desire to knock down the person and injure them? That's a hugely different matter than somebody who is, for instance, running down the sidewalk and accidentally knocks somebody to the side and injures them because they're running to say, reach their child at the end of the street who's calling for help, or some other justifiable situation. they may have been, in that case, what we'd say reckless in their action. They were aware of a risk that somebody would get hurt if I go barreling down this sidewalk at this time of day. They were aware of it. They disregarded it. They did the action anyway. How does that affect whether they should be held liable or not for a crime? So that's the kind of situation where this comes into play. And the RCCA follows and adopts the Model Penal Code core definitions. It's a 4 different mental states. The highest mental state, and it's kind of helpful to think about these in terms of levels, is purposefulness. If the person seeks a certain end, their desire is to achieve a certain goal, to hurt somebody, to steal something, to take an object, that purposeful mental state is going to satisfy whatever then the description for the rest of the crime is about what they did. So we have a mental state, and it applies to an action. Purposefully taking an object, purposefully harming a person. Purposefully is the top mental state. Below that, the MPC, the Model Penal Code, and our definitions have a knowledge mental state. In that case, a person, for example, knows that what they're doing is taking an object from somebody else or hurting somebody, but that isn't what they were trying to do. They didn't want that. They weren't seeking that, right? So the second level, the second culpable mental state of knowledge, you think about it in a lower level, one step down, a knowledge from purposefulness. And that is where many criminal offenses have their elements set, both in the Model Penal Code, other jurisdictions, and in the RCCA. And the reason is it's often hard to distinguish purpose from knowledge for fact finders. But more importantly, if a person knows, and by that we don't mean absolutely certain, we mean practically certain, we codified that, that a certain result is going to happen, well, that's generally considered kind of the baseline. That's enough for criminal liability. Supreme Court has decisions that have basically said as much as well. So knowledge is where the requirement, the mental state requirement for most offenses. Below that, yeah.
Sorry, just in the interest of time, I would try to ask a couple of questions here.
Sure.
So the way that I'm hearing you describe that, I think I'm trying to help translate this to kind of the general public here, is that mental states are in some degree being able to distinguish between those mental states, and the way in which the RCCA tries to lay out those 4 different levels to some degree is actually about fairness or blameworthiness. It's trying to help understand the how and why that then helps determine what comes after that. Is that, if I'm trying to really break that down to kind of a translatable piece, is that fair, or is that misplaced?
Blameworthiness, yes, absolutely. Blameworthiness is a really good way to think about it. Again,
it's a horrible word, but yeah,
culpable mental states. Again, it's what is making this person responsible, and it's tough because look, again, all crimes have both components. There's a bad result, right? There's a bad behavior, and then we also care though about what was going on in the person's head. Because terrible things, right? Accidents happen. People can do terrible things for innocently, right? And they should not be held liable. So, and at the other end of the spectrum, the very worst, way is a very kind of purposeful, deliberate crime, and we want to hold those most accountable. So we have this spectrum of which it really affects our sense of the blameworthiness of an action. And we want that to be reflected in the criminal law.
Right. Because we're talking about like that degree of liability. It's not, this doesn't say that the harm didn't happen.
Right.
So this is trying to lay out that, yes, harm happened. It's really trying to then figure out what took place that then created the harm, to then measure out what is that level of liability for the harm that did occur. Not that someone can just say, oops, sorry. There is still accountability and the liability that goes with the harm that was done. It's about trying to understand the degree of that liability. Is that fair?
Absolutely. And again, we have a civil system, right, that has addresses a lot of these harms. We call them torts in law, but harms to another person that are inflicted, right? And they have a different, usually lower standards, right? For the criminal law, though, we really want to make sure that it wasn't just, yeah, you harmed somebody, you damaged their car, you did, but that, what was going on in terms of your mental state, what your attitude was towards this, and is that adequate to hold you blameworthy? And definitely moral intuitions come into play with this. And again, so what we've adopted for this framework is really almost identical to what majority of states across the country have.
And that was you're anticipating my next question, which is, all right, when we think about that framework, how does that line up with our jurisdictions? And you're saying that lines up fairly well with a lot of other jurisdictions.
Absolutely. And look, again, it's not without complications, and there will be, this is an issue, but again, it should be an issue because these distinctions in a person's mental state are real distinctions in blameworthiness. It makes a huge difference. Was somebody, again, doing some reckless behavior? They knew there was a chance that, driving in a certain way could hit somebody. Or were they purposely trying to hit somebody? Or was it a totally reasonable mistake that something else happened and they shouldn't be held liable at all? Those distinctions are really critical. So we try to give some specific language to focus on those decisions.
So under our current code, how frequently do we just have kind of a strict liability that's used? In other words, we don't have a culpable mental state assigned to it at all. It's just strict liability. It happened.
Hard question. So I'd say this, we have hundreds of offenses, right, in the DC code. Ballpark, I would guess maybe about half have just no culpable mental state specified in the statute. But of that group, and again, more than half, less than half, there's often going to be case law which requires, there's been a case and a decision which has said, even though the statute doesn't say something, like the robbery statute, even though the robbery statute doesn't say anything, we're going to hold an intent to steal as an element that must be proven. So there's a bunch of case law, case decisions that say what even though the statute says nothing. And then the problem though is there's still many other instances which have never gone through the whole appellate process and resulted in an opinion. So we just don't know, right? The statute itself has nothing about a mental state. Courts haven't addressed the issue yet. So what's the state of the law? Unknown. And again, we have Supreme Court precedent and practice in the courts to, in most offenses, except for kind of low-level regulatory offenses, to require at least some culpable mental state. So courts will typically read in some kind of mental state, even when there's none specified in the statute. So that's a common thing. And so again, we've got around a half, maybe more, maybe less, that have nothing in the statute. And then most all the rest are kind of like, like the district's burglary statute, for instance. Okay, so the district's burglary statute said first-degree burglary. Basic elements are a person entered a dwelling, the dwelling was occupied, and they did so with intent to commit a crime inside. So great, you've got this, there's one mental state there, right? There was an intent to commit a crime inside. But what about the fact that it was a dwelling? Did you have to know that? Did you have to know somebody was sleeping in that office, which counts as a sleeping room? Did you have to know it was occupied when you entered? We don't know, right? The culpable mental states aren't spelled out there. So in a statute like that, and this is a good chunk of the code, I guess probably a little less than half. Like you've got one mental state that's there, but again, it leaves all these other questions unresolved. Some cases the court has been able to go in and say what it is, but there's still a lot we just don't know. And again, these things have to get sorted out, right? If somebody does something that gets charged as a crime, it goes through the process and it gets litigated, and a lot doesn't go up on appeal. Eventually some does, some gets decided and there's a published opinion. Others we just never hear about. We don't know what in the future is going to arise. So the goal with all of our work, and again, this basic framework used in all of these jurisdictions in that model penal code, is to specify for each offense, not just one mental state, but any element of the offense, saying what is required in terms of mental state. Did you have to know the place was unoccupied or not? Did you have to know it was a dwelling room that you were entering versus a storage room? And then also, did you have to have the intent to commit a crime in? So we want to spell out all of that, just be complete and specific and give that direction to fact finders, the juries, and judges.
So the RCCA continue to use strict liability for certain elements? And from a policy rationale perspective, then why?
Sure. So where we use strict liability in the RCCA, and again, strict liability is just the absence of any of those culpable mental states. So we have language, we say in fact, and then we have the language, and we say in fact means that the following element doesn't have a culpable mental state. So we're very clear when things are strict liability versus it's just silent. We try to be specific and specifically designate what is strict liability. And we do that typically where there is a clear harm with a mental state in another part of that offense. So give you an example, theft, right? We require a mental state that a person knowingly takes property of another, right? So again, you know what you're doing, you know that this is property of another, you're not mistaken, you're not thinking it's yours, right? You know this is somebody else's, and you took it and you had an intent to deprive that person, permanently. We have another crime that deals with like temporarily taking something you weren't supposed to, but for theft, it's I'm going to deprive that person of the use of it. I know it's theirs and I take it. But here's the thing. We also in theft have different gradations that provide higher penalties when the thing that's taken is of a high dollar value. And if it's, a pack of gum, it's something small, then it's a much lower penalty. That's to reflect the difference in harm. But the value of the object, we propose to be a matter of strict liability. In part, that's pragmatic. Again, these distinctions, it's going to have to be proven at trial. Let's just be clear, right? Like, even though something, again, is strict liability, it still has to be proven. Well, what was the value of the thing taken? And that's going to change the penalty that a person's subject to. But once, and this is again a common thing we've seen in other jurisdictions, is that when there's a crime and the way it's written is it has elements that clearly establish the wrongdoing, and those have mental states. And then there's some other additional elements that do some additional work here, distinguishing kind of the level of harm. Then having strict liability as to those elements, the level of harm is often used, not always. And again, there's no, unfortunately, formula for this. There's no strict rules that are applied in any jurisdiction or in the Supreme Court jurisprudence. We've tried to follow models and tried to follow district practice and laws so far. That's where we've made those judgments. So that's how strict liability continues to enter in a few places for some elements of an offense, but not across the board for any offense.
Let me move on to another topic. In your testimony, you alluded to the problem of overlapping offenses within the code. Again, keep in mind our audience here from a general public standpoint. What do you mean when you say overlap? So we make sure that's very clear to folks. And then why is that a problem under our current system? And I have some example of questions I want to go through.
All right, I'll do my best. So overlap, different ways we can talk about it, but the core of it is this. Each crime uses some abstract words, right, to describe a category of behavior. And we have another crime over here that does the same thing, uses some words to describe a certain category of behavior, but commonly in actual real world life, the behavior that's described is one and the same. Now, threats, as we kind of raised before, is kind of the clearest, where the way those two statutes, just the words they use to describe behavior is virtually identical. We're talking about the same real world behavior. That is almost complete overlap between those two different threats statutes. A little bit different is, the difference between robbery and assault, right? Okay, so some robberies may not include an assault, at least the way it's written right now in the DC code. It can be just suddenly and stealthily grabbing something and running off. The other person needn't even see, as long as it was their back might have been turned. So you can have a robbery without an assault, but in practical terms, in real world experience, again, these two very frequently overlap. So that's what we're talking about in terms of overlap. It's a matter of degree. Some offenses have, again, almost complete overlap in terms of the real world conduct they are directed at. Others significant, others hardly at all. So it's a matter of degree. And again, there are various problems that arise from overlap, many of which we can address in code reform, some we can't. Again, the whole project of the law, trying to use these words to describe behavior in an abstract way and foresee all these situations, there's only so much it can do. And so we're gonna, and we can't screw it up, right? Like we have to make sure that all the conduct gets captured. So we come at it from different angles, right? How are the many different ways an interaction can occur? And it may take 2-3 statutes to make sure that we've captured that bad act and it is criminalized. But we want to reduce the amount of overlap between these different offenses to the extent possible. And then we also, at the back end, really want to make sure that even where there is overlapping offenses, that the penalty in the end doesn't get magnified. Because one real problem with overlap is when you get charged with multiple crimes for the same one act, it can have the unintended effect of making the penalties that person's liable for huge. Let me give an example. Right now under the district's burglary statute has 2 degrees. I mentioned first degree before, but second degree is just entering any building, any location with intent to commit a crime. Shoplifting, and it's a 15-year offense. We also have shoplifting, right? It's a very short 90-day offense. It's what you would think for shoplifting, right? A person who goes into a drugstore with intent to shoplift can be charged with both second-degree burglary, a 15-year offense, and that minor misdemeanor for shoplifting, because they overlap. Okay, now that's huge, right? And a huge difference, a huge disparity. When the council created and set the penalty for shoplifting, they certainly thought it deserved a low-level punishment, right? But the fact is that same conduct counts. It is captured by a second-degree burglary charge. And for various reasons, a prosecutor or an officer might choose to arrest, and a prosecutor might charge both of those, right? And think about, again, the pressures that creates on the system are huge, right? Prosecutors want to get it right. They want to make sure that the right people are held accountable. But their job is to be an advocate. And they're going to bring forward tough charges. And it may be that, again, for a shoplifting incident, they charge both. And on the other side of the table is a person who's now looking at a 15-year maximum charge. That creates a lot of pressure, right? To maybe take a plea to the lower charge, to shoplifting. And so it creates all sorts of different incentives in the system when these overlapping offenses have really different penalties or can be stacked. So you have multiple charges for, again, what was one real world event. The law has kind of artificially magnified, multiplied.
Yeah. So, Director, let me do this. Let me apologize in advance because we have our public panel starting around 11:30. I still have several questions I want to make sure we are able to kind of flesh out on the record. But I'm going to try to move a little more quickly if I can. A couple of questions that I need to kind of work my way through with you. But as you know, this is so significant. It's really helpful to lay out the background the way you are. All right. So just one more question on overlap. Can you just help explain real fast, how does the RCCA address that overlap? I think you did a great job of explaining, so I think people can understand and wrap their heads around what that overlap and stacking is. So in what ways does the RCCA address that?
You bet. So the primary one is in thinking about the elements of the offenses. We want to write them in ways so that the conduct that is captured by each offense, it's as narrow as possible, but in order to still get at the underlying behavior we want to get at. We want to think holistically about the code as providing a whole toolkit, again, for charges that can be brought to stop bad conduct. And so it may be that under the RCCA, you know what, for shoplifting, you can only charge shoplifting, or maybe that and also a theft charge, depending on the value. But you wouldn't be able to bring other charges. The elements of another charge just wouldn't fit. Another way we do it is not changing the elements, but the penalties, and trying to think holistically again that, look, you can bring many charges. We've got some overlapping charges to fit these common scenarios that occur in the real world. But at the back end, the penalties that person faces are proportionate to that underlying harm. And we do that in some cases by lowering penalties and saying, hey, you could be convicted of 3 different crimes for that incident. Each carries penalties, and you know what? Judges can always choose, and under the RCCA and current law, they can choose to run those sentences for each conviction consecutive. So it really lengthens the amount of time. So we want to take that into account and say, again, is what's authorized under the code throughout all the statutes fit the real world conduct?
And does
so
that,
yeah.
Well, so, we've talked about the issues around overlap, the issues around proportionality. So is that an example, the way you think the RCCA is trying to look at, we have disproportionate penalties. And so from an overlapping perspective, the RCCA is trying to lay out the ways in which you're having a more proportionate penalty system. That's kind of what you're outlining, the way in which the RCCA is recommending that structural piece. Is that right?
That's right. Again, we at the level of each offense, the elements, at the level of looking at what are the different offenses that can all be brought to bear on bad conduct, and at the level of penalties for any applicable offenses, do they combine in a way such that they're adequate, but they're not, stacking one on top of the other to such a high number that's just crazy. And if I can just, I know we're short on time, but I really want to interject. This summer there was a court decision on kidnapping that was really it's something to read. The district's kidnapping statute brings in a 30-year penalty. It's huge, right? And again, as we've seen in other places, there are no gradations. There's one kidnapping statute, and it covers everything from the most serious kinds of things you'd think. Taking somebody, moving them to a far other location, hurting them, threatening them, terrible things, to what this case was about, which was, well, where's the bottom end of that? And what the court said was, look, this was an incident, early morning, a patrol officer spotted a woman who walking on the sidewalk, a man came up behind her, bear hugged her momentarily, a second or two, let go. He touched her breast. He was arrested for a sexual assault charge, right? But also for kidnapping. And this case occurred, and the court really just in a kind of a really upsetting way said, we are constrained by the statute and our past precedents to say any kind of momentary seizure of a person, again, a second or two, even when there's another charge that accounts for the main harm going on here, right? Which was an unwanted sexual contact. No, that counts as a kidnapping under our statute and case law. And so that 30-year penalty, yeah, that's fair. That comes into play, the maximum penalty. And that's the state of the, when you think about it, and as one of the judges said, look, that transforms every time somebody, grabs another person's arm to stop them, to stop them from running out into the street, even something that's socially beneficial, right? That is, under the law, a kidnapping carrying a 30-year charge. That kind of overlap with all these other things which we've accounted for. Again, we have assault statutes, we have sex assault statutes. Those should be doing the real work here. But because of the overlap, it's just this really egregious, jump in penalties and creates all sorts of problems. And again, this was a recent case. Like, it's not like these things aren't being charged. They are being charged, and in the recent past. But
using that example, concern. I think it's a really helpful example to think through. There's still a charging decision, though, about whether or not kidnapping in that instance should be charged. And that gets back to your point as well, or correct me if I'm wrong, around one of the unintended consequences within the code, that from a charging decision perspective around what sounds like that was charged with a sexual assault, kidnapping, other things, that then creates this stacking and overlapping effect that is either going to drive towards a plea on something else, or just that huge stacking for the one single incident.
Absolutely. And look, again, prosecutors are amazing public servants. They're doing their best, right, as they see it, but they're doing it individually, right? Maybe as an office, they have some norms for choosing. Is this a felony assault, a felony threats case, or a misdemeanor threats case? Do I go with the 20-year or the 6-month option? They're doing their best, but they have such huge discretion and such huge range that it's putting them in a crazy situation. And look, I again, each prosecutor can be doing an amazing job, but for the system overall, what's going to happen is there are going to be differences, right? One person with, at one point in time with one prosecutor is going to get charged with a felony, and that same conduct, slightly different prosecutor, slightly different time, is going to get charged with a misdemeanor. Hugely different implications, for the pressures to plea or not to plea, the actual sentence that might result. It just creates, it's a recipe, it's a systemic design problem, right? That creates a recipe for bad outcomes, despite the individual best efforts of all the people, in the system to try to do right in each case.
Yeah. Okay. I appreciate you walking through that. Absolutely. All right, let me jump to this. I think one of the goals of legislation, and sometimes we're better at it than not, should be that it's lay friendly. We kind of talk, like, these are such complex legal topics. It is hard to translate that sometimes to the general public in a lay term, but I think it's important because I think that clarity, or the lack of clarity, also has an impact on public safety. So here's an example. Here's what I mean. How can someone know the penalty for a crime, and assuming the person is, let's assume they're a rational actor, which is an entirely different conversation, but for argument's sake, and then change their behavior accordingly? Like, we hear that all the time. So if the law doesn't even say if the law doesn't say what conduct is it prohibits, how can that rational actor be able to make decisions based off of that if we assume that's part of what's taking place, or what that penalty could be? If one of the driving assumptions is that individuals will change behavior based on the clarity of knowing what the consequences would be for the acts, if we don't really define what the act is or what the penalty is, how can we then as policymakers have a reasonable expectation that that behavior could be changed? Again, we're pretending for a moment that everyone's going to be a rational actor in these cases. So how does the notice function of a criminal code link up with that intended deterrent effect? And it's a big question, but kind of see if you can kind of delve into that for a little bit.
Yeah, I mean, I think it's absolutely right that, you know, putting aside you know, the extent to which most criminal behavior takes into consideration penalties or the law, there's a lot of evidence that in most crimes, this is not the case, right? There are some sophisticated actors who are going to understand differences in the law, differences in penalty, they're going to change their behavior. An awful lot of some of the worst crimes, particularly homicide, right, are not driven by that, right? They're not thoughtful in that way. And research really shows that if you want to stop crime, you want to deter crime, it's not about penalties, right? It's not about people knowing that their behavior is going to have a certain penalty. It's just not. And that's why mandatory minimums don't have, you know, much effect on people's behavior. What matters more, far, far more, the research says, is whether that person thinks they're going to get caught. It's an enforcement problem, right? It's a policing problem. That is the dominant force. But okay, there are some folks who are looking at the law, are looking at penalties, trying to think things through. And let's say they're sophisticated, right? Being clear might help deter them more. It might not. It just depends on the facts, right? Is it going to turn out that, you know, is it better to just throw a huge number out there? But then again, they also know that that huge number on the books isn't actually used in practice in the courts. Those sophisticated actors tend to be the ones who kind of know what the norms are for this in sentencing. So maybe it doesn't do much, but don't talk about maybe the sophisticated criminal actor. Think about a protester, right? Think about somebody who is trying to exercise their First Amendment rights for free speech. There's an awful lot in the criminal code that goes to that. What constitutes a threat very much overlaps with free speech concerns, right? What constitutes obstruction of a public place? Something that's criminal? Well, is that part of a First Amendment action? Rioting. All of these types of offenses, there's a line that has to be drawn very carefully. There's criminal conduct, right? That is harmful, that is dangerous to other people, that needs to be criminalized and punished. There's, on the other side of that line, constitutionally protected conduct that we want to be extremely careful and respectful of, to not just criminalize, not just not make it criminal, but it's beneficial conduct. We got to really be clear about the line for those folks, right? So when we've got, as we do now, an obscenity statute that, for instance, uses all sorts of like incredibly vague and outdated language, wow, what does that do? It chills the behavior, right? For those folks who want to abide by the law, but cannot understand it, right? They look at the statute and it appears to encompass what they're doing. Same thing for the disorderly conduct statute. It's better than it used to be, but there's a lot of ambiguity there. For those folks kind of who are on the edge and want to follow the law, the ability of the code to clearly say what it is and fulfill that notice function is really critical, right? Those are the folks that you want to, we have, you know, this is a basic function of the law, right? To draw that line and to not overstep it. Because if we do overstep it, and if the laws are ambiguously written and people are arrested wrongly and arrested, and it goes to the courts, what happens? A lot of litigation, damages, right? Convictions overturned, just a tremendous churn and waste of time and resources that a more clearly written upfront crime in terms of the elements and the mental states could have really avoided. And mental states are really critical there, right? Like on a threat, the difference between a song that and singing that or saying that, a message sent to somebody that is in jest versus a serious, purposeful attempt to intimidate somebody, that fine line between free speech and a serious crime is incredibly important. And in many instances, it goes to mental state. So what we've done, again, is trying to be specific about these things really helps draw that line accurately between criminal and non-criminal behavior. And, what effect that has on deterrence, I don't know. But again, the evidence on deterrence is really, it's not about the law. In the vast majority of cases, it's about enforcement. And that's where advances have to be made there.
Okay. Let me do this. We have about 10 minutes left. So I'm trying to get a couple of kind of questions right here at the end. You've discussed throughout how in your opening about how the CCRC recommendations addressed an overwhelming majority of the offenses that are actually charged in DC Superior Court. Are there any notable offenses or categories of a crime that aren't addressed in the bill that's in front of us?
Yes, absolutely. The RCCA, as I said, it creates in chief a new Title 22A that replaces the current Title 22, which is where most of the current district offenses are. We don't do all of that. There are some that we didn't get to in the 4.5-year span to March 31st. We're continuing to work on those. We have some up now, and they're up for comment on our website as well. Some offenses that include terrorism charges, obstruction of justice charges. Those are ones which, again, we've in just the last months drafted some new possible language, put it up for comment. We've reached out to our advisory group members from before to solicit their input. We'll do another draft, and hopefully down the road we'll supplement the bill and submit to you and the council for consideration some of these additional pieces that weren't there. But I want to be clear that there's not much, right? There's, again, what isn't in the bill that is actually sometimes in use. It's terrorism, very rare, but obviously incredibly important should it be charged. Obstruction of justice, much more common, and a serious felony. We're underway there. A couple other things that are left in the criminal code that we haven't addressed, but will plan to soon. Gambling offenses, not too common, tend to be misdemeanors. Animal cruelty statutes, there's a number of them, some misdemeanors, some felonies. And then probably the biggest cluster of offenses that we have not addressed so far or in the RCCA is motor vehicle offenses. These are things like leaving after a collision or driving without a license. So they are mostly misdemeanors. What's still out there? Some of them are more common. Some of those motor vehicle offenses are fairly common. And I think we're going to have some significant recommendations as to those offenses, but they aren't there yet. They aren't in the RCCA now. What the framework in the RCCA does will be usable for the updates to these later offenses, right? Again, those common definitions are a huge critical tool so that future legislation, future revisions can all plug in a uniform way to the new code and the new system. That's kind of it for criminal offenses. There are many criminal statutes that deal with other aspects of the system. There's juvenile justice provisions in Title 16, for instance. There's procedural, how does bail work, et cetera. Some of the sentencing provisions. Many of those are quite outdated as well. And then there are also these offenses that are on the books that haven't been charged in decades. many of these are minor misdemeanors. They're regulatory, running a business of a certain kind without a license. And they're on the books, and we've found a bunch of them, but they're scattered across the hundreds and hundreds and thousands of pages of the DC code, all the text, they're scattered throughout. Perhaps, we'll get to them, but we've been triaging, right? We've been trying to focus on the most serious common offenses and trying to do right by restructuring those. What's in the RCCA accounts for about 97, 98%, depending what years you're looking at, of what's the offenses that are actually being charged in the courts. And we're a good way to like closing the gap on those last, couple percent, right? Got some out now, we're getting more out this year. So that's the process. Again, I know this committee, right, in particular, these years are a tremendous upsurge of interest and concern about the criminal justice system in a fundamental way, right? Fundamental issues. And so I know you are dealing with so much, and the community is so focused on these concerns, and that's tremendous. So, we're trying to not delay further some of these key reforms. Some could happen very quickly, right? Some are gonna, of what's in the package is gonna require some real retraining. And I would, we recommend that the RCCA have a little bit of a delay in its implementation in order that retraining can occur.
Yeah.
But some.
Well, that gets I would say that actually gets my last question. And it's probably talk with almost all of our panels with today. And that is how we prepare an entire criminal justice system, complete overhaul of the criminal law. So assuming the council passes this sometime in 2022, any recommendations you have about how do we help educate the legal community about those changes, the practical changes that will happen post passage? I think you obviously just laid out being thoughtful around trying to think what is the staging from a timing perspective layout, but just any kind of final thoughts you have on that, and then we'll start to transition just a little bit.
Sure. A few things. First and foremost is what you're doing now, right? Get this out there, have some public hearings, get public input, get government, witnesses, do all that you're doing now, right? To start this conversation in a broader way. We have for years been doing this in a very open, transparent way, but obviously it was very much in the weeds, right? People who care about this stuff a lot and advocates who care about this stuff a lot also didn't tune in because we were so in the weeds for a lot of their concerns that they said, we're going to stand back, we'll see where this ends up. Well, now we're there. So now's the time. The sooner that input can come in and you can begin to identify where there are places. And again, I would really emphasize that in these coming months, I really think conceptually, it's important to ask for all the comments that come in. Is this about a name of an offense? It usually isn't. In the end, the names, they matter somewhat, but it's not usually that. Is it about what's criminal? That dividing line between is it criminal or non-criminal? And there are some real differences out there, as on a number of issues, right? And I think there'll be more input on that. Whether what the bill has is drawn the line correctly. And then the big one is the last one, punishment. Look, it's criminal. It's on that side of the criminal line. Then what should be the punishment? And I think that's where, from what we've seen, there is just a wide range of beliefs. And so I think going forward, that's going to be in some ways the biggest task for the committee and the council is to weigh this. And I could go more into kind of the process that we used in doing the penalties and putting forward our recommendations, but I want to emphasize one thing in particular. So, these weren't just drawn out of the air, the penalty recommendations that are in there. It was based on looking at current court statistics. So what is actually going on in the courts versus some of these penalties on the books, they're outdated. They were set at a time when it didn't think about different offenses that can all apply to the same conduct. It wanted just one label, something like, burglary, to take care of the worst kind of burglary and anything else that happened in it. Well, that one label, that one offense with one really high number, that's one way to approach, but we're doing it differently, right? We're trying to say, let's look at the code holistically, make sure we can get an appropriate penalty. So we looked at all the other offenses in the code that could apply. We looked at court data. We also did empirical research. Instead of just looking at the courts, which there's a bit of a feedback loop here, right? People know and will identify what's most serious based on how they've been seeing it before, what cases do, and the cycle kind of continues. But we try to reach out directly to district voters. We did a survey, 400 demographically representative district voters, and we gave them different scenarios, common crime scenarios, and we said, look, rate these. Tell us which is more severe than the other. Compare it to some kind of very intuitive, a backbone of harms, a bodily injury, an injury that requires hospitalization, an intentional killing. Compare these different scenarios and tell us, rank it compared to some of these like core things, physical injuries. And we got back the results, and they're very different. They put a very different order of severity for offenses than we see either, certainly in currently in the books in the DC code, but even compared to what the courts are putting out. And I think the difference, it says a lot. It helped. We've got this research up on our website. It was particularly striking for some offenses like burglary, that people, they are much more concerned about the results that occur. Same thing for weapon offenses, right? Which everybody's incredibly concerned about. What we found is that, the district residents that were surveyed said, what matters in part, was there a gun there at all? But beyond that, there's a difference between possessing a gun when a crime occurs, brandishing it or showing and threatening at it, and using it. That may seem common sense, but the code currently does not distinguish those things, right? So it throws the big penalties at even the lower level stuff. And what we found was like, no, people are much more nuanced and smart and in how they differentiate these scenarios. And so we use that when we put our penalty recommendations out there, so that they can track more these ordinary differences in a sense of, what's more blameworthy, what's more serious.
Okay. Well, Director Schmeckel, first off, I know we could spend hours and hours today just alone with you and your expertise and the work that you've done over the many, many years here. The good news is I know that we can turn to you whenever we need to and continue this conversation, help round out and be able to pose lots of questions to you. Let me just make sure that as we kind of wrap this up and before we move to our public panels, I just thank you personally for the hard work that you have put into this, to your entire team, which has worked for years in a really thoughtful, collaborative way to really try to get at putting forward something that's going to make a difference. To every member of that advisory group that really pulled and pushed on each other and really worked hard to kind of craft this set of recommendations. And as you have said, represents, a range of perspectives, but really worked hard pushing and pulling each other to get to this. So I really appreciate the hard work that's gone into it. And I know it's not done yet, but really appreciate everything that has gone into this. I definitely have some additional questions, and so we'll follow up with you after this. But again, this has been really helpful to have us benefit from your expertise in laying out the recommendations. And again, as I talked about our first conversation, really about orienting us around the how and the why. Again, I have no doubt there are going to be plenty of conversations about exactly why that word was picked or that number was picked along the way. But I think it's important for us to have a solid foundation of why we're going through this process and the orientation that guided it. So for that, I really appreciate the hard work. We're going to transition to our public witnesses. What I'm going to do is this. We're just going to take a very brief, maybe about a 5-minute or so break. For those of you that are watching on our Facebook page, here's one of the quirks of Facebook. It times out after a certain amount of time. So what we're going to do so that we can have the totality of the hearing on Facebook for those that are watching during via that, you're going to see this simulcast on Facebook essentially end. We will then restart it for the public witnesses. So for you on your end, all you got to do is just refresh your Facebook page and the new video will come up when we start that panel in about 5 minutes. To our public witnesses that are about to start, give us about 5 minutes. We'll take just a brief recess to take a quick break, reset for our public panels to begin, and we'll start in 5 minutes or so, and we'll do that. So again, to Director Schmeckel, thank you so much. And we will have a quick recess here. The time is now 11:30, and so we'll reconvene in just about 5 minutes. Thanks. All right, good morning, everyone. My name is Charles Allen, the Ward 6 Council member and chair of the Council's Committee on Judiciary and Public Safety. We are reconvening our hearing today on November 4th. The time is now 11:42. So we took a brief recess between Director Schmeckel's testimony and our public panels. But let's just jump right on in. I'm going to read out, we have most of our first panel assembled here. I'm going to read out everyone's name to get us started. And again, thanks everyone for taking some time to be here to testify and share your thoughts here. Our first panel of public witnesses is Michael Cahill, President, and Joseph Cree, Dean of Brooklyn Law School, Jonathan Smith, Executive Director of the Washington Lawyers Committee for Civil Rights and Urban Affairs, Cecilia Klingel, Assistant Professor at the University of Wisconsin Law School, Jake Horowitz, Director of the Public Safety Performance Project, the Pew Charitable Trusts, DeRay McKesson, Co-founder of Campaign Zero, Kevin Ring, President of Families Against Mandatory Minimums, Roger Fairfax Jr., Dean of the Washington College of Law at American University, Premal Daria, Executive Director of the Institute to End Mass Incarceration, Harvard Law School, and Tyrone Walker, Director of Reentry Services, the Prisons and Justice Initiative at Georgetown University. Again, good morning to all of you. Let me turn to you, Michael Cahill, as our first witness, and thank you so much for joining us.
Good morning, and thank you. I'd like to thank the council for having me here and for its attention to these important issues that we're discussing today. And of course, I'd also like to thank and congratulate the Reform Commission for its very thorough and impressive work. I'm sure a number of other people here today can and will speak to the substantive policy decisions reflected in various parts of this code. I'm going to more broadly address its overall framework and why its form and structure represent a massive improvement and why I think that matters, why it's important. I've been thinking about how to write criminal codes for my entire career. My first article started when I was a law student, published back in 2000, developed a model for evaluating the quality of criminal codes, and then reviewed and ranked all of the American criminal codes in light of that model. And as Richard Schmeckel noted in his remarks earlier, my co-authors and I at that time recognized more or less the same priorities and principles that this council adopted in its charge to the Reform Commission. First, a criminal code should be clear. It should articulate rules so that someone can understand them. This is particularly important in the context of criminal law compared to other kinds of regulation, because these are rules that apply to everyone and are supposed to set out basic rules of conduct that are so serious that violating them will lead to punishment. So they should give notice to the average citizens who need to follow them, as well as being easily understood by the average citizens in the form of jurors who may be called upon to apply them. Second, a code should be comprehensive. It should set out all of the rules that govern criminal liability, including not only the conduct that is prohibited, but the required culpable mental states, the rules that support liability for adjacent categories of acts like criminal attempts, and categories of actors like accomplices and co-conspirators. And it should set out the rules specifying what will and what won't support a defense against criminal liability. Unless it's doing all of these things, it is not making clear what the criminal law does and doesn't cover. And there may be gaps, there may be shortfalls, or there just may be vast areas of ambiguity. Third, a code needs to be consistent and avoid contradiction or confusion. Comprehensiveness means you say everything that needs saying. Consistency means in part that you say it only once. So you don't have rules that overlap or conflict or are duplicative, especially if they might lead to inappropriate multiplication of liability, as I know Richard was discussing earlier. Finally, the code should be precise. So consistency means that similar things are going to be treated the same, but you also need enough distinctions to ensure that meaningfully different cases are treated differently, and to specify to the various people who implement the law how they should apply it. If your scheme is too crude, each offense is going to have such a wide range of possible penalties or sentences that even if the code itself avoids inconsistency in its provisions, it will invite inconsistent results when it comes time to determine particular punishments in individual cases. These criteria collectively embody a central fundamental value known as the legality principle, which is the idea that criminal law needs to be set out in advance and by the legislature to promote democracy, transparency, and fair and uniform application. But unfortunately, I must say, this principle was not taken especially seriously at the time of enactment of the original American criminal codes of the late 19th and early 20th centuries, including the current DC Code. Those codes aren't even really codes at all in the sense of being coherent or self-contained sets of rules. They're really just lists of individual crimes that don't even define the exact scope or meaning of those crimes, because they're relying on pre-existing judicial, or what we call common law, understandings of crime that were not themselves and weren't really trying to be systematic or comprehensive or transparent or proportional or any of the things that we now rightly demand from our criminal law. About 3/4 of American jurisdictions meaningfully modernized their codes in the mid-20th century, along with the wave of reform that attended the creation of the ALI's model penal code. Those that didn't are increasingly out of step with contemporary norms, and I should say as an educator, they're increasingly out of step with what emerging lawyers learn about and are comfortable with in their legal training. This proposed code fixes that. And it's no exaggeration to say that the proposal on the table would bring the District of Columbia's criminal law from the 19th century into the 21st century. Again, I'm not here to focus on particular choices about what should be a crime or how serious a crime it should be. But whatever one thinks should be the proper scope or substance or degree of criminal liability, the stakes of criminal law as a whole are simply too high in terms of both individual freedom and our collective security for the law to be trafficking in ambiguity or inconsistency or uncertainty. This proposed code, in a very meaningful sense, would make the District of Columbia's criminal law more lawful, which is to say, it would be something defined and bound by clear and consistent rules, rather than being the creature of a series of individual, ad hoc, and only modestly constrained discretionary decisions by lawyers and judges in individual cases. Importantly, this kind of improvement and this kind of coherent structure is possible only with a complete and fundamental rewrite, demanding exactly the kind of sustained and thorough attention and effort that this project has received. So this is a rare opportunity that should not be allowed to pass by. And once a transparent and complete code like the one proposed is in place, when changes are needed in the future, as they surely will be, it will be easier to make them because it will be easier to identify and modify the particular rule or language that needs changing. I applaud the Commission's work. I urge the Council to adopt it, and I thank you for your time.
Thank you very much, sir. I'm going to come back with a couple of questions in a little bit. Next, let me turn to Jonathan Smith. Good morning.
Good morning. Good morning, Councilmember Allen, Councilmember Chase, members of staff. Thank you very much for inviting me to testify this morning. The work of the Criminal Code Reform Commission is a major step to modernize the district's laws. If adopted, the recommendations will rationalize the code, eliminate antiquated crimes, clarify and make consistent essential elements of intent and mental status, and integrate the code into a coherent whole, as opposed to a patchwork of laws written to meet specific needs at specific times. The proposed revisions will provide the council with the opportunity to ensure that the penalties imposed for conviction of a crime are both proportionate to the severity of the offense and between offenses. The district has undertaken other efforts to rationalize and modernize the criminal code. Each of these has been incomplete. Many of the more recent changes have made a positive impact and helped reduce the size of the prison system, but have not fully reversed the excessively punitive laws of prior periods of the district's histories. The district council's decriminalization of marijuana and of metro fare evasion, for example, both eliminated the enforcement of low-level offenses where the enforcement practices targeted people of color and were often used to justify pretext stops. Proposals in the criminal code revisions will permit the council to undertake an evidence-based and careful approach to reducing excessive punishment and expanding decriminalization. Others will discuss some of the technical aspects of the statute. In my testimony, however, I will focus on the forces that led us to this point and why reform that reduces the footprint of the criminal legal system is necessary and vital to create a more just District of Columbia. A defining characteristic of the District of Columbia is a harsh and unyielding criminal legal system that has profound negative consequences on Black and Brown communities. 90% of the district's prison population is African American and only 4% is white. The district has one of the highest rates of incarceration in the nation. Involvement in the criminal legal system is a driver of persistent inequality, creating barriers of opportunity to housing, employment, credit, and education. It destroys lives, families, and communities, and has harmed rather than created public safety. While it is not the only factor that creates and sustains racial inequality, it is a significant one. These harms find their source in the criminal code. The district's criminal laws date back to the era of Jim Crow. Much of the current code was written in pre-Home Rule times when the House Committee on the District of Columbia, the effective legislative body for the district, was chaired by South Carolina white supremacist and segregationist Congressman John McMillan. The cruelty and bias embedded in the criminal laws were exacerbated in the 1970s, 1980s, and 1990s as part of the war on drugs and then the war on crime. Mandatory minimum sentences and harsh penalties for drugs and guns caused the city to grow accustomed to increasingly long sentences, overcrowded prisons, and the large presence of law enforcement in Black communities to ensure social control. Rather than address the crisis of unfit housing, failing schools, and the lack of opportunity, the district tried to incarcerate its way out of public safety crisis after public safety crisis through the use of longer and longer sentences. The district sent generations of Black men to prison with all the negative consequences that it had on their families and the communities. The trauma of the incarceration epidemic left deep marks on the city. I've had the honor to represent prisoners and others caught up in the district's criminal legal system for more than 30 years. I helped open the DC Prisons Legal Services Project in 1989, which has since merged with the Washington Lawyers Committee. We litigated dozens of cases against the Lorton prisons in the DC jail. I was a frequent witness in the 1980s and the 1990s before this council, testifying both about the conditions in the district's prisons, but also against amendments to the city's criminal laws that increased penalties, diminished public safety, and destroyed Black lives. Not only were the negative consequences of the council's proposed actions predictable, they were predicted. In preparing for this hearing, I reviewed some of those testimonies and testimony that I provided before committees of Congress. I was struck by one passage in testimony that I gave before the House Subcommittee on the District of Columbia in July of 1984. That passage reads, "The District of Columbia has the highest per capita incarceration rate of any jurisdiction in the United States. 2% of the district's citizens are behind bars. During the late 1980s, the local prison population rose dramatically as a result of the institution of mandatory minimum sentences for certain crimes, increased rates of reincarceration for violation of parole, and a trend towards longer sentences in general. Approximately 10,600 men and women are currently incarcerated in District of Columbia correctional facilities. While we have enjoyed some stabilization of the prison population over the past few years, recent initiatives by the Council of the District of Columbia will likely cause a new rise in the prison population." When I delivered that testimony, the district had enacted a raft of mandatory minimum sentences, placed restrictions on the ability of prisoners to earn good time, and was actively considering 3 strikes legislation. As the council embarks on its review of this important set of recommendations, I hope that you keep this history in mind. I urge you that your considerations be guided by the principles of lenity and proportionality. You'll be reminded of the humanity of every person who is caught up in the system, and that public safety is created by equitable investments in people and communities and not by exiling neighbors to the cruelty of prison. I urge that your touchstone be whether the changes you enact will exacerbate or heal the legacy of racial injustice brought by current laws. Thank you.
Thank you very much, Mr. Smith. Next, let me turn to Cecilia Klingel. Did I pronounce that correctly?
Yes, Klingel, thank you. Hello, it is an honor to be with you here today. Thank you for the invitation to address you on this really impressive effort to revise the DC Criminal Code. My name is Cecilia Klingel. I'm an associate professor at the University of Wisconsin Law School, and perhaps more relevantly, am here having served as associate reporter, assisting the dedicated and capable lead reporter, Kevin Wright, on the American Law Institute's Model Penal Code sentencing revision, a more than decade-long effort that ended in 2017 with the passage of the revised Model Penal Code's new sentencing provisions. Our revision of the code addressed all aspects of sentencing, including sentencing guidelines, deferred prosecution and deferred adjudication, the imposition of custodial, community, and financial sanctions, and collateral consequences of criminal conviction. Several of the provisions under consideration today by the Council find support in the MPC, including the elimination of mandatory minima in sentencing, the authorization of judicial deferral and dismissal of proceedings, which echoes MPC section 6.04, deferred adjudication, and judicial review of long-term sentences, which is similar to section 3056 of the MPC, principles of legislation for the modification of long-term prison sentences. Others already on this panel have capably discussed revision efforts broadly, and I applaud and echo their encouragement toward creating a coherent, comprehensive, and consistent criminal code, something sadly that exists much more in model codes like the MPC than it does in the cobbled together real world codes that now exist in most jurisdictions today. I want to focus my remaining comments on just one portion of this larger effort in which you are engaged, namely those provisions that relate to the punishment imposed for criminal conviction, and particularly to the more progressive and imaginative provisions that have been proposed here to ameliorate some of the harshest sanctions and consequences that are imposed under the law. The reason why this is important is that we need to ensure, in order to maintain the legitimacy of our justice system, that sanctions are justly proportionate to the culpability of those who are being punished, as well as to the harm that is created by criminal conduct. Other panelists who I have seen are speaking later today are experts in fields of criminology, and I am certain that they will speak about much of their important research and about the reasons why, from a utilitarian point of view, when we consider the needs of public safety and deterrence, very lengthy sentences are inconsistent with what we know about patterns of offending behavior as they occur over the life course. I'm going to leave discussion of statistical trends and analysis of recidivism and desistance in their capable hands. But I would like to take my short remaining time to make a few observations about not just public safety considerations, but the other consideration that often drives long-term sentences, and that's just desert. Many times we impose harsh sentences on people, not because we are afraid of what they might do, though that may be lurking in the background, but rather because as a society, we judge harshly how much punishment we think people need and deserve for what they've done. There is fear in public conversation that efforts to revise sentencing codes, to reduce maximum sentences, to eliminate mandatory minimums, or to give judges greater discretion will somehow undermine accountability for things that we believe are wrong and harmful and deserve some kind of stigma and sanction. I want to point out that none of the provisions that have been proposed, at least as I have read them in this, again, very lengthy and comprehensive code, but those that I have reviewed, particularly those related to second look sentencing, deferred adjudication, and the elimination of mandatory minima sentencing, none of them would undermine accountability. What they would do instead is allow for judges to make much more nuanced decisions in individual cases, assessing the culpability of individual defendants, making decisions about what kind of sentence is needed, what is warranted by virtue both of what has occurred and by virtue of reference to community standards that exist now, and in the case when very lengthy sentences are imposed on people, will provide an opportunity for us significantly down the line to pause and reflect and consider whether our judgments about what is necessary and warranted as a result of criminal sentencing are the same tomorrow as they are today. Any of us living now in 2021 can see in our even short memory of a decade ago, the conversation around criminal justice has changed. Public understanding, especially of the effects of the criminal justice system on minority communities and individuals, is evolving, and it is becoming more nuanced. Providing opportunities within the law for consideration of those kinds of changes advances justice, ensures proportionality, and improves the legitimacy of the legal system. Thank you.
Thank you very much. Next, we'll turn to Jake Horowitz.
Thank you for the opportunity to testify today. My name is Jake Horowitz. I'm the director of the Public Safety Performance Project at the Pew Charitable Trusts. Since 2005, Pew has supported public officials in more than 36 states as they advanced policy reforms to protect public safety, ensure accountability, and contain correctional populations and costs. Without exception, these efforts begin with rigorous data analysis and are grounded in a large and growing body about what works to reduce recidivism and crime. I join fellow panelists in commending the Criminal Code Reform Commission and this committee for undertaking the very laborious but important work of clarifying and modernizing the district's criminal code. And speaking of unglamorous but important issues, I will focus my testimony on 3 questions pertaining to the Act's proposed property crime punishments. Why are theft thresholds important? Is DC in good company when it comes to raising the threshold? And what does the research say about the effect of raising theft thresholds on property crime and larceny rates? So first, why is this important? Property crime, and theft in particular, is particularly high volume, so criminal statutes can affect many people and incur high costs. The research is clear that the growth in US correctional populations since the 1970s was driven in large part by policies that exposed more conduct to criminal sanction and increased the severity of penalties. One example is when a legislature changes the law to increase the penalty for a crime. For example, moving a crime from a Class B to a Class A felony. By contrast, criminal penalties for property crimes are increased when legislatures don't change the law. Because of inflation, $1 today is worth much less than $1 a decade ago, and as a consequence, jurisdictions that don't increase their monetary thresholds are effectively applying felony punishments to crimes of lesser and lesser significance. The logical policy solution is threefold. First, raise the threshold. Second, index the threshold to inflation. And finally, remove carve-outs that aren't closely tied to public safety. So now, I want to ask, is DC in good company when it comes to raising the threshold as proposed by the Code Act? DC's current statutory framework sets the threshold for between misdemeanor and felony theft at $1,000. The revised Criminal Code Act would raise that dividing line to $5,000 and create a 5-tier scheme that differentiates the more serious of thefts over $50,000 and $500,000, as well as 2 levels of misdemeanor penalties, lower on the scale. DC would be in good company if it raised these felony theft thresholds. Since 2000, at least 39 states and the district have raised their thresholds, with 9 doing it twice. And as of 2018, when Pew last examined this nationally, 15 states had felony theft thresholds higher than DC's. For example, more than a decade ago, South Carolina raised its threshold to 2 times DC's current threshold. And finally, I'd like to address what the research says about the effect of raising theft thresholds on property crime rates. Some skeptics are concerned that raising the felony theft threshold might increase the amount of property crime and/or the value of goods stolen per crime. Pew has conducted 2 relevant studies that I'd like to tell you about. In April 2017, we looked into the crime trends in the 30 states that raised their felony theft thresholds between 2000 and 2012 and compared them to the 20 states that did not. We found that raising the felony theft threshold had no impact on overall property crime or larceny rates. These rates continued to fall in the states that raised their thresholds between 2000 and 2012. Moreover, states that increased their thresholds reported roughly the same average decrease in crime as the 20 states that did not change their theft laws. And finally, the amount of a state's felony theft threshold, whether it is 500, 1,000, 2,000 or more, is not directly correlated with its property crime or larceny rates. To expand on that initial study, we took a deep dive into one state, South Carolina, which had doubled its felony theft threshold to $2,000 in 2010 to observe more detailed and nuanced outcomes. The evaluation reinforced our earlier national findings, showing that the state's property crime rate continued to fall, dropping 15% in the 3 years after reform. The analysis also examined the common concern that threshold increases will encourage people to steal items of higher value. We reviewed data on the value of goods reported stolen in South Carolina and found it did not change, remaining roughly $200 on average. This finding suggests that the higher threshold affected neither the total rate of nor the average harm associated with theft crimes. Ultimately, both studies came to the same conclusion. Jurisdictions can safely raise felony theft thresholds without disrupting downward trends in property crime. By way of conclusion, because they have not been updated for the past decade, DC's property crime threshold laws have allowed felony punishments to be applied to property crimes of decreasing significance. Our research suggests that by adopting reforms such as those proposed in the revised Criminal Code Act, DC would be in step with a national trend toward focusing the most expensive correctional sanctions on the most serious crime. Moreover, our research suggests that these policy changes can be adopted with negligible impact on crime trends and theft amounts. Thank you for this opportunity to testify.
Thank you very much. Next, let me turn to DeRay McCusson. Good afternoon.
Everybody, it's an honor to be here, an honor to be with this group of people committed to changing the system to help people's lives. I'm here to talk about felony theft, which Jake already set us up for, and shout out to Jake and the incredible research that Pew has done to help people understand the importance of felony theft. I'll say 3 framing things. So I spend most of my time on issues of policing, and we think of this as a police issue too, because we think of all of the issues of mass incarceration mostly as police first, that you can't name 3 ways you get to prison or jail that don't include a police officer. And we think about that as important because we don't think about the police as ancillary to this problem, but we think about the police as intricately involved in how the mechanism works. The second thing I'll say is that when we think about issues around incarceration and about jailing and fines and fees, or about laws around consequences, we always push people to think about the difference between a punishment and a consequence. That a punishment is about pain, a consequence is about change. When I think about the felony theft thresholds, and I'll show you in a second, we think that this is set up to just be a punishment for people, to cause pain to people in ways that we don't think sets them up to make any sort of change or make a different decision in the future. And the third is that we're never overwhelmed by the enormity of the problem because we understand this as the sum of the pieces and not the whole. And we believe that we can map the pieces, that we can work on it piece by piece and actually change the system. I think that what's impressive about what's done right now with this proposed revision of the code is that this is a sum of the pieces in a way that changes the whole. So I'll go through what we believe about felony theft. Like Jake said, we think about it with this idea of raise the threshold. The threshold right now is $1,000 in DC, and we think that fundamentally people should not go to prison or face a lifetime of consequences for stealing a cell phone. Now, you've heard Jake already say this, but I'll repeat it, is that we think that the felony theft thresholds are dangerously low right now. And we think that this is really outdated. And as Pew's research has showed, is that we can raise a threshold without endangering public safety. Now, as of today, the threshold is $1,000. It was last updated in 2010. We took Pew's research that they had done a couple years ago. We updated it for all 50 states, and we did this analysis. The first analysis that shows the current thresholds, the penalties, and what we call carve-outs. So every state and the district has a set of things that are considered felonies regardless of the dollar amount, considered felony theft regardless of the dollar amount. So in DC, it's $1,000, last updated in 2010. You can see that the penalty is up to 10 years in prison and a $25,000 fine for stealing something over $1,000. And that there are a set of carve-outs that we would advocate to also be removed that are not included in the current revisions to the code. So as of today, The question becomes, which of these actions in DC could potentially get you charged with a felony? These three items are theft of an electric scooter, theft of an iPhone, or altering price tags. It is a trick question in all of the ways because all three of them are considered felonies today in DC. So both the electric scooter and an iPhone are over $1,000. And there's a carve out that essentially makes altering price tags, any sort of changing the labeling is considered a felony regardless of the dollar amount of the item. So I'll give you a second to just look at this. This is our mapping of the current felony threshold and the penalties associated mapped against what the code proposes. What you'll see is that this raises it to $5,000. We think that is unbelievably progressive. We think that's a good thing. Jake laid out why property crimes matter. Remember that about 2.3 million people are incarcerated on a given day. There's not a lot of work around property, but property is one of the biggest chunks of crimes that people commit across the country. And there are three carve-outs at the bottom that we would also want to discuss. When we think about deceptive labeling, there's a carve-out today that says that essentially if you record anything without permission and potentially sell it, that is automatically a felony. And we understand the need for a consequence. We don't think that consequence should be up to 10 years. Authorized use of a motor vehicle is not the same thing as vehicular theft. So unauthorized use of a motor vehicle will be something like taking a tractor trailer. This is true. This is not hyperbole. The law today, if somebody took a tractor trailer and drove it down the street for a little bit, or just joyrided, didn't have to go far, that would technically be a felony. And again, we think that there should be a consequence for that. That is not the same thing as engaging in theft of a car. And the good thing about the proposed revision is it raises the threshold, but also that it takes away the mandatory minimum and maximum 15 years for almost everything except for this enhanced burglary issue. We actually just did a poll with YouGov, which is an international polling firm. We did a poll with them that just closed on November 3rd of DC voters, and it is promising. When we do this work all across the country, we realize that the public agrees with these issues. So DC voters supported raising the threshold, 65% supported. DC voters actually supported going to 5K. We asked explicitly about the 5K, and DC voters supported that. DC voters also supported tying the threshold to inflation. So, we know that if it's not tied to inflation, we'll just be back here in another 10 years, 15 years, saying the same thing. And DC voters supported that. And then a majority of DC voters supported removing the carve out. So there shouldn't be different gradations of felony theft consequences, that it should be just very clear for everyone. So like Jake said, we think about three solutions to this. One is increase it to 5K. Second is index the threshold to inflation, to be indexed to inflation. And the third is remove all carve-outs that are not in the interest of public safety, and the carve-outs that are in the DC law are not in the interest of public safety. So an honor to be here today, excited that this is included in the revisions and excited to see what's possible.
Great, thank you very much. Next, let me turn to Kevin Ring.
Thank you, Councilman Allen, and the distinguished members of the council for allowing FAM to testify and share our views on the bill before you. I first want to recognize the work of the DC Criminal Code Reform Commission and its advisory council, which produced this comprehensive and forward-looking update and revision of the district's criminal statutes. And I applaud the council and the mayor for supporting the agency's critical work. It is hard to imagine how the commission's work, this time-intensive development of a report with substantive recommendations, which followed consultation with stakeholders, the review of best practices in other jurisdictions, the research into relevant social science literature, and the analysis of district crime data. It's hard to imagine how all of that process could be more different than the development of so much criminal justice policy in this day and age. For too long, we have seen crime policy driven by anecdotes, usually rare events that capture the public's attention, but distort our sense of what the true threats and risks people face are and which interventions are most likely to reduce those threats. One reason for this, I think, is rooted in our human nature. We don't have a gut instinct about things like net neutrality or Medicaid funding levels. So we study the arguments on both sides and choose. With crime, we all have an evolved sense of order and intuitions about what will keep us and our loved ones safe. As a result, policymakers seem more willing to ignore the mountains of social science data that we have accumulated over the past few decades, and instead rely on their biases and intuitions when making anti-crime policy. That's why what you are doing here this morning is so extraordinary and commendable. There's not a jurisdiction in this country that wouldn't benefit from this type of comprehensive review of its criminal statutes, and that includes Congress. Indeed, a bill was just recently introduced in Congress that would require the Attorney General to simply count how many federal crimes there are, because no one knows. The bill would also require the Attorney General to list the elements, the potential penalty, and the mens rea requirement for each crime. I raised that bill in effort by way of comparison because Congress hasn't done it, and your Criminal Code Reform Commission has done all this work for the district. Again, you all deserve credit and should feel good about the process that led to this point. Moving forward, I imagine there will be some spirited debates over certain aspects of this bill, and we urge you to continue to look to the evidence and data and best practices behind the proposed reforms as you consider each one. In my remaining time, I would like to highlight two of the bill's reforms that FAM believes can enhance both safety and justice. First, the elimination of mandatory minimum sentences has been alluded to, and two, the expansion of the second look sentence reconsideration law. Mandatory minimum sentencing laws have been around since the beginning of this country, but they have no place in a modern criminal code. This is not only the considered view of the American Bar Association, American Law Institute, and the Judicial Conference of the United States, but of criminologists from across the ideological spectrum. In fact, it can be difficult to find agreement on anything in criminology, but opposition to mandatory minimum sentencing laws is one area that appears to enjoy unanimous agreement among experts. Now, to be sure, you'll find some prosecutors who support them, and definitely some politicians, but not people who actually review data and evidence on how to administer a criminal justice system most efficiently. This should come as no surprise because mandatory minimums have enormous costs, high economic costs due to expensive prison space and the perpetuation of family poverty, and high social costs due to the separation of families, trauma that comes with incarceration, and disparate application to communities of color. These enormous costs are not outweighed or even remotely matched by corresponding benefits in public safety. Criminologists, again, of all stripes have concluded that mandatory minimum sentences alone do not reduce crime or deter crime. They do not increase public safety. In addition to safety, a modern criminal code should promote justice, and mandatory minimums fail even worse in this regard. Justice in sentencing requires precision, and precision requires individualized review. No two crimes or defendants are the same. We need to know if we're confronting Jean Valjean or the head of an international bread stealing ring. Those are two very different people and should elicit two very different outcomes. We want a sentencer to consider all of the relevant facts and circumstances about a crime and its impact on the community, as well as an individual's criminal record, role, motive, profit from the offense, age, likelihood of rehabilitation, or need for mental health or drug treatment. We should want all of these factors taken into consideration before imposing a just punishment. Mandatory minimums prevent judges from considering any of them. One other point. The burden of over-punishing people because of the inflexible nature of mandatory sentencing is not borne just by the unlucky souls who receive the excessive sentences. In a world where government's anti-crime budgets are finite, which is to say the real world, money wasted on locking up people for extra years or even decades is money that can't be used on programs and personnel that might actually enhance safety. The commission was right to recommend that the council leave one-size-fits-all mandatory sentencing in the past. Finally, FAM also supports the proposal to expand the district's second look sentence reconsideration law. The council should feel good about its work in this area already, particularly you, Councilman Allen. And I know that Tyrone Walker will be testifying soon and can speak to what your reforms to date have meant to people and families. The bill before you would go further and provide a judicial sentence review to any person after they have served at least 15 years of their sentence, regardless of their age at the time of the offense. Importantly, this review would allow the court to consider whether the person presents a danger to the safety of any person or the community, and whether the interests of justice warrant a sentence modification. The review process has been recommended by the ALI's Model Penal Code and is being considered in various forms by more and more states around the country. This reform is supported by data that shows extreme sentences do not make communities safer. The vast majority of people who commit crime, even very serious crimes, naturally grow out of criminal behavior as they age and mature, making extreme sentences ineffective and wasteful. Plus, researchers have found no evidence that severe sentences discourage people from engaging in crime. It is the certainty of apprehension and punishment, not the severity of the sentence, that deters crime. We also know that excessive sentences exacerbate racial disparity in our prison system and divert resources from intervention that better reduce crime. Thanks again for the opportunity to share these thoughts, and we look forward to working with you and the council as it considers this important legislation.
Great. Thank you very much. We appreciate that. We also have next with Dean Roger Fairfax from American University. Dean Fairfax, let me turn to you.
Thank you, Chairperson Allen and members of the Committee on the Judiciary and Public Safety. And I want to thank you for the kind invitation to testify in this hearing on the revised criminal code of 2021. I'm actually currently in a meeting down at the Federal Judiciary building of the Judicial Conference of the United States, the Advisory Committee on Criminal Rules. So I have a 15-minute break. So I am thankful that you've allowed me to thread the needle and participate in this hearing during my break from that business as well. And it's great to see so many friends and colleagues on the witness list. As was mentioned, I currently serve as Dean of the American University Washington College of Law, but I come to this topic as a former federal prosecutor, as an attorney who has represented or defended individuals being investigated for or accused of violating the provisions of the DC Code, and as a legal scholar who has dedicated much of his work to the improvement of the nation's laws and the criminal legal system. I testified actually almost 8 years ago before Congress about the need for reform of the federal criminal code, and the District of Columbia criminal code similarly suffers from a number of deficiencies. And that's why I'm so thrilled about the proposal from the commission and the council's planned action on those proposals. Now, my fellow law school dean, Michael Cahill of Brooklyn Law School, who testified a bit earlier, co-authored 20 or plus years ago an article presenting a framework for assessing the effectiveness of criminal codes in American jurisdictions, as you know. And as you know, our criminal code ranked near the bottom of that study. And has been highlighted by other witnesses, the code has language in need of updating, elements that aren't explicitly set forth in the text of statutes, lack of consistency in definitions, and so forth. And the American Law Institute's project, the Model Penal Code in the early 1960s, really provided a template that was adopted by many jurisdictions around the nation. And the Model Penal Code was deemed necessary by many, in part because many jurisdictions had criminal laws representing a hodgepodge of common law concepts, or loose or non-existent mens rea formulations, or lack of a coherent structure or organization. And the District of Columbia was one of the minority of jurisdictions that did not retool their criminal codes in the wake of the Model Penal Code. And indeed, as has been discussed, the DC Criminal Code has not been the subject of significant overhaul since the beginning of the 20th century. So if we look at the mandate that the Criminal Code Reform Commission had at the outset, that was to use clear and plain language and to apply consistent and clearly articulated definitions to describe elements, including mental states, to reduce unnecessary overlap and gaps between offenses, to adjust penalties and fines and the gradation of offenses, to provide for proportionality in penalties, to organize our criminal statutes in a logical way, and to identify any common law crimes that should be codified, and to propose recommended language for that codification. And finally, to identify statutes that have been held unconstitutional or are vulnerable to constitutional challenges. And the commission certainly answered the call. Just to mention a handful of the innovations in their recommendations, there's a general part, right, with definitions, including mental states. Defenses are codified. The revised code would address how offenses merge and how penalties are stacked. Offenses have many more gradations. The proposal addresses issues such as causation and voluntariness. It also has a detailed commentary, which I think is important because that can be included in the legislative history of the council. And the commission took great care in drafting the offenses that are particularly vulnerable to constitutional challenges, such as threats and stalking and disorderly conduct. And I think overall, the statutes are written in a way that makes it easier for non-lawyers to understand, right? Which would include the public and police officers and grand jurors and petit jurors who would have much clearer guidance about what conduct constitutes an offense. And there's a great deal more to say about this legislation. For example, as was just discussed, we were talking about mandatory minimum sentencing and the expansion of second look sentencing and the expansion of the right of jury demand to the vast majority of misdemeanor offenses. And these and other features are related to the current conversation over demands for furthering racial justice and reform of the criminal legal system. So I'll sign off by congratulating the commission, and to be sure, there will be many difficult choices, Chairperson Allen, for you, the lawmakers, as we move forward. And I offer my assistance as this body explores these and other issues as it considers this legislation in the months to come. So thank you again for the invitation to speak with the committee this afternoon, and best of luck with the rest of the hearing.
I appreciate it. Dean Fairfax, thank you very much. Thank you very much for taking your break with us. I appreciate that. Also, you may know that I've got one of your new attorneys, Antonio Nunes, is on my team now. So a proud alum. So I know you've got to drop off to get back to your meeting, but again, thank you very much for joining us. Next, let me turn to Premal Daria, Executive Director of Institute to End Mass Incarceration at Harvard Law School.
Thank you. Thank you for the opportunity to provide testimony to the Committee on the Judiciary and Public Safety as it considers the revised Criminal Code Act. And thank you to both the Criminal Code Reform Commission and this committee for undertaking the critically important work of analyzing and revising the district's criminal code. It is both overdue and very important, and it's labor and resource intensive work. Thank you for doing it. As our country continues to turn to criminalization as a tool to solve social problems, a tool that people increasingly understand does not work, I'm heartened that DC is doing what others should also do, rather than making knee-jerk reactive policy decisions, but taking stock of what our laws actually say and revising them to meet the reality of our times. I also want to emphasize the importance of this council determining what our criminal laws should be. Most criminal prosecutions here are in the hands of the federal government through the US Attorney, a position that is not elected by our community members. It is a measure of fundamental democracy that the council lean into these revisions and make the changes that our city needs. As the executive director of the Institute to End Mass Incarceration at Harvard Law School, I engage on a daily basis on fundamental questions of how we got here, how we got to a place in which we incarcerate more people nationally than any other country in the world, and of how we move forward. And while data is not straightforward when it comes to DC's criminal legal system, given the diffuse way in which we incarcerate people, there can be no meaningful debate about whether DC has a significant problem on its hands. According to the Prison Policy Initiative, DC has approximately 12,000 unique jail admissions per year. And in a 2018 report, the Prison Policy Initiative also found that an average of 1,153 people per every 100,000 were incarcerated in our facilities. If we were counting rates, that number outpaces every state in the country and thus in the world. And while DC is now about 46% Black, the people we prosecute and incarcerate reflect different numbers. They are almost entirely Black. This is not a question of some slight disparate impact. We almost universally prosecute and incarcerate Black people. We are in an era in DC where change is no longer optional. We cannot sit back and assume we are doing things right. Indeed, we are quite clearly doing things wrong. I was a public defender in DC for nearly a decade. I represented members of our community facing charges that spanned the criminal code, and I have spent my career challenging the harms of the criminal legal system, first through representing individual people and now in a systemic way. I also speak here today as a longtime resident of the city, as a resident of Ward 4, and as a parent who cares deeply about the city her son will continue to grow up in. When we think about what's in the code, in any criminal code, it is what underlies the crises of mass criminalization, policing, and incarceration that we see in our neighborhoods. It is where what we criminalize and how we punish gets defined. Before police or lawyers or judges get involved, the code is what defines what they are all to set out to do, what they are able to do, and what boundaries they operate within. So it's the foundation and thus a critical step toward making any kind of change. Today, I want to address three broad issues that span the revisions. First, clarity. The revisions take great care to properly define the language and concepts used throughout. This kind of clarity is important for obvious reasons, but also because it inherently addresses the issue of notice. How does the average member of our community know what can be criminally charged and what that might entail? How do we go through our lives living and moving in our communities if we don't have clarity on what could even lead to criminal punishment? There are over 700 criminal offenses in the current DC code. Second, there's the issue of the net of criminalization, which is one of the ways we got to where we are with mass incarceration. How broad are our criminal laws? What conduct are we criminalizing? For years, this hasn't been revisited. This code revision does just that. For example, it eliminates the criminalization of what is essentially panhandling, alongside revising and repealing some drug offenses. These are basic, uncontroversial issues that actually matter tremendously to our neighbors who are swept into the web of the criminal legal system, and that matter tremendously when it comes to the behavior of police. Third, there's the issue of overlaps. The huge and unwieldy number of criminal charges we currently have, including some which are quite confusing, means that we have overlapping and duplicative charges, which is of course problematic for clarity and notice, but it also sets up the ability of prosecutors to overcharge. It gives them the opportunity and framework to charge multiple offenses that overlap, creating pressure on the people facing prosecution. The criminal legal system is rife with coercion. Identifying the parts of the system that create that coercion and addressing them is critical. One of these parts is the ability of the prosecutor to charge multiple similar offenses, which can be used, and generally is, to create a plea offer that puts the person facing charges in a coerced, often impossible situation in which the right to a trial is simply not a reality. It's no secret that our criminal legal system is a system of plea bargains. This is how that process starts, and this council has a chance to address it with these revisions. In addition to these three themes, I want to address one specific policy revision, mandatory minimums. The revision to the code eliminates them. Others here have and will address this issue in more depth, but I want to add some insight from my experience as a former public defender. I mentioned coercion earlier. It's a common theme in criminal court, and mandatory minimums play a significant role in it. When prosecutors charge offenses that carry one, they put themselves in the position of being able to hold that over a person's head while offering a plea offer to an offense that does not carry one. As you know from having reviewed the meticulous work of the commission over the last few years, this difference does not necessarily have anything to do with the offense itself, but it creates pressure. And so mandatory minimums play a real role in the system of plea bargains that we've created, and eliminating them is one small step toward addressing that larger problem. It's worth noting too, what some of the consequences of that system are. When people plead guilty pursuant to an offer or a bargain, they generally do so before any substantive litigation has happened in their case. This means that our plea bargaining system has eradicated not just trials, but also the Fourth and Fifth Amendment litigation that would come out in motions hearings. And that's important because that's where the behavior of police is unearthed in criminal court. Whether stops are legal, whether searches occurred when they weren't supposed to. That's where the check on police behavior that's supposed to happen in the system would happen if those issues weren't buried under plea bargains. There are many more parts of this that I would address with more time, including second look and jury demands. I'll submit those in written testimony. This revision is important. It will not fix every problem, but it very thoughtfully addresses important ones in the way our laws are administered. It is a much needed step toward actually building community health and safety, and I urge you to pass it. Thank you.
Thank you very much. And last on this panel, we have Tyrone Walker, Director of Reentry Services, Prison and Justice Initiative at Georgetown University. Mr. Walker, great to see you.
Thank you, Councilmember Allen and other committee members and committee staff for being here. And thank you especially for having me. I want to give a huge thank you to the commission for this huge undertaking of something that we have been waiting for 120 years. I always think about that, like 120 years, ever since we've been having this conversation. So this is a lot of work that has been done and a lot of work ahead. And Councilmember Allen, I know that you are and your staff and all the other council members are ready to hear from all the citizens of the district. As I said, my name is Tyrone Walker. I'm the Director of Reentry Services for Georgetown University's Prison and Justice Initiative. I'm a person who was incarcerated, and I'm a person who benefited from one of the incremental changes of law in the district through the Incarceration Reduction Amendment Act of 2016, an earlier reform that was passed into law on April the 4th, 2017. That's 49 years after the death of the assassination of Dr. King. It's because of that law, I was provided a chance, some call it a second chance, to live a meaningful life in the community after maturity. It's because of that law I am here today to speak about my experience of living through it and working directly with the people who have benefited from what we call IRA and those who will be benefiting from the new iteration of IRA 3.0, or affectionately known as Second Look. After proving that I was rehabilitated, I was released on December the 4th, 2018. Since my release, I have been working tirelessly alongside some of the members on this panel to make this city a safer and better place for all its residents. My focus today is on Second Look for All, which is public safety and justice. In my first 8 months of being released, after serving nearly 25 years of incarceration, I graduated from the Georgetown Pivot Program and was hired in a full-time position by the Justice Policy Institute as an associate. While I was in the Georgetown Pivot Program and working as an intern at the Justice Policy Institute, I was largely responsible for co-authoring an IRA reentry support concept paper that garnered super support from the District of Columbia by providing resources to support those who are returning to the district from incarceration. At that time, those services were for individuals who had committed an offense before their 18th birthday and went to prison at the age of 15, 16, and 17, and returned to the community in their late 30s to mid 40s. Because of that, I became the face of IRA as a productive member of my community and someone who is dependable to advocate for those who have been marginalized since 1901 by the antiquated criminal codes that are currently the practicing standards of the district today. The real faces that drive me are the countless number of friends and peers who I left behind. The same people who have suffered through every single inequity this city has had in place before establishing the criminal codes in 1901 and since its enactment. Adopting these recommendations and complete overhaul of the criminal codes will ensure that people will have a chance to have their cases reviewed by a judge. If deemed worthy by a judge, he or she will be provided a chance under Second Look, what some would call a second chance. But for most of us, we've never had a chance to live as productive members of our community. Since being released nearly 3 years ago, I have been tirelessly working and learning how to continue to make this city safe by working with so many different people and doing so many different things to make a difference. But I'm only one face. And I believe that all those people who are currently incarcerated will tremendously benefit from Second Look. Second Look for All, that is. Second Look for All will create such a safety and a just environment for even those who are incarcerated. I've fielded a number of calls, a number of messages, a number of people, families reaching out to me, and they're all telling me the same thing. Since the passage of Second Look, they are now changing the way that they think. Second Look creates hope for people. They're changing the way they think. They're now enrolling in classes because they know that they have an opportunity, a meaningful opportunity, to be considered for release after serving 15 years of their sentence. And I believe that there's also a huge gap in the information that if we knew the numbers, we know that a number of people are eligible for Second Look currently. How many of those people have been in a fight since the passage of Second Look? How many of those people have been in a stabbing? How many of those people have received any institutional disciplinary infractions? Those are the things that this council needs to know to effectively make the changes going forward for this city. I urge this council to adopt second look for all and make it available for everyone. Thank you for your time, and I'm available for questions.
Thank you very much, Mr. Walker. And let me add my thanks to this entire panel of just some incredible advocates and experts that have shared your time and ideas with us today. So thank you all very much. I want to note we've been joined, I think, by Councilor Mary Che. I see her box up on the screen. So Councilor Che, thank you very much for joining us. What we're going to do is probably 10-minute rounds, and if we need it, maybe an additional 5-minute round right after that. But thanks so much for joining us today. Dean Cahill, let me start with you if I can. One of the things as we've thought about, the work that you've done, and there's something that you talk about in addition to obviously the need to modernize our criminal code, but that you had one of your kind of prescient recommendations in the article that you had written about, that it's not just about the creation, but then you have to have the maintenance of a sound code. We need to have expertise, we need to have vigilance, and even the best of codes, I think you wrote, will slowly deteriorate without active oversight as later generations of legislators unfamiliar with the original code scheme add, delete, and revise provisions, oblivious to the effects these changes have on the code as a whole. In our earlier panel, we talked a little about some of the efforts we have made bit by bit here in the district. So when I went through the process to decriminalize fare evasion, for example, that's one piece, of a larger element. We talked about making an assault on a police officer become a jury demandable charge, and then we just watched essentially everything switch over to a simple assault charge. So if we don't address things in a totality, even when we think we are marching in the right direction of a more just and fair system, we're still running into problems. What are some of the recommendations that you would have about let's assume we pass the RCCA, so we pass this criminal code revision. How do we do that? Or where have you found best practices about how to do that ongoing vigilance?
So first, you're absolutely right. There was, a wave of reform in the 1960s and 70s that dramatically improved the vast majority of American criminal codes. Nearly all of them have been getting worse ever since, as more and more things have been added to them, kind of piecemeal, and in ways that create needless and problematic duplication, right? So just sort of adding things without regard to what's already there in ways that are unnecessary. So you're absolutely right that, the cost of quality is eternal vigilance, making sure that you are not undermining things that you've previously achieved. Now, I think an important thing about codification as a whole is that it properly prioritizes the role of the legislature relative to other bodies, right? If you think about the criminal law of the District of Columbia right now, much more of it is being made by prosecutors and judges because of the gaps and inadequacies of the criminal code than has been put forward by the legislature. This proposed code corrects for that, right? It is more, and appropriately so, an exertion of democratic legislative authority to say what the law is and to make distinctions within the law. But the legislature is very busy, right? And so I think one thing that is beneficial, as you see at the federal level in the form of the Sentencing Commission, and federal law is governed by a terrible criminal code itself, but there has at least been meaningful progress in the area of criminal sentencing because there is a standing commission that is charged with being attentive to matters of sentencing and trying to create in the realm of sentencing a framework and stability that doesn't exist within the substantive criminal law itself. So one thing that might be helpful to the legislature is for a commission of the kind that has been created to create this code to continue to exist, to think about what recommendations should be made as modifications are necessary, so that there's some standing familiarity and expertise that can recommend changes that are understood to be thoughtful and appropriate in light of the code that you already have, rather than just adding something in isolation to respond in a sort of immediate fashion to the crisis of the day.
Okay, got it. And are there any states or jurisdictions that you would point to as kind of the gold standard for that type of either ongoing entity or any other type of efforts?
Well, that's a good question. So one code that I was involved in, 20 years ago, one reason that Kentucky started thinking about having a revision to its criminal code is because they had a standing criminal justice council that was responsible for thinking about these matters in an ongoing basis and offering advice. So, there are certainly states that empower the legislature, but where the legislature also takes input from people who are, charged with paying more regular attention to these matters and offering recommendations that sort of cohere with what's already there.
Okay, great. I appreciate it. Let me turn, I'm definitely gonna have to go through my second round to get to everybody. Let me turn for a second to Jake Horowitz and Mr. McKesson. I think, Mr. Horowitz, you outlined at least trying to look at the evidence of, I think South Carolina was the example you used, showing that raising the threshold did not have a negative impact on public safety. I'm somebody that doesn't really trust round numbers, but I realize that you gotta, thresholds get created at some mark. And I think your point about not having an index is spot on. But we're also talking a little bit about like rational actors. Like I highly doubt that people are going to be making highly rational decisions of saying, here's the exact value of something. I get it that someone's going to say, all right, that's worth more than that. But I don't think people are going to be able to go out and get an assessment of a price on something before making a decision, right? Like that rational acting is not what's happening. So as we think about the gradations, do we think that, I believe and I think Mr. McKesson, I think you had the slide that showed the two, essentially the two gradations to the 5.
Yeah.
Any thoughts around, is 5 too many when in some degree, the act is the act. There's not a whole lot of rational thinking through of like, well, here are my different threshold breaking points of what I'm going to be doing. But then again, there's a value to having a threshold per se. So I want to get your thoughts on that a little more.
Jake?
Go ahead, jump in.
No, you go with this one.
One, just going back to the question you had, council member, for Mr. Cahill. You can think of indexing to inflation as a way of sort of auto-maintaining the code. But to your question about, is 5 too many gradations? There's no objectively right answer. There, some states have 3 or 4 or 5. It's I think the one thing that might be worth considering here are those gradations below the felony theft threshold. So it might be that the district wants to create a standard for theft offense that are simply not arrestable or not jailable. And so those are the kinds of things where you can give a little bit of a nuance and set direction for the city. So that's the only thing I'd comment there.
And the only else I add is that both in Pew's research and ours is that the initial numbers were made up in the first place, right? So you think about New Jersey's is the lowest in the country. In New Jersey, theft over $200 is a felony. It was set in 1978, and you're like, that is, where $200 come from, right? You all are right, sort of in the middle. But we have been shocked at how low these numbers have been for so long with no adjustment.
Yeah. Well, I think your example of, something that just resonates with a lot of people, is just how much does this cost? And so understanding that from a threshold perspective. Let me ask this then a little bit. I'll frame the question a little differently. I think most forms of typical theft, we're thinking shoplifting, pickpocketing, theft, are going to be used as from a criminal law. If you're my employer and you steal my wages, and so it's wage theft, it's going to be civil. It's not going to be criminal, most likely. If it's a rental dispute and a landlord and a tenant, most cases it's going to be civil, not criminal. Is there a distinction that we have that is grounded in public safety, or is it grounded in wealth and power around why we're just choosing which things are criminal and which things are civil? Maybe it's a bit of a rhetorical question, but.
Jake, I don't have a response. I think that's a good push.
Yeah, no, this is well beyond my testimony, but I think that's a wonderful question, and worth thinking on.
All right, excellent. All right. Well, Well, thank you. Let me turn for a second. Actually, wait, let me see my clock. If I still, I'm down to 30 seconds. So let me make this one as fast as I can. To Jonathan Smith, you've been with this committee for a while and have really been a great partner in everything from good time credits to a lot of great work. So I appreciate that. You echoed a lot of our recurring themes today. Much of our current criminal code is implemented by a House committee, not locally elected. White supremacists and segregationists, 1901. Do you think the district residents are actually familiar with that history? When we think about what our laws are in our criminal code, do you think DC residents get that we're talking about, as I think Mr. Walker talked about, 120-year-old essentially framework?
I don't. I do think that understanding that history is incredibly important. How did we get here? What are the forces that drove us here? You think about, you go back and you look at sort of how did we get the enhanced drug penalty in the District of Columbia? There was a front page news article about a pastor who was robbed at gunpoint, and weeks later, the council enacted enhanced gun penalties in the District of Columbia in the 1970s. And people don't understand where these laws come from. So this forums like these, and as you do this work out into the community, I think understanding that history is going to be very important to meet some of the concerns and objections about, is there going to be created, we see in the national debate around, the criminal legal system, is this sort of notion that if you change the laws to actually take into account what we know works in terms of, problem solving, that somehow that's going to create disorder. And, we're now looking at a rise in certain forms of violent crime in certain communities that have got the whole world completely panicked. And, it's without context to understanding the history of our criminal laws and how we have done things that have actually enhanced rather than reduced public safety. So I do think that more education to the community was going to be critical to make this process an effective one.
All right, I appreciate it. We're going to come around with a shorter second round, but let me turn to my colleague, Councilor Mary Che. Thanks for joining us today.
Thank you very much, Mr. Chairman. And I'm really not going to put any questions to our wonderful witnesses. I do want to thank you for all of your expertise and involvement. The only person I'm going to direct anything to is to Jonathan Smith. And it's by way of saying hello, and also to ask you a question analogous to something that you presented in one of my courses. We were talking about the Ferguson report and how there is this effort, to pursue people just to get money, for the local government and all the consequences of that. And then at one point I said, well, how many other Fergusons are there? And you were ready for me, and you pulled down a slide that showed, with all of these dots on the map, how many other Fergusons there really were where this phenomenon was ongoing. So my question is, analogously, how many other jurisdictions have the antiquated, disjointed, and sometimes incomprehensible criminal codes that we have? How widespread is this?
So that may be a question for other members of this panel. I have not studied criminal codes, and there are people who have that are on this panel. I do want to say that, just to take off on the issue around Ferguson, one of the characterizations of Ferguson, one of the driving forces of Ferguson, was the use of our criminal laws to generate revenue for municipalities. That is a problem that exists everywhere and in the District of Columbia. And as the council undertakes this effort, making sure that the revenue that's generated by the enforcement of our laws has no role in deciding what is criminalized and what penalties are attached to it, is going to be critically important. And that is a problem that exists virtually everywhere in this country. And it drives a lot of inequality and inequity. But I'll turn to others who may have looked at more criminal codes than I have. My sense is that it is a fairly common, the kind of chaos in the code is a fairly common problem. And it's more common the farther south one goes than the north, but that may, others probably have more detail than I do.
Before we turn to anyone else on that, though, I just want to point out, and somebody else, actually it wasn't somebody else, it was our chairman who mentioned Some things are civil violations, some things are criminal violations. We have a lot of civil violations where the penalty in terms of money is really extraordinary. And then you have people who don't have the means to pay, then it's doubled, and then, their cars are towed or whatever else happens. All of that money becomes part of the general fund, and it's used and it's built in to pay for things. It's a similar problem, happens in the civil context as well as the criminal. And I just want to mention that because we're constantly raising all of these fines, even though they're not criminal, for the purpose of funding the government. And that is quite wrong. But in any case, if anybody else wants to offer some observation about the extensiveness of codes, the current one of ours, that are like that, I would just be curious to know. Anybody? Okay, then. I have no questions. Basically, I'm in the midst of something else, and I'm listening to this, and I'm very grateful that all of you have come forward to testify and to participate in this whole project. So thank you very much. Thank you, Mr. Chairman.
Thank you so much, Councilmember. Let me turn to a few more questions. I'm going to actually pose this to the whole panel, but specifically to those that have been involved in some of those criminal code revisions in other jurisdictions. That could be everything from raising that theft threshold to other more wholesale pieces. One of the things I'm trying to think about is as we look at this, and again, this is going to take many months for us to work our way through our hearings and input and decision making and voting, but assuming that we're going to move forward and pass our own criminal code revision, have you seen ways in which states that have gone through this have helped best inform their judges, the lawyers and attorneys, the courts? Are there ways that local bar associations or law schools have supported the legal services community through a transition like this? Because when we pass this, it is going to be quite significant, and would welcome any feedback or recommendations you've seen. And I could just call on people if I need to. I'm not afraid of that.
I hesitate to, volunteer others.
Of course, the
Roger
dean is going to
Fairfax
step up. I appreciate
was
it.
on this call earlier. I hate to volunteer him for this effort, but as a legal educator, we have a role in getting the word out and helping people understand, in various ways. And we train lawyers, and sometimes when it's useful and important, we train judges. Here at my law school, we for a long time had a series of conferences around training judges about how to use scientific evidence, because that's not something that is intuitive or familiar to a lot of them. Similarly, if you've got a profound change in the law, there's no reason not to deploy members of this commission, as well as law professors who certainly will recognize the resemblance of this new code to other criminal codes in other jurisdictions, and will be in a position to explain what this transformation is like. Now, I actually think a decent number of lawyers and judges will have a sense of the framework that this code is adopting, because most law students for the last really generation or two have been acquainted with the general structure and template of the model penal code, which isn't quite precisely adopted in this code, but is certainly something that bears a family resemblance that people will find somewhat familiar and intuitive. But I would certainly think that the law schools, some of whose professors have been advising this commission, can be a bit of a force multiplier to sort of help you get the word out and explain the nature of the change, as well as advertise the benefits of the change.
I think that a multi-pronged approach is going to be your most effective, right? So when I think about major revisions just in sentencing law that I've seen in Wisconsin and Indiana over the past decade or two, often what you're doing is having, targeted trainings for specific groups. That could be conferences. It could be sending people to pre-existing and highly attended conferences, particularly in places where there's a lot of requirements for continuing legal education, articles in bar journals, right? Presentations at law schools. You want to get out information as much and as broadly as you can so that you're hitting lots of different stakeholder groups with your sort of triage approach of starting with those who are going to be most directly affected. So you're going to need to get to your prosecutors very quickly, right? They're going to be important. Your police officers, right? The line level first contacts on the street need to know what's happening when you have changes, judges, defense attorneys, et cetera.
Yeah. I appreciate that. I think, sorry, go ahead, Jake.
Yeah, just two quick comments. One, I was thinking about what Councilmember Che asked about, and just really briefly, it's really common in states that we've worked in to find that failure to appear leads to a cascading set of consequences, from license suspension and warrants, which then lead to driving on suspended license. And then you start seeing in the arrest numbers that failure to appear and warrant service are leading causes of arrest, and you even see them in jail admissions. So we've worked with a couple states, Michigan, North Carolina most recently. I'd be glad to discuss that if that's something of interest to the council. And then on this question right now about how to educate, I totally endorse what others have said around annual trainings and CLEs. Another thing we've tried out are these practitioner guides, which are basically shortened form, spiral bound, laminated documents that boil down what's in these massive codes into very understandable kind of tables and things like that. And I'd be glad to share a couple of those with the council if that's helpful.
Okay. Yeah, thank you. I appreciate it. Yeah, I'm trying to think about as we heard Mr. Schmeckel talk about being able to add in a bit of a time. What are the things we need to be doing during that time is kind of something we should think about. So let me turn to, let's see, I think I was going to go next to Ms. Klingel. We've talked a little bit about historically, the council has really abdicated responsibility to draft very clear and consistent criminal laws over time. And within that vacuum, then the courts become the de facto legislature of their own, in essence. I think most, if not all of our panelists have framed that as a bad thing for a variety of reasons. But when we get to the issue of sentencing, most panelists then reject the idea of legislatures establishing mandatory minimum sentences. So they argue that there's an area where the legislature that would be one where the legislature oversteps. Can you help walk us through or explain from your perspective why judges are better situated to determine an appropriate sentence for a defendant when compared to a legislature establishing mandatory minimum sentence?
Sure, that's a great question. What the legislature is doing when they draft criminal laws is letting us know what kind of behavior the community finds not just unacceptable, but worthy of actual punishment and the potential deprivation of liberty. Right? This is the kind of behavior that's so antisocial. We think you deserve to be punished for it. And we're going to set out what the absolute most punishment you might deserve for it would be. The job of the judiciary then is, after prosecutors have served their executive branch function of selecting which cases deserve to be brought before the court, then we're trying to decide within the bounds of permissible punishment that the legislature has set out for us, what amount is appropriate for the particular defendant in front of us. And the task, just to make it simple to the things we do every day, is not different from what a parent is doing with a child when you're imposing a consequence for a rule infraction, what employers do with employees, what teachers do with their students, right? We're trying to look at a behavior that's not permitted and put it into context, both the severity of the behavior itself, knowing that theft, as we've discussed, right, great example, can vary from some shoplifting some gum to large-scale embezzlement. They're not the same. And then within that structure of deciding the nature of the conduct, also deciding what the culpability of the individual person is. Are there reasons to believe that this person didn't fully understand the severity of the behavior at issue, that this person was affected deeply by whether it's mental illness or some other context that makes us understand a little bit better why he or she acted the way that he did, and to think that there might be interventions short of just pure punishment that might be more effective in responding to the crime. That's a really, really rich fact-intensive inquiry. The fact is our criminal courts don't do it well either, right? We don't have the time and the resources to individualize punishment at a level that's like truly intimately just and fair. But we try to do it as best we can on the scale at which any institutional system has to operate. And judges are positioned to make those inquiries. Legislatures can't, right? There is no abstract, the theft that is worth this amount that actually maps onto a real person's experience of taking something that she shouldn't have taken. And we trust judges to exercise that combination of legal and moral judgment on our behalf. And when they do it well, we feel like the system is fair, right? Both victims and those who are being punished for criminal behavior accept the legitimacy of our legal system. And that's what we want. The problem is that we haven't been doing that well at all. And no one's happy with it. Not victims of crime, not people who are being punished, and often not the people who are implementing the laws themselves. Most people with deep knowledge of the criminal justice system, from legislators to prosecutors to judges, they're not really happy with it either. And I think that suggests that we have some really deep work to do to fundamentally get back to a justice system. The very fact that there has been a move, not only in the academic community, but in the policy community, away from referring to this as the criminal justice system and calling it instead the criminal legal system, suggests a very profound brokenness if we no longer feel comfortable using the word justice to describe what we're doing to people.
Yeah, that's a great point. Mr. Ring, to kind of pivot to you for a little bit, since we were talking about mandatory minimums there. You've talked about, well, first off, let me just say good to see you again and thank you. You've been before this committee several times and appreciate the work that you've done with us. You talked about, and we heard this echoed from a few other places as well, that it is the swiftness and certainty rather than the severity of sentences, if I'm looking at it from a deterrent, if the question or if the perspective I'm looking at is from a deterrent. Swiftness and certainty is something that's kind of hard to address from a criminal code perspective. And we'll kind of ask you just your thoughts around that, or does that speak more to criminal procedure and law enforcement strategies if I'm taking a lens of what is or is not a deterrent, and the data and evidence tells us that the extremeness and severity of a sentence is not what is an actual deterrent?
Yeah, I think that's one of the oldest findings in sort of criminal justice policy is that, it's the fear of being apprehended that is what deters behavior. It is why, when you catch your child, you don't need to give them a 3-hour timeout. You just need to give them some period of punishment so that they realize that the behavior isn't warranted. And so I think, you're right that that's not necessarily something that a code can fix in terms of the likelihood of apprehension. That's something that the system through, whether that's, police or other systems monitoring behavior. But what often happens is the only thing lawmakers have to express their anger and disgust at, a high profile crime is this one piece. And so you see throughout history, harsher penalties follow these high profile crimes. I mean, even the history of federal mandatory minimums is piracy first, because that was it. Robert F. Kennedy is assassinated. We get our first gun mandatory minimum. These things follow. We get laws named after children in high profile incidents. So I think it's because lawmakers only have this one tool in their belt, they think, to express their anger, righteous indignation about crime, that you see that. But, as others have said, you sort of have to have the humility to understand that you're not going to foresee every fact and circumstance under which a prosecutor is going to use that penalty. And so that is the problem. And so when you were talking about why do we trust judges, don't trust anybody, but trust a system of checks and balances, right? Because when you act as giving somebody a mandatory minimum, you have now cut out a system actor. And the best actions are when more people review something. And that's where you get closer to justice. People think you take away discretion, but with mandatories, you only take away judicial discretion. And so I think it is important, not necessarily to trust anybody, not to think that judges are omniscient, but just that they know more facts and that they themselves can provide a check on an overzealous or corrupt prosecution or a police investigation gone wrong or other system actors not doing their job. And I think, but I don't think there's any question. And again, this is what's so interesting about the literature on this is there's a lot of areas in our world or policy world where sort of the evidence and data are disconnected from policymaking. Criminal justice is definitely one when it comes to this point. No one thinks that you have a dial that you can keep turning up punishments and you're going to see the behavior go down. That's just not how it works.
Well, asking for humility from elected officials will be
Hey.
absolutely. And there definitely are some people who think that if you keep cranking that dial, that's that. And I think that's, as you accurately point out, will be the headwinds that many times elected officials will be facing. Let me switch gears for a moment. And Ms. Dari, I wanted to turn to you a little bit about, I guess, two things. One is kind of first continuing on the kind of wrapping up this mandatory minimum conversation. And I also want to talk to you for a moment from your own practice of plain language, clarity of language. But first on the mandatory minimum. So you've talked a little bit about how the mandatory minimum sentences can kind of distort the decision-making and enter into a plea bargaining system. Can you talk a little bit more about what are some of the other type of weaknesses we see in our current code? Lack of clarity, overlapping, as we talked about with Director Schmeckel, overlapping offenses that then impacts the ability to advise clients, for example, regarding litigation strategy or navigating plea bargains.
Yeah, absolutely. And if before I answer that question, I was just having some sort of reflections on what Kevin was saying and what DeRay was saying earlier too. I think that a lot of what this code revision does is allow us to, as we're redefining terms and as we're really thinking through what they mean and trying to clarify, to also think broadly about what the purpose of the code is, right? And of harm and what kind of harm we're trying to prevent. And to acknowledge that criminalization and punishment causes harm too. And I think that's just a really important piece of the conversation around mandatory minimums and sentencing and those features. It's to not lose sight of the fact that the harm goes in lots of different directions and that needs to be part of the analysis by judges. And it's part of the reason it's important that judges are doing that analysis, but it needs to be part of the analysis as well. So I wanted to make sure that we didn't lose sight of that piece too. Mm-hmm. And with respect to advising clients, I mean, right. So there are, I mean, I could potentially talk all day or for multiple days about the number of vague places in the criminal code that lead to very, very challenging conversations with people you represent who are facing criminal charges in DC. If you look at any sample of DCCA opinions regarding, mental state or culpability or multiple actors involved in a potential offense, I mean, it's mind-boggling. It will make your eyes glaze over with confusion because, the courts have grappled with these issues for years because the code is so unclear. Trying to advise individual people in individual circumstances about what kinds of liability or punishment they might face it's incredibly challenging. And what that means for real people who live in our city, right, is that there's totally a lack of notice, a lack of clarity, which leads to not only a lack of engagement and trust in the system, but it leads to widespread sort of malaise, right? It creates new harm of its own. And so I think this piece about really clarifying the meticulous work the commission has done to clarify mental states, culpabilities, levels of culpability, the interaction of different actors who might have engaged in overlapping conduct. All of those pieces is, it's highly technical, and I'm so grateful for the work they did to weed through it, and for you all for engaging with it. But it is so important for the daily lives of people who are facing actual punishment in the District of Columbia.
I appreciate that. The other, and just quickly related to that, we've talked about clients, we've talked about, advice clients. What about jurors? I think I heard Dean Fairfax talk about this a little bit around the need for that type of clarity, plain language. From your practice at PDS previously, like, how do you see that play out in terms of the ability for jurors to understand what the charges are, what the specifics are, what all the things that they are being asked to do, in what ways that plain language helps them be able to make an informed decision?
Absolutely. Jurors are part of our community, right? Part of the public. And when they come into courtrooms, they're expected to take on these roles where they automatically understand how the process works and what the criminal laws are. And of course, there are jury instructions, right? The courts and lawyers instruct jurors on what the law is. And as someone who's practiced here, I can assure you that in nearly every trial I ever had with jurors, there were always questions from jurors, right? They send notes. They send these questions like, what does this mean? You said the law was this, but what does that actually mean in this context? I don't understand how I'm supposed to evaluate this evidence because this doesn't make any sense. That's a norm. I mean, that's just common, right? And so then there's litigation that ensues. There's back and forth and litigation and time and resources being spent to then explain to jurors, and potentially without agreement between the parties in the court, right, about what the law is. All of that could be addressed by the kinds of clarifications that are present here, in addition to jurors actually feeling empowered that they could come into a courtroom and engage in the way that they're meant to, that the Constitution and the courts mean them to. A colleague of mine at PDS used to talk in his closing argument about how the chairs of the jury system are literally built into the infrastructure of the courtroom, right? They're attached. We are very much meant to be engaging jurors in a way that we're not currently engaging them. And I think that this kind of clarity will really enhance our ability to do that.
Right, I appreciate it. All right, Mr. Walker, I'm going to have you help us close out this excellent panel. And I appreciate how many times you've come before us and talked, and I know you're coming up on your 3-year anniversary too. But you have spoken powerfully today as well as previously. And to be fair, I've actually heard this repeated to me from so many other places as well, that when we passed the Second Look Act, when we passed IRA, that the sense of hope that it gave to individuals who were incarcerated and serving extreme and long sentences, that it fundamentally changed the ways in which individuals were thinking about their future. It started creating hope where there was none. And this idea of the clarity of the code is something I wanted to ask about. And you and I think on this panel may be the only 2 non-attorneys here. We are certainly attorney adjacent. We have attorneys everywhere. But as lay people, having that clarity, and especially when we think about reforms like a Second Look Act, being able to have that type of clear, plain language that, someone who is not trained in law school is able to help understand, feels like that's somewhat related to the ability to then navigate that process to create that hope you're talking about. Just kind of curious if you want to talk a little bit more about, by going through a process that creates more accessible language, in what ways do we see that then get translated into those that are trying to then obviously apply the code?
That is a great question, because when I think about it in that context, and understanding that the average person that's incarcerated read at a 3rd grade reader level, right? So to have clarity of the code of what I'm faced with, how much time I must serve before I'm eligible for second look, parole, or whatever that is, that's huge. Mm-hmm. And also taking into the context that the prison officials are also confused at the same time about codes and legislation. And so they're not in a position to help. So having clarity about the code helps everyone. And I do have to echo that passing a second look for everyone helps everyone, not just in the district, but throughout the nation. As I mentioned, like if we can get the data about how people are acting, because that's something that's not known during initial sentencing, how a person is going to reform their life, right? What's going to be the trajectory of this person's life after the initial sentencing? That's not known. No one knows how bad that person inside wants to change because of that mistake. And when that person or them people do that, we want to know the information about them. And we can only know it if it's shared. That's the only way we'll know it. Like, so we can share it. If it's shared, more legislation that can be passed throughout the nation, and we can start affecting the change of what we have been trying to affect with these incremental changes of mass incarceration. Because you'll be able to overhaul the system throughout the nation. because everybody will want to adopt the changes knowing that these changes work.
Yep. Well, I appreciate Mr. Walker. That's really powerful and helpful. Thank you very much. All right, we are at time now to move on to our second panel. I want to thank everybody on our first panel for just some really thought-provoking and excellent testimony for us to consider as we take a look at this. So thank you all very much for your time today, for your thoughts, and I hope and trust that we can reach back out to you with additional questions as we go through this process. So thank you all very much.
Absolutely. Thanks so much.
Thank you for having me.
Absolutely. Thank you. All right, let me go ahead and start calling our second panel. It takes us just a moment as we move our second panel from attendees onto the panel, but let me go ahead and call out our names. We have Miriam Krinsky, who's the Executive Director of Fair and Just Prosecution. Vita Johnson, who's an Associate Professor of Law at Georgetown Law. John Kramer, Professor Emeritus, Department of Sociology and Criminology, College of Liberal Arts at Pennsylvania State University. Casey Anderson, Communications Manager for the Council for Court Excellence. And Nazgul Ghanoush, Senior Research Analyst with the Sentencing Project. So thank you all very much for your time. And I see that we're moving people over. Excellent. And what we'll do is we'll just kind of go in the order in which I had called. So Miriam Krinsky, I see you are here. So why don't I turn to you first? And thanks again.
Councilman Allen, and thanks to the entire body. We appreciate the invitation to address this group, and we appreciate as well the important work that all of you have been doing in the District of Columbia. It's also great to be in the good company of friends and colleagues. And let me note that sometimes it's the attorneys adjacent that have the greatest clarity on these issues. So my name is Miriam Krinsky, and I'm the Executive Director of Fair and Just Prosecution. Our organization, FJP, brings together elected prosecutors from around the country as part of a bipartisan network of leaders committed to change and innovation. Our bold and innovative leaders come from around the nation. They include Attorney General Carl Racine in the District of Columbia, leaders from rural and rural areas, California, New York, and everywhere in between. Collectively, the leaders we work with represent 70 million people, or more than 20% of our nation's population. I myself spent a decade and a half as a prosecutor. A number of those years were in the DC Mid-Atlantic region. And I saw firsthand during the 80s and the 90s, the failed tough on crime approaches. Now, today, we know that we have leaders, researchers, and communities most impacted by those policies that are reckoning with decades of tough on crime practices. We've seen countless dollars and millions of people who have been impacted as we fail to achieve the promise of advancing safer and healthier communities. So today I'm here to applaud all of you for your work and to encourage this body to embrace best practices and lessons learned from within our country, lessons learned from around the globe, as we try to craft a criminal legal system that's less punitive, that's more aligned with community norms and values, and more attuned to science and data. As you engage in your work tonight, we know that we have over 2 million people behind bars in our prisons and jails. We also know that while we represent 5% of the world's population, we house over 20% of its prisoners. That is a rate of incarceration that is second to none across the globe and makes us an international outlier. And I believe that we're far past the point where we can argue that the status quo is the best solution in a punitive system that seeks to address all of the societal challenges that are better solved often elsewhere. Mass incarceration is not a necessity, it's a choice. And we now have an opportunity to revisit that choice. So against that backdrop, I applaud all of you for the important and timely work to reform the criminal codes and craft a revised Criminal Code Act of 2021. This is a rare opportunity for you to address past injustices, align with new thinking, and go further and spur change, not simply in your statute, but also on a systemic level, how we think about these issues. So let me offer 6 observations and thoughts as you move forward with your work. And I hope to stay for question and answer, but have to virtually appear in Miami by around noon. So hopefully I'll be able to be with you until then. First of all, as to sentencing ranges, I know that your sentencing ranges have come in slightly lower than DC's existing statutory ranges, but I would encourage you to think about the maximum sentencing ranges and maximum sentences under the law that still far exceed international norms, and I believe what is necessary to protect public safety. You may want to consider aligning yourself with the research that demonstrates the significant harms and lack of public safety benefits associated with extreme sentences of more than 20 years. That is the norm in other countries around the globe. It has not left their communities any less safe, and I believe it's time to reset the thinking in that regard. Secondly, I came in at the tail end and heard my friend Kevin Ring and others talking about the issue of mandatory minimums. And we applaud the effort to eliminate the district's mandatory minimums. That starting point, one that I operated under as a prosecutor for 15 years, strips judges, prosecutors, and others of discretion. It fails to account for the unique circumstances of each individual and each case. It's not necessary, and it simply fuels punitive approaches that have disproportionately impacted Black and Brown communities. It's wasted resources and it's destroyed lives. So there's good reason to prioritize the imperative to end mandatory minimum sentencing as part of your revision process. Third, I'm heartened to see the effort to significantly narrow the application of DC's felony murder provision, which holds individuals vicariously accountable for the acts of others. And in so doing, it's been used historically to result in unjust sentences. It's important to keep an eye as you proceed with that work on ensuring that as you move forward, that any felony murder provision and its application is as narrow as possible. And that's an objective that we hope will continue to be advanced. Fourth, I applaud your willingness to expand even further the efforts that were made previously by your body as it relates to sentencing review. If we want to truly address and undo harms of the past, we need to revisit past unjust and extreme sentences. We have today over 150,000 people aged 55 or older behind bars. 1 in every 9 people in prison is serving a life sentence, and we hold 40% of people sentenced to life in jail from around the globe. We need to address this, and it's particularly appropriate to do so amidst the current health crisis behind bars. You led the nation on your Second Look Amendment Act, and we're heartened to see the RCC provisions that continue this important work. We applaud it, and we also think that there are ways to go further in encouraging prosecutorial practices that in the first instance don't advocate for sentences that then later need fixing. Fifth, the current provisions allow the use of sentencing enhancements against individuals with prior convictions. I suggest that you rethink that. It's not necessary and it isn't needed to protect public safety. And finally, I would urge you to think about the criminalization of sex work. I know you've indicated more work is to be done in that area. I think it's an area drawing national attention and one that warrants your attention. So again, I applaud you for your work. We don't need a criminal justice system that continues to define people by their biggest mistakes. And if we continue the status quo, that premise will continue to be a reality. We'll continue to cement racial inequities and trap individuals and families in cycles of poverty and incarceration. We can decide to act, we can decide to change, and the time to do so is now.
Thank you very much. Next, let's turn to Professor Johnson. Good afternoon.
Good afternoon. Thank you so much for inviting me to testify. My name is Vita Johnson. I'm an associate professor of law at Georgetown Law School, where for the past 10 years, I've worked in our 2 misdemeanor clinics. I testified today to support the Revised Criminal Code Act of 2021, specifically the provision that would expand jury trials for misdemeanor offenses. As you probably know, at the moment, the vast majority of misdemeanor offenses, and certainly the most common charges, are prosecuted by the United States Attorney's Office for the District of Columbia. These cases are not currently jury demandable and are thus decided by a judge at a bench trial. Allowing the citizens of the District of Columbia to decide these cases rather than judges creates a meaningful way for district residents to have a say in the vast majority of criminal cases. This is particularly significant in a city where its citizens do not have a say as to who prosecutes most cases brought in Superior Court, nor who its judges are. Restoring the right to jury trials and misdemeanors is a meaningful check on the power of the United States Attorney's Office, the police, and other institutional players that wield power in the criminal legal system in the district. While all are ostensibly public servants, police, prosecutors, and judges are not currently accountable to the public outside of the felony cases that happen to make it to trial. And make no mistake, most trials in the district in DC Superior Court are misdemeanor trials. In 2019, according to the United States Attorney's Office annual report, there were 153 felony jury trials, yet there were 598 misdemeanor bench trials. By keeping these misdemeanor trials away from jurors, we deny the citizens of the district full participation in the largest part of DC's criminal system. As you surely know, it was an act of the legislature that took away this important right from DC citizens in 1994 as part of the Misdemeanor Streamlining Act. And as the Court of Appeals Chief Judge Eric Washington explained in his 2018 concurrence in the case of Beddoe versus United States, restoring the right to a jury trial in misdemeanor cases could restore the public's trust and confidence that the government is more concerned with individual rights than efficiency. And I'd point out that despite the fact that DC does benefit from a diverse bench, it's not as racially diverse as the community it serves. At the moment, there's not a single Black or Latino judge on the misdemeanor calendar. And next year, only 2 of 7 judges are Black, despite the fact that Black people make up more than 45% of the population in the district and more than 90% of those facing charges brought by the United States Attorney's Office. Jury trials for misdemeanors is a racial justice issue in this city. Nor, of course, is there any diversity in educational background and little diversity around age or socioeconomic status among judges, something that jury trials for misdemeanors would accomplish, as fact finders would come from all walks of life. And finally, as it stands now, not only is it true that Superior Court judges, rather than everyday citizen, decide misdemeanor cases, but because most misdemeanor trials take place in community courts, misdemeanor courts that are arranged specifically by a police district, the same judges hear repeatedly from the same police officers. And in many cases, the police are the government's only witnesses, especially in cases like drug allegations or assault on police officers. I worry that cognitive biases and social norms make it very hard for judges to fairly assess credibility of police officers in those circumstances, because the judges know that he or she will encounter that same police officer in the same courtroom in the near future. Jurors who are called to service every few years and whose deliberations take place in secret won't face this issue. So in terms of representation, civic engagement, accountability for powerful institutions, and from a racial justice perspective, it's the right choice to restore the right to a jury trial in the district for misdemeanor allegations. Thank you so much.
Thank you very much, Professor Johnson. Next, let me turn to John Kramer. Mr. Kramer, I think you're muted. If you can unmute.
There.
Got it.
Sorry. Good afternoon. My name is John Kramer, I'm Professor Emeritus at Penn State University, but my remarks today will particularly focus on my background as the Executive Director of the Pennsylvania Commission on Sentencing and for 19 years or so, and also as director of the United States Sentencing Commission. And looking at this act in terms of its implication for policymakers in the process of both building guidelines, revising guidelines, working with the legislature. Lots of war stories over the years about dealing with statutes and mandatory minimums and others. I also want to commend in beginning the many remarks of the people about mandatory minimums and sentencing and the mass incarceration issues and themes that have been played, I think are very, very important as a part of this important process. I want to add my voice to this act and the importance of this comprehensive and thorough review performed by the Criminal Code Reform Commission, primarily for policymakers. Enactment of the RCC will provide a foundation for thoughtful and fair application of the law and serve as a clear framework in the future for amending the law and for policymakers such as the District of Columbia Sentencing Commission. My work as Executive Director of the Pennsylvania Commission on Sentencing and Staff Director of the United States Sentencing Commission provides me two very different contexts for appreciating the importance of adopting the revised code. First, Pennsylvania revised its statutes decades ago, relying on the Model Penal Code of 1962 and establishing the definition and structure of its criminal code. That certainly was very helpful. It is not as updated and as clear a code as being provided here by this particular commission, but it certainly was a foundation for us to begin working and communicating and training and other things as part of the process. Pennsylvania's crime code provided a solid foundation for this work and provided clear definitions, et cetera. And it provided not only the Pennsylvania Commission on Sentencing with an important legislatively adopted structure as it considered drafting sentencing guidelines, but it also provided those reviewing proposed guidelines a clearer picture of the implications of the guidelines and their foundation. Furthermore, over the years, as the Pennsylvania Commission on Sentencing worked with the General Assembly of Pennsylvania, sentencing issues, the clear structure of the Pennsylvania Crimes Code allowed for a much clearer understanding of any proposals and their impact. One of many illustrations may help to make my point. In 1979, the PA Crimes Code had one broad definition of burglary, which was the breaking and entry into a structure with the intent to commit a crime therein. Very broad definition. The problem for the Commission on Sentencing and its guidelines was how to provide a sentencing guideline that reflected some of the more critical elements of burglary that were not incorporated into the statute, such as property loss, type of structure, time of the crime, potential for injury to the victim, number of issues that were not elements of the crime, but the commission said if we just lump all of these offenses into one category, obviously proportionality is broken, fairness is broken, et cetera, as part of the process. So we stepped back and looked at the burglary statute and ultimately subdivided burglary for sentencing purposes by distinguishing whether the burglary was of a structure adapted for overnight accommodation or not, and whether a person was present in the structure at the time of the offense. In other words, we felt there were significant elements, not elements in statute, that guidelines and judges needed to consider as they determined the appropriate sentence. My point is that the burglary statute, when viewed by a group considering the blameworthiness of the defendant in sentencing, needed more information. The goal for the commission was to establish fairer sentences for defendants convicted of burglary, but in doing so, the commission provided the Pennsylvania General Assembly with distinctions that it determined should be used to amend the burglary statute. By having a well-structured code to work with, the PCS and the Pennsylvania General Assembly were able to easily coordinate their efforts to amend the burglary statute to reflect additional elements that enhance the statute's definition of blameworthiness and risk, and to attach statutory maximums more reflective of the grading of seriousness of the offense. The Model Penal Code model used in Pennsylvania provided great assistance in a number of other areas of policy development. The General Assembly expanded sentencing options to allow for intermediate punishment in the early 1990s for some offenders, for eligibility for problem-solving courts, such as drug courts, at boot camp, as well as many other legislative agendas, including 3 strikes, et cetera, that became a part of the battlefield within which I spent much of my time. I believe that the adoption of Bill 24-0416 will not only provide a fairer system of justice today, but it will also serve as a foundation for policymakers and others as our often changing criminal justice system evolves. Quickly, I want to juxtapose my experience with the United States Sentencing Commission. The United States Sentencing Commission suffered in its writing of guidelines for virtue of the fact that the federal code is very much like the antiquated and unstructured code currently in effect in the District of Columbia. I will not go into detail regarding the problems this presented to the United States Sentencing Commission. And I must note that not all of the USSC guideline problems could have been solved by a revised statute using the model penal code framework. I will just interject one comment to earlier comment I think made about the use of agencies like sentencing commissions and justice councils, et cetera, around the country. The U.S. Sentencing Commission created what is called relevant conduct. In so doing, I'll use the robbery statute. It created a robbery offense subcategorized by adding on elements, the dollar amount, entries, et cetera. It ended up with approximately 1.8 million combinations of robbery. I'll let you just let that simmer, but just think of the number of categories. That fell within 23 categories on the offense scale, but it was 1.8 million categories of an offense called robbery. Obviously, no one's ever sat down and thought through how those proportionately are scaled through those 23 categories. But I just wanted to note, that was my side comment alluding to some of the issues. But I did want to note that the policymakers at the USSC and Congress faced very high hurdles as they attempted to write policy with the antiquated and unstructured code that fails to clearly set forth the elements of crimes and fails to provide statutory grading of offenses. The United States Sentencing Commission attempted to rectify this definitional problem through its creating something called relevant conduct, which is where they came up with the categories for the robbery. Ultimately, the Supreme Court determined that the relevant conduct's use of non-statutorily defined components of the offense required that the federal guidelines be advisory, in quotes, and not mandatory, as the commission liked to define its guidelines, referring there to Booker decisions and some others. And in conclusion, I think the revised Criminal Code Act provides a much needed advancement for justice in the District of Columbia and a clear foundation for future advancements in criminal policy. Thank you very much.
Thank you, Mr. Kramer. Next, let me turn to Casey Anderson.
Thank you so much. Good afternoon, Chairman Allen and members of the committee. Thank you for this opportunity to testify today. My name is Casey Anderson, and I am the Communications Manager at the Council for Court Excellence. CCE is a nonpartisan, nonprofit organization with the mission to enhance justice in the District of Columbia. For nearly 40 years, CCE has worked to improve the administration of justice in the courts and related agencies in DC through research and policy analysis, facilitating collaboration and convening diverse stakeholders, and creating educational resources for the public. Please note that in accordance with our policy, no judicial member of CCE participated in the formulation or approval of today's testimony, and that this testimony does not reflect the specific views of or endorsements by any judicial member of CCE. For over a decade, CCE has advocated for piecemeal criminal code reform, and we are eager to support the comprehensive revisions proposed by the Criminal Code Reform Commission. Adopting these proposals will reduce the criminal code's complexity and make it fairer. DC's criminal code is uniquely outdated compared to other jurisdictions and retains provisions that have ill-defined language, disproportionate punishments, and perpetuate racial disparities. The United States' criminal legal system is rooted in racism, and the district's criminal legal system is no exception.
This means that DC's criminal code has real and racially disproportionate impacts on DC residents, particularly DC's Black residents. Today, 95% of all people serving sentences for DC code offenses in the Federal Bureau of Prisons are Black, and Black people are overrepresented at every intercept of DC's criminal legal system. The current criminal code's harsh sentencing and vague language disrupts the lives and removes people from their communities. This is a systemic issue that can't be fixed by ad hoc changes. Meaningful reform is not possible unless it is comprehensive and explicitly seeks to reduce the racialized impact of our criminal legal system. In 2010, CCE published Revising the District of Columbia Disorderly Conduct Statutes, which concluded that the court's definition of disorderly conduct was vague and led to the abuse of the contempt of cop charge being used by police in situations that lacked any real threat to public safety. In fact, data analyzed in the report found that DC had an exceptionally high rate of disorderly conduct arrests compared to other cities. In order to draft this report, CCE created a subcommittee which included major stakeholders such as defense counsel, former prosecutors, and a former member of DC Council. The committee met several times over a 9-month period in 2010 to formulate reform legislation. Based on their findings, the report proposed a bill to update the definition of disorderly conduct in order to make it less vague. As a response to our report, in February of 2013, BC Council passed the Omnibus Criminal Codes Amendment Act of 2012, which amended DC Criminal Code to remove the profane and indecent language provision. Bills like these, which shrink the unmitigated powers of police officers on the street, are to be considered a success, no matter how small. We are proud to have been a part of the effort to get this amendment a reality and plan to continue similar work going forward. However, that change and many more are long overdue, and we should not continue to wait for one-off bills to reform small pieces of code while people of color are still disproportionately impacted and harmed by the criminal legal system. The revised Criminal Code Act of 2021 provides the district with the opportunity to enact many reforms, like that of the disorderly conduct statute, which will improve the lives of DC residents while also helping to update and modernize our criminal code. It is comprehensive and ambitious, finally restructures the archaic language of the original code, and is targeted to reduce the racial disparities within DC's criminal sentencing. CCE strives to make the district a leader in justice reform, and we commend the Criminal Code Reform Commission for their efforts in drafting this bill. That concludes my testimony. Thank you so much for your time, and I look forward to answering any questions you may have.
Thank you very much, Ms. Anderson. And next, let me turn to Ms. Ganoush with the Sentencing Project.
Thank you, Chairman Allen. It's an honor to be here. As a Ward 6 resident and as a senior researcher speaking on behalf of the Sentencing Project, I strongly support the Revised Criminal Code Act of 2021. Several of the RCCA's features help to scale back extreme prison sentences, which are infused with racial bias and are counterproductive to public safety. I'll focus on 3: eliminating mandatory minimum sentences, lowering maximum sentences to 45 years, and allowing judicial sentencing reconsideration after 15 years. These proposals would bring DC's criminal penalties closer in line with criminological evidence on public safety. This evidence, in fact, would support the council going much further than these RCCA proposals, pardon me. Reverend Vivian Nixon, former executive director of College and Community Fellowship in New York City, has said, "The quality of the solution depends on who is impacted by the problem." Criminal sentencing in DC is overwhelmingly something that affects people of color, in particular Black men, and crime victims are also overwhelmingly people of color. Researchers have demonstrated that the association of crime with communities of color has favored punitive policies over prevention and rehabilitation. So let us work to mitigate our biases and develop high-quality solutions. The RCCA is in good company in proposing to eliminate mandatory minimum sentences, in league with President Joe Biden, Attorney General Merrick Garland, the American Bar Association, the American Law Institute, and the NAACP Legal Defense and Educational Fund. Researchers have shown across the country that mandatory sentencing has been a key driver of mass incarceration. In Washington, D.C., mandatories have contributed to DC ranking 8th among states in its incarceration rate. And this is a chart that I've included in my testimony if you'd like to have a closer look. Rather than eliminate racial disparities, mandatory minimums allow them to flourish through prosecutorial discretion. It's especially important in DC that we not allow mandatory minimums to tilt the scales of justice, because our felony cases are handled by unelected prosecutors with a history of resisting popular reform measures and their implementation. Rhode Island and New York are two states that eliminated mandatory minimums for certain drug offenses over a decade ago. Since then, both their prison populations as well as their crime rates have fallen dramatically. Since 2004, the Sentencing Project has called for ending life without parole sentences because they're cruel, costly, and counterproductive to public safety. We therefore strongly support the RCCA's proposal to limit prison terms to 45 years, and we encourage the council to go further and establish a limit that cannot be considered a de facto life sentence. The United States Sentencing Commission, for example, considers a sentence above 39 years, just over 39 years, to be a de facto life sentence. We and over 200 organizations recommend limiting maximum prison terms to 20 years, except in unusual circumstances. Criminological research has established that people age out of crime. Criminal careers are typically under 10 years long, as Professor Alex Precaro, who's testifying later today, has noted with colleagues. People released from life sentences for murder convictions in California, Michigan, and Maryland have been found to have minuscule recidivism rates. Life and other extreme sentences are also of limited deterrent value. As Professor Daniel Nagin, leading national expert on deterrence, has written, quote, increases in already long prison sentences, say from 20 years to life, do not have material deterrent effects on crime. Long sentences are counterproductive to public safety because they divert resources towards unnecessary imprisonment at the expense of making effective investments in policies that would prevent future victimization. Organizations such as Network for Victim Recovery of DC echo this understanding when calling for policies that tackle the root causes of crime that, quote, affect crime victims and defendants alike: poverty, lack of access to education, lack of safe housing, institutional racism, and so on. Long sentences are also cruel. Pope Francis has called life imprisonment the secret death penalty and a problem to be solved. So we encourage you to lower the sentencing maximum to 20 years and ensure that all sentences never exceed the maximum that you set through mechanisms such as the repeat offender penalty enhancement. Tyrone Walker, Troy Berner, Kareem McCraney, and Walter Allen, who I'm now proud to have as a colleague at the Sentencing Project. I'm grateful to the council for making it possible for these men and many others to return to our communities through legislation that allowed them to receive a second look by judges for crimes committed as youth and as emerging adults. But many remain ineligible for review because they committed their crime after turning 25. Specifically, of the 3,600 people imprisoned with DC Code convictions in 2019, half had sentences of 15 years or longer. And of these, 46% committed their offense above age 25. While criminological research is clear that youth and emerging adults are especially prone to crime and amenable to rehabilitation, this doesn't mean that we should foreclose the possibility of redemption for others. The RCCA rightly extends judicial review of sentences to everyone after 15 years of imprisonment. The Sentencing Project and many experts advise lowering that cutoff to 10 years. That's the Model Penal Code's recommendation for resentencing for youth crimes. And Professor Kevin Wrights, who served as reporter for the code, has joined with national parole experts to recommend initiating resentencing for everyone after 10 years of imprisonment. Senator Cory Booker and Representative Karen Bass's federal legislation would allow resentencing to begin after 10 years. And 10 years is when the DC Task Force on Jails and Justice has recommended that resentencings begin, and that they should be automatic after 20 years. The Sentencing Project encourages you to make sentencing reviews automatic after 10 years of imprisonment with a rebuttable presumption of resentencing. We also recommend instructing judges to address anticipated sources of racial bias, such as in-prison disciplinary records. Meaningful sentencing reconsideration may, as Professor Douglas Berman has written, quote, foster respect for a criminal justice system willing to reconsider and recalibrate the punishment harms that it imposes upon its citizens. Thank you.
Great. Thank you all very much. I saw Professor Johnson, you have to leave in a couple of minutes. So let me just start with you so I get a chance to give you a question before you've got to hop off. You had touched on your testimony, but I want to just give you a chance to get a little more detail about what are the democratic checks? And what I mean by that are obviously locally elected officials, appointed prosecutors. They're in the justice system in other jurisdictions, and why those same protections don't apply in the district. You'd also said in your testimony, you mentioned that jury trials provide at least some check. I just want to give you a chance if you could talk a little bit more about that and kind of what you mean by checks and kind of how you see them working, or on the flip side of that, not working.
Thanks so much for that question. I think this is such an important issue. So as you know, right now, the prosecutors for the district are come from the United States Attorney's Office. And so the head prosecutor is appointed by the president. Same with our judges in DC, they're appointed by the president. And so the district residents don't really have the ability outside of the Office of the Attorney General to elect the people who are going to be making these judgments about what happens to people accused of crimes in the district. Allowing jurors in misdemeanor cases would at least allow some check on what types of cases are brought to full conviction. So for example, in my time in the clinic, we've seen cases like a theft of a $1 cup of coffee from a gas station, the theft of a burrito from a 7-Eleven, the theft of hat and gloves in January from a store. These sorts of cases that I think district residents might not support a full prosecution of those people where they're clearly crimes of poverty and nothing else. And so I think allowing district residents to have a check in terms of a not guilty finding in some instances would be meaningful. And I think it's also worth noting that the types of interactions that normal everyday citizens have with police officers is going to be pretty different than the interactions that judges have with police officers. Judges benefit from seeing police officers at their very best, right? They're freshly scrubbed, they're putting their best foot forward because they're testifying. And that's not necessarily the reality for every police officer in their interactions with people in the public. And I think that allowing jurors to have a say in the outcomes of criminal cases will bring that knowledge into our criminal legal system of what police officer interactions look like on the street in the community. I hope that answers your question.
It does. And what I want to do is also kind of ask you a little bit the flip side of this as well. And what I mean by that is, there's obviously different jurisdictions. This goes beyond the scope of the bill, but it's just part of the conversation. Different jurisdictions elect their judges, and some jurisdictions do not. And I think there's arguments that can certainly be made that you can see a political tide that turns in a way that we certainly see people who campaign on tough on crime. And so, but they are democratically elected. There is you can argue that there is in the same way. And so how should we consider and weigh that when there's kind of the argument can go both ways a little bit? And then does that strip away the independence of a judiciary in terms of being able to make decisions and be somewhat insulated from that political wind that could be blowing?
Sure. I think generally it's a good thing. And I think most criminal legal experts agree that it's better to have judges that are appointed because they have freedom from having to campaign over and over again, have freedom from having to get donors to help them win their elections. So they don't have those biases towards those special interests. So I'm not suggesting that it's necessarily a bad thing that our judges are appointed here in the district. But I do think it's important to note that in many jurisdictions, judges aren't the final fact finders or decision makers in criminal trials like they are in the district. The vast majority of trials in DC, criminal trials in DC, are misdemeanor cases and they're bench trials. And that sets us apart from other jurisdictions.
Okay. Got it. Thank you. I appreciate it, Professor. And again, you got to step away, so we appreciate your time today.
Thank you.
Ms. Krinsky, let me turn to you for a moment. You had mentioned in your testimony that we should consider, that we should reconsider the use of sentencing enhancements in the RCCA. Could you just give you some time to kind of help elaborate on that a little bit more about what your recommendations would be? Ms. Krinsky, I'm sorry, I think you're muted.
That better? So thank you for that. I think that what we've seen, unfortunately, over the past few decades has been a ramp up of tougher and tougher penalties with legislatures that have presumed that that is the pathway to public safety. And also, I think, engaged in a false presumption that that's what communities want. And so that has led to the piling on of enhancements, the piling on during the decades when I was a prosecutor in the 80s and 90s of mandatory minimum sentences, the sorts of things that John and others working in the federal landscape, again, where I was a prosecutor as a federal prosecutor, saw. And unfortunately, it's left us at a place where a couple of consequences have flowed from it. First of all, the racial disparities, as the Sentencing Project and others have so aptly pointed out, have been astounding. And what we have done is we've incarcerated generations of Black and Brown, often young men, through mandated penalties, through drug penalties, gun enhancements, and others that simply aren't necessary, because the presumption there, I think, inherent in those mandatory penalties is that we can't trust judges to get it right. We need to cabin their discretion and tie their hands by mandating what the result would be. And second of all, there's a false presumption that what statutory maximums provide for and might allow is insufficient, that we need to pile on and race to the highest possible sentence. And so I think they've not only resulted in racial disparities, but they've led to individuals behind bars for decades on end. We now have an aging prison population where many are in their 50s, 60s, and 70s, and during this most recent pandemic were at grave risk to their health. We now have to go back and undo many of those penalties. And I think in echoing the comments and that wonderful chart from the Sentencing Project, we also know that the maximums of our penalties, not simply enhancements, that I would suggest dramatically need reducing, rethinking, and can also lead to tremendous disparities across jurisdictions based on the individual decision-making and whim of a prosecutor. Some prosecutors will file them, some won't. The decision to file or not file makes dramatic difference that a judge can't undo by virtue of their mandated nature. So they do lead to disparate treatment of like individuals. But when you look internationally, Germany, for example, has a maximum sentence of 15 years in all but 0.01% of cases. This is just, and only 1.4% of cases in all of Germany trigger more than a 5-year sentence. What we're doing in our country through maximum sentences that are far too high, through enhancements that strip everyone of discretion at the end of the day, is to fuel decades of an aging prison population that just isn't needed to keep our communities safe. So I think for all of those reasons, it's an appropriate time to rethink both enhancements and the maximum caps on sentences that are needed and appropriate.
Thanks, that's helpful. I appreciate you walking through that. I mean, let me ask you also as a former prosecutor, I think oftentimes, these debates oftentimes break out in a way that's probably all too familiar to every single person who's been a part of the conversation today, that there are either tough laws or there's lenient laws. Tough laws mean more time. It's not actual muscular, it's about how long is someone going to be locked away. And people perceive lenient as how little time they are locked away. Nothing to do with rehabilitation, nothing to do with what the harm could be, but that's the way it kind of gets boiled down. But as a former prosecutor, one, is that consistent from your experience in terms of that kind of public debate, but also in your actual experience as a prosecutor, is it ever that clear cut?
It's not that clear cut. And just as laws have been defined that way, sadly, prosecutors have been defined that way, tough or lenient prosecutors. I think what we need are smart laws and smart prosecutors. And I think we even need a set of metrics, as perhaps your work digs deeper in future years, around what do we view as success of our laws, success of prosecutors. I think we have to ask, what are laws and what are the actions of prosecutors that are making our communities healthier and safer and promoting community well-being? How are we enhancing trust with communities? How are we addressing racial disparities? How are we looking at not what the maximum sentence is, but how do we really make it right for victims? How do we address the harm? And how do we avoid recycling through the system? Because we no longer sentences are criminogenic. The longer we keep people behind bars, the less likely they may be able to be to return and stabilize with their family, with their community. So I think that we need to be smarter and not look at a race to quantity, to number of years that we pile on, but really what do communities want? And what they want when we pull them are not excessive decades-long sentences. That's not the yardstick that they're using. But how do we rebuild trust with them? And how do we tend to the needs of survivors of crime who aren't necessarily looking for the longest possible sentence? They're looking perhaps to be made whole, to have the wrong addressed, to be heard in the process, to have procedural justice, as opposed to the maximum possible sentence.
Yeah, I mean, you really are speaking to that restorative justice model that we've seen here and elsewhere, which again seeks accountability, although accountability comes in many forms, but really is trying to aim at what is a just resolution to that. And if I can draw you a little bit as well on what we mean when we say victims, because when we talk about dichotomies, I also think we oftentimes have a very false dichotomy of that there is the person who does the harm and there is the person that experiences the harm, and these are just two defined buckets, when the reality is, oftentimes the person who commits harm has also been the victim and survivor of harm and trauma. So, again, as you're thinking from that prosecutorial role, how much do you see that? And then secondly, in what ways does our law allow for that dichotomy to get broken, essentially be broken apart, or does it actually just reinforce that dichotomy?
Unfortunately, it doesn't do enough to break down that false starting point. And in many ways, for too long, the voices of survivors that have been lifted up and heard have not represented.
Wait, Ms. Krinsky, I think you actually.
In many ways, the voices that we've heard in the past have not been the diverse group of survivor communities. Because as you pointed out, very often those who have been subjected to trauma themselves are often finding that they're at the doorstep of the criminal legal system, and that the trauma that they've suffered isn't recognized when they come to that doorstep. And they now shift from having been a survivor of crime to the individual who's looking at a punitive response to the behavior that they've engaged in. So I think we need to look more deliberately and in a more nuanced way at the vast perspective of survivors, many of whom are simply looking to be heard, treated with dignity, having a place at the table, and not to have that trauma ignored, whether they are whatever side of the justice system they find themselves. And I also think that we have to recognize that a punitive criminal legal system does a particularly poor job of listening to the needs and attending to the needs of survivors of crime. It does not restore them. It simply exacts a further cost in terms of another life that's been impacted, which is why many survivors are loud voices that are speaking out to end life without parole sentences, to allow for second chances, to end the death penalty, to not exact a further cost that piles onto the cost and the harm that they've already been subjected to.
Okay, thanks. Ms. Ganush and Professor Kramer, let me turn to you on something. One of the themes that we've talked about and heard so far today has been a little bit of which body or which actor is best situated to make decisions. Legislators are subject to the democratic process. So one argument is we're best situated, I say that as a legislator, best situated when it comes to writing the laws. Individual judges are best situated to determine individual sentences and where appropriate resolve those ambiguities there'll be in the law. Second look proposals take that process one step further and propose that a second reviewing judge is the best position to determine if a person qualifies for a sentence modification. I guess one question I was trying to pull out of the two of you is, why not just stick with what the original judge determined? There was a case, there was a finding, there was a decision, and there was a sentence. What's the argument to not just stick with that and just say that the judge made their decision, and so that should be the final? And Ms. Ganush, I guess I'll start with you, then Professor Kramer.
Sure, thank you. A couple of reasons, I think. One of them has to do, and here I'm really borrowing a lot from the text of the model penal code that goes through this discussion of why sentences should allow to be modified. And so one of the explanations is just evolving standards of our society. Increasingly we moved away from the death penalty as a sentence. And so it makes sense to look at the most extreme sentences that we no longer think are humane and reconsider them. Another reason is we have an evolving evidence base now to recognize that long sentences are not effective. And so we need to re-examine very long sentences that we imposed decades ago in light of this evidence. And then I think the final reason would be because in order to have a sentence better reflect the changes of the individual who's been incarcerated, and to be able to reduce their sentence and release them if necessary, if there's no longer any interest in continuing to hold them behind bars, and to recognize the interests of survivors and victims of crime who at the time of the offense may have advocated for and supported a very extreme penalty, but as the years go by and as decades go on, their views may change. And there are some very high profile examples of this happening, of people who advocated for legal changes, statutory changes to expand and lengthen sentences, and decades later coming to terms and trying to advocate for repealing those penalties. And actually, Councilmember Allen, I remember hearing you talk about your own experience with victimization with an offense, and how your own experience with that and reaction and idea of what makes a just sentence changed over time. And so I thought that fit as well with what my understanding is, what some victims go through.
Yeah, thanks. Professor Kramer?
I had a couple. I agree with what she was stating, the evolving standards, changing individuals as part of the defendant, the offender. But there's also happens to use a couple of examples of a broader context, and that is, we'll use Pennsylvania or use the federal system and think about various districts and the way in which sentencing varies from districts. In Pennsylvania, if we look at rural counties versus urban counties, et cetera, and the very different standards that evolve in that. You can argue that's a community context and it does that as an individual way. But when you think about the cost, and you think about those streams coming from the 67 Pennsylvania counties, and as one district attorney argued to me many times, in Philadelphia, 2 grams of cocaine is no problem at all. Here, it's a major felony. And so you get a lot of disparity across jurisdictions that really need, I think, a second look. And I mean, that happens both by county standards. It can happen by an individual judge. I had a good friend of mine that was a judge. He felt that every victim the sentence should reflect every victim. So to illustrate this, he sentenced a person who had committed 10 robberies and felt that each victim needed to be reflected in the sentence. He gave the maximum sentence of 10 to 20 for each one. And that ended up with a total of 100 to 200-year sentence. That's a life sentence without parole. In Pennsylvania, there is no good time. The minimum has to be served. That's 100 years time served, more than we give to anything else. Now, it's time to relook at that sentence. And there was an appellate review that went to the Superior Court in Pennsylvania, and they overturned the sentence. That was a part of that review process in which there could be an appeal. So those are, that's an important second look that I think needs to occur because, one, as she indicated, there's an evolving standard too. What happens today may be, viewed very differently in 5 years, and we can think about the marijuana statutes, et cetera, and the changing dynamics of those, the crack cocaine, powder cocaine distinction at the federal level. A number of things that have occurred that we've started to say, we were wrong here. We need to re-evaluate what we're trying to do here. And mass incarceration is one of those things now that as we look at it in terms of cost, in terms of impact on communities by defendants coming back into communities, et cetera, we're going to have to relook at that in the next 20 or 30 years, very, very definitely. And I think what this code is going to set up the opportunity to do that very nicely.
Thanks. Let me ask Ms. Anderson. Mr. Schmeckel testified earlier today that the CCRC repealed or replaced nearly all the criminal offenses actually charged in DC Superior Court. So I take that to mean that there are some rarely charged or never charged offenses that are still in the books under the RCCA. So some might tell us, so what? If an offense is never charged, what's the harm in just keeping it around? Do you have a response to that? How might even the possibility of a punishment, change human behavior or lead to unnecessary encounters with law enforcement?
Absolutely. I think that is a great question. So the Council for Court Excellence, we are not endorsing sort of any particular revisions of this legislation, but the overall revision of the DC Criminal Code. So I'm not entirely sure if I am able to answer this question.
Okay. I might then, Ms. Krinsky, I know you have to step out in just a couple of minutes. I don't know if maybe you have time to give an answer for that one.
No, thank you for that. I think a law on the books, even if not utilized, can absolutely chill behavior. And laws are there both to provide a consequence for behavior, but I think in many ways there's also a symbolic value of laws. They provide an ability to, in some ways, give a sense of what our values are, what we view as problematic, what we view as needing the heavy arm of the law and of government to come in and cabin. And so I think for that reason, even if you look around the country at some laws we have on the books, laws that are still out there that prohibit interracial marriage, laws that are still out there that prohibit adultery, laws that are out there that infringe on personal health care decisions, laws that are out there that criminalize trans behavior and individuals. Even if prosecutors make a choice in exercising their discretion not to enforce those laws, and we certainly welcome prosecutors doing that, because they have discretion and that's what they're there to exercise. The fact that the law is still on the books, it's a problem because individuals may make personal choices about their behavior based on what government has chosen to criminalize. And government is sending a signal to its community that this behavior is behavior that we frown upon, that we view as crossing the line. So I think that there's a need to revisit those laws, even if they're never or rarely enforced.
It's helpful. And again, Ms. Krinsky, I know you've got to jump off just a minute. So again, thank you very much. And as we kind of start to wrap up this panel a little bit, Ms. Ganush, I might come to you just for a second. And that is, so if we think about the extremeness of some sentences, one argument could be criminal laws become more punitive from a time perspective over time because of how people will assess risk within the system. If officers, prosecutors, or judges don't take that action and that person is not sentenced to a long term, that society is then risking that that person is going to victimize someone else. But that also, though, ignores, are there societal risks to over-incarceration, to extreme sentences? Not just on the person, and I think you outlined in your testimony, obviously identifying individuals that that resentencing has led to very valuable, positive contributions by that person. But we think back, what are the effects then on the family, on those family members and to those community members? What are some of the effects of being incarcerated on that individual's family? And as we think about, you know, part of what we asked earlier, kind of the framing of this whole process, thinking about the proportionality and fairness of this entire system and conversation. Are there shouldn't that be part of our conversation as well as thinking about what that proportionality looks like, what that fairness looks like, because that extreme sentencing can also then have an impact that does actually come back and impact public safety overall.
Absolutely. So there's quite a bit of evidence that incarceration has negative impacts on family members in a number of different ways. It can throw people deeper into poverty. It takes away someone who might have been able to provide care for elderly people in the family, provide care for children in the family. So these are some of the ways that removing someone from the community causes harms. And with respect to the poverty issue, it's not just that, you know, a breadwinner is taken away from a family member, but incarceration poses all kinds of costs as well on families who try to stay in touch with their loved one. So that means, you know, the high cost of staying in touch by telephone, calling someone, receiving calls with someone who's incarcerated. It has a it's like calling another country, you know, at prices that existed 20, 30 years ago. It's very expensive. It's not like calling someone in the regular community. And then there's the whole other issue of visitations, which are extremely difficult, especially for people sent to prison from Washington, D.C., because they're held in federal prisons across the country. And so in some cases, it's just prohibitive for family members to be able to make visits. But if they can make visits, it's extremely costly to, you know, the travel costs, the lodging costs to be able to make those kinds of connections. So I think that during the pandemic, something else that we've noticed and seen is that, you know, when we think about people who are especially at risk of health problems during the pandemic, the first population that we were very cautious with has been the elderly, because they're especially at risk of illness and death. And so having an incarcerated population that is so elderly has meant that, you know, a lot of people are at risk of health issues because of their incarceration, people who do not pose a public safety threat. And the fact that we have so many people incarcerated means that the circulation of the virus in prisons, it then circulates to staff and guards and will be distributed into the communities that that these prisons are in. So it's not just a connection between the incarcerated individual and their immediate family members or their community that their family lives in, but also the community that hold the prisons as well.
Great, and I would open it up to any other panelists if they wanted to add to that.
I would just agreeing with what she said, but I would also add that one of the things that happens in our criminal justice system is we've created what we in sociology refer to as kind of a master status. A person commits an offense, that becomes who they are. And we lose an awful lot of other attributes, which are can be very positive and built upon, and categorize them as an offender, a robber, a burglar, a criminal, whatever you might want to use as your label. But it's a label that is a very significant attachment. Irving Goffman wrote a book many years ago about when you take that person with that role of identity of being an offender, and then you put them in an institution, that learning to be an inmate, identification as an inmate, is a very powerful mechanism in terms of defining who that person is in totality. And I think we are throwing away of other assets that those people have in order to fulfill what we want to do as a society in terms of punishment, getting rid of, eliminating these people from our world, et cetera, that I think is results in severe impact on communities and on families, as she was suggesting, that bounces us back into, in a sense, it builds upon the negative to create more negative throughout the community and throughout the families. And you think about role models. I mean, one of the issues that we've done is young Black males happen to be particularly targeted in terms of incarceration, sanctions and incarceration. And that's the elimination of that part of our population by putting so many into prison is, I think, a particularly threatening thing to the positive evolution of our society.
If it's possible, I want to sort of talk about what both Nazgul and John said and tie it back to what you said, council member, about family members. So when John was speaking sort of the labels that we place on people, those labels have subsequent stigmas. And my mother is actually formerly incarcerated, and those stigmas that we place on people who commit crimes, I really do believe that they sort of trickle down, and those family members and the children feel them as well. And so the things that we can do to reduce those stigmas and to reduce those impacts of incarceration, both in terms of duration of time the person is gone, other sorts of things, I do think really have a trickle down effect, because I think the stigmas that are placed upon family members of loved ones who are incarcerated, they do really impact a person's view of self, their ability to thrive, those sort of things. And those have larger and broader implications for a person's disposition to, or thoughts about themselves and how they function in the community. And so I just wanted to sort of uplift what Nazgul and John were saying and touch to your point directly, council member.
Yeah, I appreciate that. Thank you, Ms. Anderson, and thank you for sharing that. Well, I think it's a powerful way to kind of end this panel, so I appreciate everyone's testimony. What I'm going to do, because it's just at 2:30 right now, our next panel is actually, our next public panel is scheduled to begin at 3 o'clock. So what we'll do is probably take a little bit of a recess and reconvene a few minutes before 3 o'clock with our third public panel of witnesses. But let me thank this second panel very much for your testimony and the discussion that we've had. We appreciate that. And I know, again, just like with our previous panels, I can count on you to reach out to you with additional questions and feedback along the way as the committee and the council does this work. So my appreciation to each of you. Thank you all very much. So for the public, the time is now just at 2:30 p.m. We are going to take a recess till a few minutes before 3 p.m. and reconvene with our third public panel at that time. So thanks, everyone, and we'll see you in just a few minutes. All right, good afternoon, everyone. The time is now just a couple of minutes before 3 o'clock, but let's call it 3 o'clock. We've taken a brief recess after our last panel. We're about to begin our third panel of public witnesses. What I'm going to do is call the names of our third panel of public witnesses for today's hearing, and then we'll move people over from attendees onto the panel and then work our way through to hear your testimony. and ask some questions. So let me start by reading out the names and then we'll begin. I have Jennifer Doliak, Associate Professor of Economics at Texas A&M University. Barbara Bergman, Director of Advocacy, James E. Rogers College of Law, University of Arizona. Catherine Huffman, Executive Director of the Square One Project. Patrice Sultan, the founder and Executive Director of the DC Justice Lab. Mara Verheyden Hilliard, co-founder of the Partnership for Civil Justice Fund. Alex Piquero, Professor and Chair of the Department of Sociology, University of Miami. Fernandez, Senior Fellow at the Justice Policy Institute. And Troy Berner, Associate at the Justice Policy Institute. So good afternoon to you all. Thank you for being here with us. I know it's been a long day so far, but appreciate you all making the time out to be here this afternoon. I think Professor Doliak, did I pronounce that correctly? Doliak?
You did, yeah.
Like we're going to begin with you and look forward to hearing everyone's testimony.
Great. Thank you so much for having me. So yes, my name is Jennifer Doliak. I'm an economics professor and director of the Justice Tech Lab at Texas A&M University. I study crime and discrimination, and I'm an economist by training. So this means that I'm an expert on how people respond to incentives. It also means I'm particularly focused on measuring the causal effects of various interventions related to crime. In this work, I typically use natural experiments such as policy changes to distinguish correlation from causation and figure out how policies or programs are affecting behavior in the real world. I was asked to speak today about the effects of sentence length, including mandatory minimums on crime. For decades now, most communities in the US have tried to deter crime by using long sentences. The hope is that would-be offenders would consider the consequences of their actions and that the possibility of spending many years in prison would discourage them from committing a crime today. We now have a great deal of research on what the effects have been. This research tells us that these policies have not had the benefits we'd hoped for. It turns out that making sentences longer has very little effect on behavior today because most people who are at risk of committing a crime are simply not that forward-looking. They might be thinking about tomorrow or next week, but they're not thinking about 5 or 10 years from now. So adding years to a potential sentence, years that are far off in the future, has very little, if any, deterrent effect on their current behavior. Long sentences do prevent people from committing crime while they're locked up, but since most people age out of criminal behavior very quickly, the benefits of that are also much smaller than you might think. Incarcerating people past their 20s or 30s is unlikely to be protecting the community in any meaningful way. And long sentences can actually increase future criminal behavior. That is, people might be more likely to reoffend after they get out. This is partly due to negative peer effects from the others you're incarcerated with and disruptions to work and family life that make it more difficult to build a stable life upon release. In theory, a variety of treatment and training programs offered in prisons could be rehabilitative, but we know remarkably little about whether such programs are effective or how to implement them well. What we do know is that our current recidivism rates are shockingly high, so whatever we're doing right now is not working very well. So what does this mean? The cost of long sentences, including mandatory minimums, far exceeds the benefits. Simply put, long prison sentences are a poor investment. They are extremely expensive and they don't make communities safer. If your goal is to reduce crime, there's no reason to keep them. The best evidence suggests that getting rid of mandatory minimum sentences will have little effect on public safety. Getting rid of mandatory minimums could also help reduce racial disparities in sentencing because there's so much discretion in when they're currently applied. Now, prison has an important role to play in our criminal justice system. I'm certainly not suggesting we should never lock anyone up, but we are way past the point of diminishing returns and it's time to pull back. Reducing sentences doesn't mean being soft on crime. It means being smart on crime. Why continue to spend money on something that doesn't work? So I know that many communities, including DC, are worried about recent increases in homicide and shootings. So what does deter crime if not long sentences? Increasing the probability of punishment rather than the length of the punishment works much better, making it more likely that an offender gets caught and is punished, even if the punishment's not very long, has a big deterrent effect on behavior today. Investigative tools such as security cameras and DNA databases make it easier for law enforcement to quickly identify offenders, and research shows that this has a big deterrent effect on crime. So this is where we should be shifting our public safety resources and energies, increasing clearance rates for crimes. That is, the probability that perpetrators are identified and prosecuted would have a much bigger benefit than continuing to lock people up for decades. In addition, investing in programs like summer jobs for teens and access to mental health care could also have big crime reducing effects. I could go on for quite a while about all the other ways we could invest our public safety resources that would be much more cost effective than long prison terms. And I'd be happy to talk about more of that during the Q&A. Thank you.
Thank you so much, Professor. Next, let's turn to Barbara Bergman, Director of Advocacy, James E. Rogers College of Law at the University of Arizona.
Thank you for the opportunity to comment today at this public hearing on the Revised Criminal Code Act of 2021. I am Barbara Bergman. I'm the Director of Advocacy and Professor of Law at the James E. Rogers College of Law at the University of Arizona. But I'm here today in my role as the editor of the DC Criminal Jury Instructions that are commonly known as the Red Book, for very obvious reasons. It's always been published in a red format binder. I have been editor of the Red Book for over 25 years. I work with an amazing committee of judges, prosecutors, and defense attorneys who spend countless hours throughout the year drafting jury instructions for new offenses and updating existing instructions when the courts issue decisions that change the law that applies to criminal cases. At the end of a trial, judges are required to explain the relevant law to the jury, and they do this by reading instructions concerning the law to the jury and providing the jury with a written copy of the instructions. They do not simply read the relevant statutes to the jury. In fact, in most cases, the jurors would find such statutes impossible to understand and apply. The Red Book Committee, therefore, performs the important function of writing instructions that attempt to explain the relevant law in layman's terms so a jury can understand it. Typically, each jury instruction for a criminal offense contains all the elements of the offense that the jury is supposed to consider, including what actions and what mental state the prosecution is required to prove before a defendant can be convicted. The Red Book instructions also include descriptions of defenses the defendant may raise, such as alibi, self-defense, defense of others, duress, and insanity. And finally, after each instruction, the Red Book Committee includes a comment that explains the relevant statutes and case law interpreting them and why the committee has written the instruction as it has. There are times when the committee members cannot agree on how an instruction should be written, and in those circumstances, the comment also usually explains the disagreement to alert judges and practitioners to potential unresolved issues. The committee's work has often been difficult for a variety of reasons. First, DC's current criminal code is a hodgepodge of statutes. Members of the committee have struggled throughout the years to do their best to determine what the council intended when it enacted various criminal statutes. The committee often must research case law when the current code does not contain essential definitions or elements. The assault set of statutes are a good example of the confusing mixture of offenses which the Red Book Committee has tried to sort through to draft instructions. Enacted in 1901, the statute for the offense colloquially called simple assault prohibits assault, a term it fails to define, and further prohibits threatening another in a menacing manner, which is not the same as the conduct covered by either the misdemeanor threat statute or the felony threat statute. Without a statutory definition, the assault statute has resulted in 3 different types of simple assault: attempted battery assault, intent to frighten assault, and nonviolent touching assault. Then there's assault with significant injury and aggravated assault, both of which are more modern additions to the criminal code. Also in the panoply of assault is mayhem and malicious disfigurement. The statute creating those offenses was also enacted in 1901, and that statute basically just sets out the penalty. It reads in pertinent part, every person convicted of mayhem or maliciously disfiguring another shall be in prison for not more than 10 years. It defines neither mayhem nor malicious disfigurement. And it was not until 81 years later in Perkins v. US that the DC Court of Appeals set out the elements of malicious disfigurement, defining disfigured and permanently disfigured and clarifying the required mental state for both offenses. As a result, in drafting those 2 instructions, the committee had to rely entirely on case law developed over the years by the courts. And in contrast to this, the RCCA, the Revised Criminal Code Act, contains an exhaustive set of definitions and carefully defined elements for each criminal offense. In terms of assault, the RCCA appears to criminalize essentially all the same conduct, defining terms and clarifying mental states in the 4 degrees of assault, as well as in the 2 degrees of offensive physical contact and in non-consensual sexual conduct. Another issue with which the committee has grappled has been the various culpable mental states, or mens rea, required for different offenses. To say there has been a lack of consistency across statutes would be an understatement. Many times the terminology used is outdated and unclear. For example, many statutes use the term malice or malice aforethought, the meaning of which was not clear. And eventually the courts held that malice for homicide cases comprised 4 distinct mental states: specific intent to kill, specific intent to injure, conscious disregard of an extreme risk of death or serious bodily harm, and implied malice in felony murder. A search of the RCCA reveals that the word malice does not appear anywhere in the proposed criminal offense statutes, which I'm delighted to see. It instead substitutes a series of mental states that are clearly defined, primarily based on the model penal code. Finally, the current DC code does not codify any general defenses, such as alibi, self-defense, defense of others, and insanity. And here again, the Red Book Committee had to rely totally on case law to draft those instructions. The RCCA would codify those defenses and give the committee guidance on how to draft those instructions. The Red Book instructions are not mandatory. Judges are free to choose to give other instructions. If they disagree with the Red Book Committee's recommended instruction, then the judges have to grapple with the same issues that the committee has had to address, as I've just discussed. Overall, a clear, modern set of criminal laws, such as the RCCA, would help the public, judges, and attorneys better understand the code, and would also be of immense assistance to the Red Book Committee. While the total rewriting of the current DC criminal jury instructions will be a monumental task for the committee, the creation of a new 6th edition of the Red Book using those carefully drafted statutes would be of immense help to practitioners and judges in the District of Columbia. Thank you.
Thank you very much. Next, we have Catherine Huffman. Good afternoon.
Good afternoon. Very nice to see you. My name is Catherine Huffman, and I'm the executive director of the Square One project of the Columbia University Justice Lab. I'm a resident of the District of Columbia, having lived here for almost 19 years. My husband and I are raising our 2 kids here. Our son is a 10th grader at Benjamin Banneker High School, and our daughter is a 7th grader at Oyster Adams Bilingual School. We love living in the district, and we're really happy to be here. And I'm just really delighted that the council is taking on these important issues. I commend the district for moving forward with this important process, and especially for committing the resources, time, and energy needed to have a deliberative and thoughtful process to modernize the district's criminal code. This comprehensive revision of the criminal code is an incredibly positive step forward for the district, one that will increase clarity, consistency, completeness, organization, and proportionality within our system of justice as it applies to and is experienced by individuals charged with crimes, victims of crime, communities most impacted by violence and by the footprint of the law, and our city as a whole. I strongly encourage the council to move forward with this and take on the recommendations that the commission has provided. As policymakers in our city who act on behalf of all of us, the council also has the opportunity to take into consideration and be guided by the larger picture of justice that goes beyond what can be accomplished within the 4 corners of this criminal code revision, as important as that is. This step should be part of a process towards larger goals for our city, reducing incarceration, ending racial disparities in the system, and building the broader public policy system that will make public safety and thriving communities possible throughout the district. Why does this larger picture matter as you consider the criminal code revision? Because as members of the council, you will have decisions to make as you finalize this legislation. Disagreements and tensions may arise, and competing and at times seemingly contradictory considerations will be at play. By keeping these larger goals in mind as you consider and hopefully finalize this criminal code revision, you can help ensure that it advances them in every possible way. I'd like to share a few ideas that may be helpful in defining the larger picture during your deliberative process based on the research, ideas, and lessons from our work at the Square One project. First, to quickly explain what Square One is and what we do, the Square One project is endeavoring to imagine a future for justice and public safety that finds new ways of addressing the violence, poverty, and racial inequity that stand in the way of public safety, justice, and community thriving for all. Our goal, as we articulated, is to reimagine justice in real life. Our work brings together a broad range of people with expertise, knowledge, and experience that is relevant to this process of reimagining justice. Everyone from academic researchers to community organizers, to policymakers, to justice system practitioners, and many more. For the last 3 years, we've been looking at and learning about what's happening in neighborhoods, in research, in history, and among creative thinkers from every background and field. What we've seen is that there's a national interest in changing the justice system. People don't always agree exactly on what they want from the justice system, but just about everyone can agree that the system we currently have isn't working to get us where we need or want to be. In considering this comprehensive revision of the district's criminal code, DC is contributing to this growing national consensus around change and taking a crucial step towards greater justice and equity. Through our work at Square One, a number of themes have emerged that provide guidance and inspiration when thinking about how we might fundamentally change the way we define and invest in public safety. These themes are many, but there are several that are relevant for the Council's work today. First, a recognition that mass incarceration, the sheer numbers and volume of incarceration levels in this country, unequaled by any other nation now or ever, and reflected in DC, is itself a major driver of the dangers and negative impacts within and around the justice system. Second, a recognition that racial inequality is a defining characteristic of our justice system as it is currently constructed. It's a feature, not a bug, and that we need to reckon with the histories of racial injustice and trauma, as well as their impacts on the present and future, if we're to create safety and healing for individuals and communities, for survivors of crime, and for people who've caused harm to others. Third, that a focus on community thriving and on investing in communities in order to civilianize safety, as we call it, is necessary to achieve lasting change. And finally, that centering the human dignity of every person involved, a person charged with a crime, a victim damaged by violence or other harm, a practitioner in the system, should be the guiding star for an ethical society's policy and practice choices. At Square One, we've grown to understand that this larger context has the potential to guide policymaking, build understanding and buy-in among stakeholders, and strengthen the decisions made. As you step forward and finalize this legislation, I urge you to keep the larger context of what is needed in mind. The commission that has worked so hard over the past few years and provided these recommendations was specifically directed not to focus on some of these larger goals, such as reducing incarceration rates or increasing racial equity within the system. And indeed, it would be impossible to fully address those and other larger goals only through the revisions to the criminal code itself. A revised code is important, but it cannot achieve the deep structural changes necessary to transform the criminal legal system into a true system of justice. As members of the council, however, as the district's policymaking body, you are able to bear those larger goals in mind. And I encourage you to take up that challenge, to consider what it will take to reduce mass incarceration, to reduce racial inequalities, to invest in community-based structures for public safety and thriving, and to center human dignity. Doing so will guide you as you make decisions and exercise your judgment within this legislative process on the criminal code, and also as you consider what may come next. As Professor Ruth Wilson Gilmore has put it, dividing a problem into pieces in order to solve the whole thing is altogether different from defining a problem solely in terms of the bits that seem easiest to fix. You have an opportunity here to take on this piece of the work to solve the larger problem, and I encourage you to take it. Based on my professional experience and research, and as a resident of the district, I again express my great appreciation to the CCRC for its work and to the council for taking on the somewhat monumental task of comprehensive criminal code revision. I encourage the council to pass legislation that would result in this modernization of the DC criminal code, consistent with the CCRC recommendations. While we all recognize that there will be more work to do to improve the safety and justice of everyone within our city, these recommendations constitute a significant next step forward towards that goal. Thank you very much, and I'm happy to answer any questions that you have.
Thank you very much, Ms. Huffman. Next, let me turn to Patrice Sultan. Good afternoon, Ms. Sultan.
Good afternoon, Councilmember Allen. I'm Patrice Sultan, Executive Director of DC Justice Lab. And before this, I was a Senior Attorney Advisor to the DC Criminal Code Reform Commission. I was primarily responsible for rewriting offenses that could be subject to constitutional challenges. And I also helped with the general part of the code, including writing defenses and definitions of terms. People have already mentioned that the district has some criminal statutes that are really old, and I want to explain what that means in a practical sense. So the old common law basic definition of a burglary is entering premises with intent to commit a crime. Simple. If we read that literally, that's someone going to their friend's house to smoke weed, which is a federal offense, right? That's someone walking into their own home with intent to commit an offense against their roommate, like writing them a bad rent check, right? And under current law, first-degree burglary is punishable by 30 years in prison. Okay? I'm 36, 30 years of a person's life, potentially. We do have a second-degree version, which is a 15-year offense. And that's used if someone isn't going into a home and instead they're going onto like a steamboat, canal boat, railroad car, or of course, your yard of coal, right? That's how old these statutes are, our current statutes that we're using every single day. But for a more modern example, the 15-year version could be someone walking into a grocery store with intent to shoplift, or walking into the Wilson building with intent to commit a blocking and parading offense. Even if the person didn't actually do it, entering with that intent is technically enough for a completed burglary punishable by 15 years. And we might say to ourselves, nobody's actually reading these statutes literally, but just go read the cases coming out of the Court of Appeals every week. Go sit in arraignment court in the Superior Court, right? There are in fact a lot of instances in which our court is being asked to read these statutes literally when deciding whether or not someone has committed an offense. And as you heard, it sometimes takes decades for the Court of Appeals to interpret and clarify the scope of a particular offense. And in the meantime, so many people are arrested and convicted based on what everyone's best guess is about how that's going to turn out. Importantly, criminal courtrooms are not the only places where offense definitions matter. In civil protection order court, where parties are often not represented by lawyers, courts have to decide whether something amounted to an offense or not. If a person's suing over police violating their Fourth Amendment rights, the court will have to look at whether the person's conduct amounted to an offense or not. Even in contract law, right? You're not supposed to contract to do things that are illegal. But most commonly, it matters for the thousands of people who are on probation, parole, and supervised release, who could lose their freedom at any moment if they do something that is technically a crime. So the way offenses are defined matters a lot, the way defenses are defined matters a lot, and the penalties we authorize matter a lot. The problem is it's hard to fix them. It's hard as a policy matter, and it's hard as a political matter. It took an awful lot of effort to get the language right. In addition to the 1,900 pages of commentary, which I sincerely hope become part of the legislative history when this is enacted, there's also an appendix that's 900 pages long. And in that appendix, we responded in detail to every single written comment received by the advisory group, carefully considered every question and concern, spelled out why we were or were not incorporating their suggestions, explained how our reasoning aligned with our mandate, clarity, consistency, proportionality, and so on. There was no jumping to conclusions involved in this effort. It took a lot of hard work and it took a lot of thought. As a political matter, it's hard to fix bad statutes. Take that burglary example, right? I dare a council member to introduce a bill that does nothing other than lower the maximum penalty for burglary. It's very difficult to explain that to the public. Nobody thinks about the examples that I gave earlier. They think about the most horrific home invasion, right? They think about fact patterns that actually constitute 5 other offenses, all of which are more serious than the burglary itself. So when we have a bad statute on the books, it stays there for 100 years, even though nobody likes it. And it's going to take political courage to pass this bill. As objective as this process was, there are a few areas of criminal law that boil down to moral judgments. And that's what makes it so fun to teach as a professor. It pulls on our most fundamental impulses. And there will be parts of the code that you can't decide without upsetting one group of thinkers or the other. That is going to happen along the way. But my hope is that everyone will understand how good this package is overall. It is way better than current district law. It is way better than the model penal code, and it is way better than any criminal code in any other state. Nothing man-made is ever perfect, and our sensibilities will change over time, but everyone should resolve to pass this measure and commit to making it better and better after that. I'd like to go into a bit of detail about the weapons offenses we rewrote. Weapons appear in a lot of different parts of the code. They're in their own special chapter in Title 22, but they also appear in the firearms regulations in another title, in the DCMR. They're tucked inside other offense definitions as elements and enhancements. So just understand that we basically punish the following, right? Illegal possession, possessing with intent to use in a crime, possessing while committing a crime, or using to commit a crime, right? And if you take all of the existing statutes and segments of statutes, unbundle them and rebundle them into those categories, you can see that the penalties we have don't make any sense at all, right? If we take possession, for example, we have lots of laws about illegal possession based on the type of weapon, who you are, or where you are. We have the same penalty for simple possession of self-defense spray as we do for possession of an assault rifle. It's weird, but true, right? People can get more time for the assault rifle, but prosecutors have to rely on other laws. Was the person carrying it? Do they have a prior felony? Were there drugs nearby, et cetera? But most people would agree that simply possessing an assault weapon should be punished differently than simply possessing mace. It's more dangerous. So the RCC changes the penalties for possessions of things that are super dangerous, like assault weapons and bombs that are actually not punished very severely, and treats other weapons differently. And the other thing the RCC does, which is novel, is we created a new offense called endangerment with a firearm. Other states that have hunting sports have endangerment statutes about shooting across highways and stuff like that, but nobody else has an offense like this yet. So I wanted to explain what it is. So under current law here and elsewhere, you have liability for possessing a firearm, that's a weapons offense. And you have liability for shooting at a person, that's an assault offense. But in order to prove an assault offense, you almost always need a witness. Because of how offenses are defined and because of how the confrontation clause works, you almost always need to go out and find a person who saw what happened and is willing to come to court and say, this happened, he did it, it was unprovoked. And sometimes that's really hard to do. So what's happened over time is we ratcheted the penalties for simple possession of a firearm way up, the maximums and the minimums, and made that the only solution available in some more serious cases. So we have possessory conduct, most of which is allowable in other states, that gets treated like shootings, and people end up going away for a really long time. So what we did here is we said, look, there's a big difference between possessing a firearm and discharging a firearm. If you get caught shooting, that's going to be its own criminal offense. No need to track down the witnesses to say I'm a specific person, no need to prove the elements of assault. You just can't do that, period. And if you do, you're not going to get the benefit of the reduced penalties in the RCCA for possession alone. I see I'm out of time, so I'll save the rest for questions. Thank you very much.
Thank you, Ms. Sultan. And I wasn't sure if you were going to identify yourself as a former CCRC member. So let me just make sure I say thank you for the hard work that you put in to this final product that is here as well. So look forward to getting with you on questions just a little bit. Next, let me turn to Mara Verheyden-Hilliard. Good afternoon.
Good afternoon, and thank you. I'm Mara Verheyden-Hilliard. I'm an attorney and co-founder of the Partnership for Civil Justice Fund. I am a lifelong resident of the District of Columbia and a parent of a District of Columbia public school, high school student. And I'm so glad to be here today and to discuss the incredible efforts of the Reform Commission. And I think it simply can't be overstated the amount of work that the people on this commission have put into this effort and what is now sitting before the DC Council, and the opportunity here for the DC Council to take meaningful action that can have a significant impact on the lives of hundreds of thousands of people in the District of Columbia. Many people today have testified about different specific elements, and I would like to be among those that is talking about a somewhat bigger picture, the larger picture of what code reform means, what it means to the residents of the District of Columbia, what it means to people as a whole. And to address the criminal code, we have to understand the realities of our criminal justice system, which is more accurately defined as a criminalization process system, and the way it operates in our society. In terms of the code, the laws, sentencing, prosecutors, police, these are all entwined. And the system that we live in our society operates to sweep away and out of sight and out of mind the failures of our society. This criminal justice criminalization system, it acts to tell the public that it's addressing crime when in fact it does not address crime in any meaningful or effective way. It works to sweep away the failures of society to address the vast economic inequality, lack of opportunity, historical and ongoing exploitation and oppression, as well as the failure to provide meaningful mental health services in our population. Instead, the way that our laws are written is they're laws addressing particular offenses or things that happen at the end of that process or as part of that other process, instead of addressing the systemic failures of our society that bring us to this point. And the way that we're all trained to think about the law, and just as individuals, as lay people, as well as lawyers, is that we look at crime as if it's an individualized phenomenon that can be addressed by punishment of the individual. And the way that our system stands is that it turns our attention to the individual, focusing on racist tropes and then enforcing racist disenfranchisement, mass incarceration, family separation, the destruction of young people's futures, rather than addressing the societal issues that take us to this point. So how does code reform fit into this, or does it even matter when we're faced with such an enormous structure that is so imposing on our lives? And I believe it does matter. I believe that it matters very deeply and that it is a significant step as part of a greater effort. And just to look at some of the most significant overarching aspects of what has been put before the council, the efforts to address charge stacking, the efforts to address mandatory minimum sentencing, to change the capacity of prosecutors to basically escalate cumulative penalties in a way that forces people to plead no matter what, that deprives people of their constitutional right to challenge to a jury trial. In America, as we know, 2% of criminal defendants are able at best to go to trial, which means our constitutional right to a jury trial is just a phantom right. It doesn't exist. And it doesn't exist because of these types of provisions, these types of structures that allow a prosecutor to stack and stack and stack until a person feels like the best they can hope for is to plead to something, even if they're not guilty. And even if they're the victim of extreme police violence and police misconduct, because this is the other aspect of what happens when you can't go to trial. You can't go to trial means you can't explore and expose what the police have done. And that's something too that I think needs to be taken into account. There will be a lot of opposition to this bill. And I want to really acknowledge what Patrice said, which is that it is going to take political courage to take the steps that have to be taken here. And we know that there's going to be opposition, and that opposition may come from prosecutors, it may come from police, it may come from community members who love to work in, basically in lockstep with the prosecutors and the police. But all of us who want to stand for justice, and everyone on the council that is fighting really for their constituency, knows, and we all know in our heart, the way the system works in the District of Columbia, and particularly here, where you have a US Attorney's Office that is unaccountable to the people of the District of Columbia, a complete failure of democracy. We have to rely on the council to step up for the residents of the District of Columbia and to make the changes that will take away some of that prosecutorial discretion, that will stop them from being able to abuse their power to put people away, to destroy families, to destroy young lives, and to be able to operate with some measure of precision to give people a chance, an opportunity. This doesn't answer all of the problems, as I've said, and it can't. And there is a lot more reform that can be done, and there may be tweaks and things that can be made better, but we have to start with a change that can give people a chance, because there is no chance right now. If you get pulled into the criminal justice system and you are a Black person, a brown person, a poor person who does not have the opportunity to get out from under what you are facing, your life is destroyed. And there is no basis in our society for allowing that to happen if we consider ourselves a just society. So again, I am appreciative and grateful of all of the efforts that people have really put into trying to make this change, this step that's part of a much larger change that our society has to have. And thank you so much for allowing me to testify here today.
Thank you very much. Next, let's see, I think I have Mr. Piquero.
Good afternoon. One of the challenges of going later in the day is that a lot of things that you wanted to say have already been said. So I'm constantly deleting.
But you haven't
my
said
slides.
it. But you haven't said it yet, so you get to do it.
That's right. That's right. Thank you for allowing me the privilege to address you all and to be part of this session. My name is Alex Piquero. I am the chair of the Department of Sociology and Criminology and Arts and Sciences Distinguished Scholar at the University of Miami, as well as a professor of criminology at Monash University in Melbourne, Australia. I also grew up in Washington, D.C., so this is both personal and important to me. I've been a criminologist for over 25 years and have consulted with city, state, federal, and international political leaders and government agencies on crime and crime policy around the world. It is absolutely clear, as everybody knows, that the U.S. incarcerates more people and for longer periods of time than any other democratic country. We rival Russia, Iran, and China with respect to what we do with our incarceration, both when you include jails and prisons. The effects of these decisions on reducing crime more generally are small, but the costs to you, me, the citizens of the district, and our American colleagues is significant, not only with respect to economic costs, but to social and human capital costs. Long and long-term sentences do more harm than good on people, families, and communities. On people, we know that the risk of offending gets much lower with age. I've spent 25 years studying this precise issue. Incarcerating people into middle or late middle adulthood is inconsistent with what we know about criminal careers, and that is they don't last typically longer than 10 years. On families, taking persons away from children, spouses, and significant others removes potential role models and supportive socialization for young children. On communities, incarcerating people for long periods of time hurts communities by taking away labor force participants, hurts communities by taking away extra eyes and ears in the homes, on blocks, and in cities. The evidence is clear. We need less people in prison serving longer periods of time while they are in prison. As my colleague Mark Levin said, prison is good for people we are scared of, not people we are mad at. As I've also said, we can be smart on crime by being smarter on people. The proposed changes of B24-0416 are smart and deserve the consideration of the Commission. The COVID-19 pandemic has offered the criminal justice system, as well as political leaders, a window of opportunity to reimagine criminal justice and start making better decisions. Windows, however, close, and sometimes they break. I urge the Commission to take a serious look into this proposed legislation and make the right decisions moving forward. Thank you for having me be part of this important conversation.
Thank you very much. Next, let me turn to Maya Fernandez. Here's Maya. How you doing?
Good afternoon, Councilmember Allen. Thank you so much for having me today. As you know, I'm Maya Fernandez. For the past 2 years, I've served as a senior fellow at the Justice Policy Institute, an organization that develops credible solutions to problems plaguing our juvenile and criminal justice system. Previous to this position, I served for 10 years as the executive director of the National Center for Victims of Crime, a national organization providing training and technical assistance and access to research on the best practices and policy development on behalf of crime survivors and the organizations that assist them. I've also been a prosecutor in the Manhattan District Attorney's Office, and I helped run the Latin American Youth Center here in DC for 13 years. However, today, my testimony is through the lenses of a victim advocate. I would also like to say that I've been a district resident for quite over 30 years at this point, and most of that time I've spent living in your ward, Chairman Allen. It's a lovely ward. I will bring all these perspectives to this matter, again, thank you very much for having me here today. I really want to commend the Criminal Code Reform Commission and its advisory members for their work in presenting this proposed revision to the District of Columbia Code. The bill before us creates transparency and eliminates confusion in the interpretation of the law. The revisions are based on prevailing research on criminal justice. They also incorporate principles of equity and fairness into the code rather than simply those of punishment. Most importantly, the changes do not compromise the safety of the district residents, and I believe will provide crime survivors with an easier and less painful path to justice. Maneuvering through the criminal justice system is often difficult and traumatizing for crime victims. The roles of each party in the case are not easy to understand, and the rationale for certain procedures is often perplexing. The lack of agreement amongst prosecutors, judges, and defense attorneys regarding the meaning of the district criminal statutes provide significant latitude in the charging of crimes by prosecutors and for judges to make their ruling regarding sentencing and other matters. This further decreases predictability and certainty for survivors and discourages them from participating in the process. The revisions to the code would increase clarity, completeness, and consistency in the law, allowing for more predictable outcomes, and I believe will bolster victims' trust in the process. As we know, many of the revisions to the code aim to make sentences proportional to the harm caused, and thus a number of the instances propose a reduced length of incarceration for individuals. While public safety is a paramount concern for survivors, they are not necessarily wedded to achieving this goal through long sentences. This is particularly true if long sentences do not correlate with public safety. The current version of the code is based on antiquated and unproven ideas that mass incarceration and long sentences deter crime. The code revisions, however, are based on the prevailing criminal justice research and national best practices that promote both fairness to individuals and safety for the community. Research in the field shows that long-term sentences produce diminishing returns for the public safety, and as others on this panel have said, most of these individuals age out of crime in their early to mid-20s. The vast amount of people in our system are either middle-aged or past middle age, making it highly improbable that they will re-engage in criminal activity when released. Moreover, the research also shows the length of a sentence provides minimal deterrence to crime as compared to the certainty of interaction. We heard testimony earlier about this, and I will say again that it's the certainty, knowing that an individual who knows they're going to go to jail may be stopped from committing a crime because of that reason. In general, these are young people who don't have full brain development, that don't sit around calculating how long they're going to be in jail. So therefore, it doesn't become a deterrent of crime. Similarly, while proponents of mass incarceration proclaim that it reduces crime rates, research shows that in effect it is minimal yet extremely costly on a fiscal and societal level. Well, I can't sit here and tell you what every crime victim wants, particularly in their particular case. In general, victims want investments in what protects them from crime, not in solutions that have minimal, if any, impact on their safety. Investments in interventions such as drug treatment, mental health treatment, and employment assistance carry more promise for crime deterrence. We need to think of them as the means of achieving public safety rather than just soft on crime approaches. Along these same lines, a survey conducted by the Alliance for Safety and Justice and its affiliate organization, Crime Survivors for Safety and Justice, provides evidence that crime survivors are in favor of the types of revisions to the district's criminal code developed by the Commission. Crime Survivors Speak is the first national survey on victims' views on safety and justice. Overall, the survey found that the vast majority of victims thought that our criminal justice system relies too heavily on the use of jails and prisons, and that they would rather see funding go towards prevention and rehabilitation services rather than incarceration. More specifically, the surveys found that by a margin of almost 2 to 1, victims prefer shorter prison sentences that do not incarcerate individuals for as long as possible. Further, 7 out of 10 victims think that prosecutors should spend their time on solving neighborhood problems and stopping repeat crimes through rehabilitation rather than through convictions and long sentences. While these findings are national, my sense is that if you survey the majority of crime victim survivors in a district, would also but also support rehabilitation over long periods of incarceration. I encourage the council to commission such a report. In closing, I would be remiss if I didn't point out that the majority of incarcerated individuals are also crime survivors, almost exclusively from our poor communities of color in DC. The underlying trauma that plays a large role in why individuals commit crimes is rarely addressed and is further exacerbated by long sentences. The revision of the DC Criminal Code would go a long way to right-sizing sentences. The reduction in incarceration will create savings for the district if the strategy is properly executed. Those savings should be invested in community-based service, supports, and opportunities that victims are seeking for themselves and for those in the criminal justice system. I'd like to again thank the Commission for its work, encourage the Council to accept the Commissioner's revisions to the district's criminal code. They are just, and they will keep us safe. Thank you.
Thank you very much. And then our last witness on this panel, Troy Berner, Associate with the Justice Policy Institute. Mr. Berner, good afternoon.
Good afternoon. Thank you, Chairman Allen and other committee members for inviting me to testify at this hearing in support of the Revised Criminal Code Act of 2021. Currently, I'm an associate at the Justice Policy Institute, committed to assisting reform efforts here in Washington, D.C. and around the country. The road to this point in my life has been an arduous one. I'm honored to speak in front of this committee and share my story and perspective on how the antiquated DC Criminal Code had a direct and disastrous impact on my life. On May 27, 1994, I was found guilty of first-degree murder while armed, assault with intent to kill while armed, possession of a firearm during a crime of violence, and carrying a pistol without a license related to a 1990 shooting. The prosecution relied on profoundly problematic aiding and abetting statute in the DC Code. The statute that sent me to prison for most of my adult life was only 65 words long. It merely says that any person advising, conniving, or inciting of an offense must be charged as a principal and not as an accessory. There are no details on how one is to determine those factors in a court of law. The current code has been informed by case law that is confusing, inconsistent, and is devoid of clarity and precision. The current aiding and abetting statute is entirely silent on a necessary mental state to implicate aiding and abetting. It is absent of anything that says someone needs to have intent to aid and abet the commission of a crime. The absence of guidance in the statute leaves the authority up to archaic precedent. The lack of transparency in the statute has the effect of broadening the scope of aiding and abetting, shifting discretion and authority to the prosecutor. During my direct appeal process, the panel vacated my firearm convictions, removing the very same firearm it was alleged to have, that I was alleged to have on me to aid and abet. It was determined that the testimony that placed me on the scene of the shooting was false. I spent nearly 25 years in prison for a crime I didn't commit. The lack of clarity in the current code, particularly with regard to mental state necessary to constitute aiding and abetting, was a significant contributor to my wrongful conviction. The proposed criminal code revisions for aiding and abetting is well over 500 words with 10 subsections detailing and describing how the law should function. That is not to suggest that longer means better, but the clearness and exactness is quite evident. I would like to refer to section 22A-210, accomplice liability. Subsection B defines the culpable mental state applicable to circumstances of target offenses, indicating that an actor must intend for all circumstances or elements required by the offense. Although falsified, at the time of my trial, I was conveniently placed on a corner as a third assailant. However, there was no evidence offered to link my participation, to link any participation by me in the offense. The provision underscores the importance of mens rea, the mental element of person's intention to commit a crime. The structure and clarity of the revised code regarding mental state and intent, if in place at the time of my crime, would have prevented an innocent man from spending nearly a quarter of a century behind bars. The current code lacks due process and fundamental fairness. This in turn drives more plea bargains, longer terms of incarceration that are grossly disproportionate to crime, and in my case, sending an innocent man to prison. I, Troy Burner, am here today speaking on the significance of the criminal code revisions and the current code and its propensity to lead to unjust and unprincipled outcomes. I will be remiss if I fail to acknowledge and applaud the council's thoughtful and comprehensive and progressive efforts to date as it relates to Title 16, the Incarceration Reduction Amendment Act of 2016, and the most recent Second Look Act. Those reforms rightfully set the stage for revising the Criminal Act of 2021. I have been tragically impacted by the transfer from juvenile to adult, mandatory minimum sentences, and tomorrow will be my third year free pursuant to the Incarceration Reduction Amendment Act. Because of those things, I have been greatly impacted. And as a fourth generation Washingtonian, I'm deeply invested in our city's public safety and fundamental fairness. With the hopeful passage of these codes revisions, things may be different going forward. These code revisions cannot give me back 25 years of my life, but hopefully it will create and restore another layer of protection to future district residents to assure the grave injustice that happened to me doesn't occur to them. With all due respect, my journey is a prime example of everything wrong with the DC Criminal Code. Again, I would like to thank you, Chairperson Allen, and the rest of your committee for your diligent efforts. I also will be remiss if I fail to, include the CCRC giving me the opportunity to speak for something that it touched me all the way around the board. Thank you all, and I appreciate you lending me your ear.
Thank you very much, Mr. Burner. And I'm
available for questions if need be.
Oh, I know you are. I know you are. I appreciate it. It's good to see you again. And certainly
always
with your third, I'll call it a third anniversary tomorrow. And we heard from Mr. Walker earlier, who's coming up on 3 years as well back home. So very glad. And thanks you for spending the time with us today. Let me go through.
Let's get it done.
Absolutely. All right. Let me go through a couple of questions here for this panel. I'm going to kind of just follow back to the order and the way which most folks testified. So, Mr. Doliak, if I can start with you, not trying to stray too far afield, but you mentioned in your testimony that there are public safety solutions other than long sentences that are actually effective. I want to give you a moment if you wanted to expand on some of those tools and interventions that as a researcher, you've been able to identify, and just give you a chance if you wanted to share any of those.
Sure. So I mentioned two of the biggest ones. So summer jobs programs now have just incredible support, research support from a number of cities that is just giving teams something to do over the summer. It turns out doesn't just reduce crime while they are in that summer job, but puts them on a permanently different and better track. And then there's a variety of evidence also showing that giving people access to mental health care and substance use treatment also has really beneficial effects. A lot of violent crime in particular is a function of some sort of mental illness. And so giving people the help that they need is really beneficial. I actually put together a webinar series for the Niskanen Center this summer where we went through a bunch of these different types of programs. So if folks are interested, I would direct you to the Niskanen Center website, and we tried to pull in a huge array of top researchers to give short presentations, very short, summarizing their work, because we know that there's so much interest right now in figuring out what to do about rising homicide rates, which is, of course, a concern for a lot of people in a lot of communities.
Great, thank you. Then I wanted to also touch on this, and there was I can't remember which panel was on, but previous panel today, I think it was on our first one, we were talking about, again, lengthy sentences, extreme sentences, and if the belief is, and I think you touched on this in your testimony, I just want to give you a chance to expand on it, that one believes that a lengthy sentence is part of a deterrent strategy, that strategy is dependent upon everyone being a complete rational actor, and being able to, as I think I remember hearing you say, talk about, like 5 years from now, 10 years from now, 20 years from now. And I know as I talk with individuals that are court involved, that have been both victimized by violence, but have also committed harm, and we have talked about the nature of those decisions. I mean, very just point blank, folks have said, like, there's no discussion of like, one day when I grow up, or 20 years from now, right? Like the degree of also trauma that is experienced and hopelessness that can be there takes away from my conversation experience, like that type of theory of this completely rational actor type of decision making isn't there. And I think I heard you talk about that. I just want to give you a chance to talk a little bit more about that for me, as you have, as a researcher, been looking at this from, with your economics and other aspects.
Yeah, so as an economist, I'm not going to give up too easily on the idea that people are rational and respond to incentives, but there are different margins, right? And I think there's this idea that I think where the research is at this point is that we know that people do respond to incentives on the margin, but the overwhelming consensus is that people are just not, this group in particular is not looking super far into the future. If you're the type of person who's kind of, who might be affected by policy in terms of whether you are going to rob a convenience store right now or get into a fight with someone on the street corner, you're not thinking about 10 years from now, and that, the mandatory minimum that might be put on that sentence just isn't factoring into the decision making. Other things might factor in, like the probability of you getting caught, which I also mentioned, but it just turns out that that the group that we are most trying to target here, which is typically younger men, as someone mentioned, we know the brain science is such that your brain isn't fully developed until you're at least 25. I mean, this group is just not looking that far ahead when they're making these decisions and getting themselves into trouble. And so these long sentences just aren't having that deterrent effect that we might have hoped that they would have.
Let me turn to Professor Caro, but also Professor Doliak, you touched on this too, because both of you talked about a little bit of this criminogenic effect. And it's maybe a little bit counterintuitive for some, so I just want to give you a little space to kind of flesh this out a bit more. And that is that longer sentences may actually lead to increased reoffense or recidivism. And can you walk through, for example, how that plays out in practice? Just want to make sure we kind of fill out the record on this. How does someone who has a very long period of incarceration, why are they more likely to perhaps commit a crime that might lead them to another arrest and period of incarceration?
I'll let Jennifer go first and I'll follow.
Well, so there are a few potential channels. So one is that, you know, you're putting people into an environment where you're surrounded by a lot of other high-risk people who are facing similar challenges, similar traumas, and those kind of you know, bad influences, to put it bluntly, could rub off on you. So that's one potential channel. Another is that if you're taking people out of their communities and out and away from, you know, school or jobs that they might have been engaging in for a long period of time, it's just going to make it really hard for them to reintegrate successfully into their community when they get out. What are we expecting people to do when they've been, you know, sitting in a jail cell for 10 years? They just, you know, they don't have the skills they would need to be able to reintegrate successfully. So I think those are kind of the big ones, but I'm eager to hear what else Alex has in mind.
I'll add two to those. One of the things that we've learned about incarceration facilities, and we're talking about prisons, not necessarily jails, is the heterogeneity or the huge variability of how much programming is available in certain facilities, the fidelity with which those programs are available, and if they're targeted to the needs of the offender. That's a lot to ask, and it doesn't always play out the way we want in practice. We know really well that there are some practices and programs that work for offenders, even the hardest deep end offenders. They're not always available at the scale we want and always implemented with fidelity. So when we're housing offenders, we need to give them the kinds of skills that are going to translate back into the real world. Now, when they get back into the real world, our society creates roadblocks. For example, you've had the discussion, you all know, familiar with ban the box things and an amendment for it in Florida about how you can get the right to vote. Yeah, you can get the right to vote. Oh, but by the way, you have to finish paying off all your fines and fees. And oh, by the way, you can't get a job because you've committed a robbery. Therefore, you can't get a job to pay off those fines and fees. So all of the things that we need to be able to have a more successful reentry for individuals who return to the community, we don't have those things set up. And so that's the problem with incarceration potentially having an adverse effect when individuals return back to society.
Well, thank you both for that. Professor Bergman, let me turn to you for a second. I want to focus on your testimony around the Red Book. So Red Book jury instructions are considered highly authoritative in the district's criminal justice system. I think some would say it essentially functions as a source of the law itself. Why is that problematic?
Because we struggle to try to figure out what the law is. And one of the things we struggle with is we're not a committee to create the law. That's the city council or the DC Court of Appeals. And so while we all have very personal views about what we think it ought to be, we can't make that the jury instruction. We have to struggle with whatever language is in the statute and whatever case law is out there, and then try to use our common sense and hopefully good judgment to try to craft a jury instruction that makes sense to lay people, that accurately reflects the law. And I wish people could come to some of our committee meetings because we struggle mightily with that. And one of the things that, you know, the committee members keep reminding ourselves is we can't create the law. All we can do is try to figure out what it is. And there are times, quite frankly, we sort of joked about a new statute will come down and we'll try to figure out what the instruction ought to be. And some people have said, you know, the city council ought to have to write the jury instruction when they pass a statute because it would give them a perspective of what needs to go in and to the thoughtfulness of it. And this revised code does that. I mean, it gives us a blueprint that's going to be amazing to work with. And we won't have to worry about, are we creating the law? We'll just be writing jury instructions to reflect what it is and a law that explains to us clearly what was intended. And that's going to be wonderful. As I said, a new 6th edition is going to be a monumental task, but it's one we'll take on with great fervor and we'll be happy to do it.
Well, all right, help me understand then. Are you saying that essentially the RCCA, if passed, would make the current Red Book obsolete?
Oh, yes.
Would the RCC be so clear that you wouldn't really even need a red book? Or is it that the RCCA would give you a just unprecedented level of clarity that then informs the red book in a way that is just much more clear and direct for juries?
It's the last. You can't just read statutes to jurors and expect them to understand them. And I haven't read the entire RCCA, but I've skimmed through it, and some of my committee members have already. And there are different there are elements, there are circumstances, there are like different things that have to be shown. And that's going to have to be explained to the jury in a layman's terms. And that's hard to do. And we struggle because all of us are lawyers on that committee. And we tend to sort of fall into legalese and all of that. And we have to step back and say, who's going to, are they going to understand? Are regular jurors in the District of Columbia going to understand what we have in this instruction? And we have tried over the years, I've worked on 3 editions now, to simplify the language and yet still retain an accurate statement of the law to the extent we can determine what it is. So the RCCA, they're not going to be able to just read the RCCA to the jury. It has to be put in layman's terms and pulling together the various aspects of it in a way that makes sense for each offense to somebody who doesn't know the law. And so it's not going to replace the Red Book. I'm confident of that, but boy, it will sure give us a roadmap to follow in drafting these instructions. And that will be such a relief.
What does the timeline for a process look like? I don't know if you heard earlier panels, I'd asked the question, because Director Schmeckel had suggested, well, once you pass this, you're probably going to create some type of amount of time because you've got an entire legal community that has to now get up to speed on, courts have to get up to speed on, to then be able to put that new piece in practice. So if we need to write a new issue, 6th edition, I guess it is.
Yes.
How long does it take? I'm assuming it's more than a weekend.
Well, it's thick, it's big, and it's gotten bigger over the years. I think at least a year. We did a 5th edition, was the most massive revision we had done up until now. And we put a good part of a year into doing that. And that was meeting really often and regularly. I have like 5 or 6 judges on the committee at this point. I have representatives from the U.S. Attorney's Office, the Public Defender's Service, the Private Defense Bar, the Attorney General's Office. So we have about 13 to 15 members. And what we did with the 5th edition is if I remember correctly, it's been a while, we divide up topic areas and we have subcommittees and they work on drafts and then we circulate everything and then we meet as a group and go over them. And it's time consuming. And I'd say at least a year, but I don't want to delay the implementation of it either because I think it's so important. But once it's passed, we will knuckle down and set up a timeline and do our best to get it done as quickly as we can, as long as we're confident we can do a good job.
And on that point, so there's definitely going to be, I'm speaking as if this is passing, but let's assume that it's passing. Isn't there going to be a pretty compelling fairness argument that once this is passed and signed into law, whatever the final version looks like, that there will be individuals who will be essentially awaiting, or who are charged, awaiting, and there's going to be this period of time where we have an interest in trying to think about how expeditiously we can put in place what we believe, if we've passed this, to be a more fair, a more comprehensive, a more straightforward and modernized criminal code. But the reality is that there will still be individuals who are coming before the courts, coming before decisions and sentencing. So how should we weigh that in terms of how fast we want to push, and at the same time recognize there are just some practical elements that have to be stood up for a new and revised criminal code to go into effect?
I think that's a hard question. And I think you're right. I think people who are in the system or get involved in the system would probably prefer, most of them, to have the new code apply to them. As Mr. Berner testified, I mean, there are aiding and abetting. There are all kinds of jury instructions and statutes that are important to people and that can have a real impact on what happens to them at a trial. It's a tough balance to make. And I think realistically, as you said, the judges, the practitioners, they're going to have to get familiar with it. They're going to have to understand how it all fits together. And if we had to do it piecemeal, gradually, based on the most common offenses first and work our way through them, I mean, we'll do what we can to do what we can get done in whatever time you give us.
Okay, so more than a weekend, less than a year, somewhere in there.
Somewhere in there.
All right. I appreciate it, really do. And I'm not trying to be flip about how complicated and how long that will be. I appreciate it. Ms. Sultan and Ms. Verheyden-Hilliard, let me try to bring you in a little bit on this. So throughout the day, we've talked a bit about how vague language fails to provide individuals with proper notice about the law. But vague laws can also create issues with enforcement, correct? Can you talk about, from your perspective, in what ways vague or ambiguous language can actually promote discriminatory or selective enforcement that then plays out in our city? And Ms. Sultan, I don't know if you want to go first, and then Ms. Verheyden-Hilliard.
Oh, she's hard to follow, so I'll do that. Sure. So I think sometimes we're talking about vague in terms of things are just broad and capturing too much conduct. And sometimes when we say vague, we mean unconstitutionally vague. And so I think it's important to point out that part of the mandate of the commission was to make sure that our statutes were constitutional. And I looked at a lot of First Amendment and Second Amendment issues and can tell you that we have language in our statutes that other states have already struck down as facially unconstitutional. So as we're thinking about victims' rights, right? And in addition to sort of like the judicial discretion piece and the crime survivors for safety and justice piece that was mentioned earlier, that's important to understand, right? That a lot of convictions are vulnerable to being overturned at any time. We're just waiting all of the time for the Court of Appeals to tell us what a statute covers and what it doesn't. When you have something that's really broad, especially at the bottom, right? We're talking about like those smallest misdemeanors, disorderly conduct, all of that defines the breadth of conduct that a police officer can use as reasonable articulable suspicion or probable cause to stop someone, right? So if everything that a person does is technically criminal, then there's no narrowing of when a police officer can stop a person, right? You have reasonable articulable suspicion of almost everyone who's walking down the street. And so I think as there's been so much public discussion about policing in the city, that's an important thing to keep in mind as well.
Thanks.
And following up on what Patrice was saying, I mean, I think to your point, Councilmember Allen, when you're looking at the issue of vague laws, that it operates in both directions, right? It's the person subject to them and it's the person enforcing them. And there are obviously challenges that my organization and many other civil rights organizations bring to unconstitutional laws because they are, unlawfully vague in such a way that, as it says, a person can't reasonably know what they may or may not do. But in application, this is a fundamental issue where you may have a law such that it's not going to be struck as facially invalid. One waits to see in a criminal defense application, as Patrice is mentioning, whether or not the challenge can go such that a person will be found not guilty because the law is too vague or has been applied in such a fashion to them that it's inapplicable. But the issue of discretion for the police is a huge one. And when you have police who are using the extraordinary powers that they have to deprive someone of their liberty interests, to use force, to use violence, to use lethal force against a population, and you have laws that become the predicate, the triggering factor for them to be able to act against a civilian. If we don't have extreme precision, then we are allowing the police with all of that massive authority to act in such a broad manner. And it's very dangerous. And we see it play out every single day in the District of Columbia and around the United States. And it also really matters too in terms of not just the police acting against them in the first instance and the charging and the prosecution. At every step of the way, we have to have the most tightly defined and precise language possible in order to actually protect the liberty interests of people, so that people aren't swept into a system and unjustly and unfairly arrested, prosecuted, and subject to the system that once you're in it, its level of brutality and disruption and destruction of lives, it's immeasurable. And, it's easy for those of us who aren't in it and who are observing from, a distance, or those of us who at least are on the streets and trying to work with communities on the streets. I mean, for folks that aren't there, we can look at things in the abstract and sort of say, well, what are the measures that we can take, or what are the deterrents and what are the incentives? But if we're not looking at the real situation, the real life situation that people are in every single day, where the decisions they're making are not just, and this is a little to your earlier question, but I think it's important, the decisions people make are not just these decisions as to, I'm sitting here and I'm thinking about this step, this step, this step. Decisions people make are based on their real life circumstances, everything that's happening to them in the moment, the sense of self-defense, the sense of need, the sense of where they are at, the sense of their options, their sense of their daily lives. There's no way to look at humanity as sort of clean, white coating rablats. And we have to look at our system and where we write laws in a way that protects people and is so precise and does not send people away for eternity based on some idea that they are faulty, they are broken because they failed to act in a particular way when they were on notice as to a deterrent, because it just doesn't work like that.
That's a great point. To you both again, let me ask this, again, kind of focusing on this ambiguous or unclear language. How much should we, the council, we, the city, be concerned that if we have unclear language, how much does that impact if you take two different individuals, but similarly situated, similar charge, even similar conviction, but can receive different outcomes because of the vagueness of the language? And I don't mean in terms of the discretion of a judge being able to look at some very case specific pieces, but I'm just talking about the actual process itself. It feels, based on the testimony we've heard thus far, that we really have a situation where that vagueness allows for even very disparate outcomes to play out for, again, similarly situated individuals, charges, and cases.
That's right. I think the threat statute is a great example of that, right? That we have one offense that's punishable by 6 months, and that includes threatening to inflict serious bodily injury. And we have another one that's punishable by 20 years. That includes threats to commit serious bodily injury or threats to harm property. And what happens is it just gives all of the discretion over to a prosecutor to decide who to charge with what. And they have to set policies internally or rely on their own instincts, which we all know are fallible and subject to bias like all other humans, in making those determinations. And that's what we see across all of the criminal laws, right? What happens is something happens in the news and those who represent us want to respond to that. And so we respond to things and say that we care about things by criminalizing it and attaching a penalty. And no one has the time to do the level of work that you saw the Criminal Code Reform Commission do in enacting these statutes. And so we write things really broadly, and we just expect that police and prosecutors are going to enforce it and apply it in a way that's consistent with the intent of the lawmakers and the intent of the people who elected them. And that's not what happens. And it's especially not what happens in a place like the District of Columbia, where our police department is enormous, our prosecutor's office is enormous, and we have this weird sort of disconnect in terms of accountability between the people who are enforcing law and the people who are subject to it.
And I'd like to give sort of an example that's sort of adjacent to this, which is, let's look at the example of the way that the riot law has been written and the way the riot law has been used in the District of Columbia. I mean, and then compare that, for example, with the restrictions on police conduct that were put into place under the First Amendment Rights and Police Standards Act. So you have laws that, not criminal code laws, but District of Columbia code that is very, very clear as to restrictions on illegal and unlawful police conduct in the context of demonstration activity. Laws that came after extensive hearings from the District of Columbia Council, after a series of cases that my office brought in class action cases. And these were put in place to restrict the police from mass arresting without particularized probable cause, from sweeping up demonstrations. And then what the DC police did years later, because they were bound by those laws, is they tried to end run them, and did end run them, by using the riot law, the District of Columbia riot law, and declaring that something that was a First Amendment activity was not a First Amendment activity, and somehow now fell under the riot statute, such that they could sweep up all persons, 200 people, who were engaged in First Amendment activity based on the allegation that it fell within a riot. And that's sort of an example where having something like that that was written so broadly and so unfortunately, and something that our office has been working on as well in terms of trying to reform the riot law in the District of Columbia, so that it isn't a tool that can be used in this punitive way against people engaged in demonstration activity. But that's an example where you can see what the police do when they want to have a basis to sweep people up off the street. That's in the context of First Amendment activity. When you have racist policing in Black communities in Washington, DC, well, you do have police that are looking at any and every opportunity to take a law and use it as they wish to use it in that community, where turn around and when they're in Chevy Chase, they're not going to apply the law in the same way.
All right. One more quick question, Ms. Sultan, for you. Again, as we talk about the language and being clear versus vague, kind of throughout, while I think we've heard pretty uniformly from most of our panelists today, broadly support for what's in front of us, some recommended there are some tweaks and changes. But we've had people say, well, but you're going to probably get opposition from prosecutors. You're going to get opposition from other places. I'll note that, U.S. Attorney's Office was on the advisory group that actually voted unanimously for this package. But I almost kind of hear you also making an argument that that type of increased clarity actually makes it better for prosecutors and can make their job more direct and clear. I want to see if there's anything you wanted to add around that aspect.
Yes, the readability of the code is really important and something that we paid a lot of attention to. So part of the difficulty with writing the statutes well is there's always a tension between being very precise and making something really understandable to the reader. And what we did is rely on a lot of defined terms. So there are a number of things that are defined in the general part, used consistently throughout the code, hopefully in a way that makes that red book drafting a lot faster and easier. And that makes it easier for the person who's reading it to understand what's going on inside that statute. And just like we as criminal defense attorneys have to explain the law to our clients, there are witnesses and complainants and victims involved in these cases who need to be able to understand what the law is as well. And it might sound difficult enough to explain the law based on the way it's written to somebody who is a strong reader and speaks English, but oftentimes that's not the case when we're preparing these cases either. And so we really tried to draft the statutes with that in mind, that people need to be able to read and understand what's on the page. And a lot of what the statutes look like, I think, resembles the Red Book in many ways.
That's helpful, thanks. Let me move for a moment. I think Ms. Fernandez and both Professor Piquero, you both talked a little bit around this aging out phenomenon. We've heard this kind of referenced a few times as well throughout the day. And I'm not sure if we actually had a full explanation on the record, just to make sure that the legislative record is built out. So can you, when you say the phrase aging out, and again, I'm asking a question that probably almost everyone on this panel can talk about, but it's part of the legislative record here. What do you mean when you say aging out? So we make sure that that's kind of clear.
Yeah, so I'll go over a little bit more detail to have it on the record, and then people can ask me questions for further information. So when we look at crime patterns with age, there's something called the age crime curve. And the age crime curve is an aggregate that looks at the age of people when they've been arrested. And it typically rises through early adolescence, peaks in late adolescence, early adulthood, and then it drops precipitously in the 20s to just about zero in the 30s and 40s very quickly. But that's an aggregate. it'd be like taking all of us on this call and asking each other what our ages were, each of our crimes, and then doing one overall plot. What that does, Commissioner, is it hides the variation. I could have a lot more offending when I'm 30, and you could have a lot more offending when you're 20, and some other people could be 0. So when you look at an aggregate or an average, it's like an average in an exam for a class. It doesn't tell you what everybody did. It just gives you an overall answer. It's a good guess. What we also know is that there's quite a bit of individual variability in offending patterns. So if I were to plot my age crime curve, I could look at every age, how many offenses I did. I could have an earlier age crime curve. I could have a later one. So there's both the aggregate and then there's also the individual. The problem is we're really not good at predicting human behavior, especially criminal behavior. So, and the same is true with judges. There's a lot of research on judge decision-making about their prediction about who may recidivate or who may not recidivate. So a lot goes into why people offend. So but in the aggregate, what we know about aging out is that most careers, when they do begin, most of them would end in their 20s, 30s, and 40s. In fact, in the some studies that exist on career length, which is the age when you start and the age when you finish, assuming you have still a non-zero probability even when you're 7 years old because you're still alive. Most criminal careers are about 8 to 10 years in length. They're not very long. And so the evidence is pretty strong that incarcerating people when they're 60 is really not good policy for lots of reasons. Now, you might want to incarcerate certain people for a long period of time, but that's why I talked about the people we're scared at compared to the people we're mad at, because obviously some people need to be in prison for lengthy periods of time. How much that long is a question for you all on the policymaker side. But other countries in the EU, even in the EU don't punish people who committed homicide for life, much less death. So, prison sentences of 25, 30 years, those things should be sunsetted back in the 80s. So that's what we mean by the phenomenon of aging out. And then also to impart the importance that there's still individual variability about your age crime curve might look different from Catherine's age crime curve, for example.
Thank you. That's really, I really appreciate that. I want to make sure that I think we've frequently in hearings, we talk about different topics, and it's helpful to make sure we get that on the record and kind of be able to have that to draw upon. Ms. Fernandez, I don't know if you wanted to add to that, or if you felt that was pretty sufficient there.
I think that's pretty sufficient.
Okay. All right. I'll come back to you in just a moment. Ms. Huffman, I think my recollection is, but correct me if I'm wrong, you had a quote in your testimony and you talked, I cannot remember the person you said, but you were talking, the gist that I got out of it was there's the whole, then there's the pieces of the whole. And I think you kind of talked about this is a moment where we have a significant piece of the whole, and that we really have an opportunity to help think about how best to address this piece. The whole, as I heard it, but correct me if I'm wrong, was also speaking just about overall mass incarceration and justice writ large. So this is rewriting and revising the criminal code can be a very significant part of that. But just want to give you a chance. Were there other pieces of that whole that you felt like you just want to make sure were highlighted in our discussion today? And if I missed that, your reference to that quote, please correct me.
No, you had it exactly right. That was Professor Ruth Wilson Gilmore, and talking about how the journey, the traveling to a place where, as a District of Columbia, we are able to really establish justice, address problems with racial inequity. Many of the things that others on the panel today have talked about in terms of the need for stronger social supports within our other systems, for being able to provide other types of services, for being able to do a whole range of things. All of those are things that can't happen within the four corners of a criminal code revision. And so, the point that I think Professor Gilmore was making and that I was making is that, we shouldn't let that sort of large perfect be the enemy of this good. At the same time, we shouldn't check a box with this good and not be thinking about that larger picture even as we're doing it. That's because there's going to be more work to do. And I think, the council is looking at a whole range of issues all the time that are relevant to to criminal behavior in the city, to safety and thriving of communities, all of those things. Those keeping that larger picture in mind makes it possible for us to also do the best work that we can on this criminal code revision, so that, as Alex was just talking about, when we think about how long is long enough for sentences, keeping in mind the idea that we do have a problem with mass incarceration, and that does drive racial inequities, and that there are these other considerations can help the council as you're thinking about what is that outside number. It helps as you're thinking about, do we or don't we want mandatory sentences? Those are just some of the sort of the values and the bigger picture needs that can help to inform the decision making that the council is tasked with in this important work. So, this piece of a whole is really important and is going to make an enormous difference in the way that, the other panelists here and that folks all day have been talking about. And so, that is not at odds with also keeping in mind this larger whole.
Okay, I appreciate that. Thank you. Mr. Berner, I want to turn to you. My appreciation again for sharing your very powerful story today. It, like many others, it's a reminder that the criminal code is not just some abstract idea. It's not just a theory. It's not just words on a paper, but it has real impact on people's lives. And just want to ask you, just as an opportunity, how much, from your perspective, how much of having the opportunity to have a chance to have our criminal code reflect our values can be, frankly, inspired by stories like your own, so that that abstract concept that sometimes we all can be guilty of kind of slipping back into this idea of kind of it's this theoretical thing, it's a committee report and a hearing, but when it's brought home for real life, how much do you think that being able to have stories like yours really help us as policymakers and lawmakers and as a community together make a change that actually is much more reflective of our values?
Well, I think for me personally, when you have them years on years, where you're reaching out to people and you're making attempts to, just be able to present something to them that give them pause to stop and whatever is going on in their day, and just to say like, wow, this is not right, and being in that situation and having the opportunity now is so surreal, because I basically, there's a saying, I don't know if it's, apropos right now, but it's, you live by what you die by, and pretty much, to a great degree, I feel as though I was destroyed by the code, when you speak into, what purpose it serves and why, it should be changed, it's just, for me, and my understanding of it, and there's so many different variations, is like, there are these things that people, when you go into trial and you just put in a situation where, you got to charge and document, so it's expected that how you receive, your justice is going to be based on a charge and document, and then you find out that's really, not true. And it gets to the point where, there's certain things that, for a common sense person, they'll look at and they'll be like, and it's far beyond me to say who has common sense, right? But, there's those times where it's just there's certain things that the vast majority of people gonna see and they're gonna be like, that's not right. But then you turn it into where you have the ambiguous code, this imprecise, that gives the opportunity to the prosecutor to give them many angles of how they convict you outside of specifically, sticking to the code, especially, when I speak of, mens rea and intent, there's certain things that, that suggest that infers, that's presented that gives one, the belief or the understanding that one some intended something, but then you take these things away and it's like with in that situation, this not necessarily, an attempt to bash prosecutors. But the reality is, if we're gonna keep it fair on both sides, if we're gonna keep it fair for one side, we got to keep it fair for all sides. And the objective is to protect sentences, and people that's innocent have the right to be protected as well, not just dealt with based on them being charged with a crime and a prosecutor is trying to, obtain a conviction and having many variations of ways they can go about getting that conviction. That's not right, and when it's all said and done, I think, my story, and my journey and how I got here and to be here, is a prime example of everything that's wrong with the DC Criminal Code.
Yeah, well, I definitely appreciate that. And, you and I have gotten a chance to know each other now for the last several years. And, you've always said as well that you want to use your voice to be able to speak for the voice of others that can't sit in this hearing and can't be here. And you've done that over and over again. I'm really grateful for it because it makes sure that we're grounded. So thank you. Last question I had for this panel, Ms. Fernandez, I was going to turn to you just for one more question. And that was, on the last panel, I talked with Miriam Krinsky about this kind of false dichotomy that we often see play out between quote unquote tough laws and quote unquote lenient laws, and then the relationship that has to public safety. And, your testimony touched on the notion that while victims and survivors may very well want offenders to be held accountable, that accountability is a broader concept than the only option of saying, I want to see that person locked up. For victims who pursued a criminal case and felt the process was worthwhile, what aspects of that process do we think, or in your experience, helps contribute to that sense of a resolution? If it's a question of just having agency during the criminal justice process, how do we better empower and support victims and survivors through that process?
So pretty consistently what's been seen is, what a particular victim wants in their particular case is going to vary. But what we generally see is that people are more satisfied with the outcome if they feel that there's been fairness and clarity throughout the process. It's when they feel like they didn't know what was going on, or that they expected one thing but got another. There's always going to be, excitement or disappointment as a result of the case, but whether you thought you were treated justly has a lot to do with the fairness that begins and ends with the process. And that means that there's some expectation of what's going to happen at each phase of a case, that the instructions are clear, that what's going to be happening to an individual as the case moves forward is sort of planned out and told. I mean, in the best of any situation, all victims should have an advocate in court because it's such a confusing place. But that is part of creating fairness in a process, and having a clear code is the first thing that you need. So I think that that's why that's so important, because it goes to that issue of predictability and fairness through the process for victims. Again, everybody's going to want a different kind of outcome, but you often can live with the outcome if you feel that it was fair and just.
And is there a way that we should, can we do both at the same time? Meaning that, can you undergo a comprehensive code reform and revision and improve the resources and supports available for victims of crime?
Yeah, and I would say that they need to go simultaneously. The code is where you start. You can make it so it's a bit more predictable than it is now. We've heard across this panel about the ambiguity, the uncertainty, the not being able to even give clear jury instructions. All of that adds to the confusion and actually kind of anger in going through it all. So that's where it starts. But then I think you have to give those other supports, services and advocacy for victims. And all of that has to be provided in conjunction with a clear code.
Yeah. No, I think I've had this play out so many times where I have someone that I'm talking with, a constituent, and they feel let down, they feel disappointed, they feel angry at a process where maybe it was, the prosecution decided to offer a plea deal that was a surprise to them. They felt let down, that there wasn't a fairness to it. And that's separate from, well, what was the length of what the sentence was going to be? It was about, was there a fair process? Was there a fair decision that recognized whatever the harm was that was done? And that vagueness, that lack of clarity, not having the code be clear, I think actually plays right into that. That as a victim and survivor, those clear expectations and sense of fairness makes it even harder to accomplish because of the lack of the clarity within the code. And I think as we think about the resolution and what accountability means, that has a really deep impact and a meaningful impact as well.
You said it really well, Councilmember Allen. What I would add is the right to be heard is a basic victim's right. However, it's often not enforced sufficiently. So in those cases where a plea agreement is offered and a victim isn't consulted, I mean, that just adds insult to injury. Mm-hmm. And when you're thinking that the individual is being charged with one thing, but it doesn't really play out in the process that way, again, that's a moment of confusion and lack of expectation, which leads to anger and real disappointment in the system. And quite often it can lead to not wanting to participate in it at all. What's in it for me? What am I getting out of this if it really seems unjust for me?
Yeah, that's a great point. Great point. Well, my appreciation of this entire panel, this has been another excellent discussion today to really think through all the hard work ahead, the just immense work of the CCRC to get us to today, but the hard work that's still in front of us. So again, my gratitude and appreciation for everybody's testimony, your recommendations, the discussion that we've had here, really appreciate it, and hope I can count on being able to reach back out to everybody as we continue the work. And I have confidence that I can. So again, thank you all very much for your time today. Really appreciate it.
Thank you.
Thank you very much.
All right, we are now going to move to our final public panel. We have 3 people here. I'm not sure if everyone is here, but we'll go ahead and get started with our 4th panel. And I know that we have Eduardo Ferrer, who's the policy director for the Juvenile Justice Initiative at Georgetown Law. I believe we have Bianca Ford, public witness. I think I see Bianca there. And we also have Michael Sirota, visiting assistant professor and associate deputy director for the Academy for Justice, Sandra Day O'Connor College of Law at Arizona State University. It looks like I see Michael there as well. All right, perfect. So let's just go in the order that we called. So I have Eduardo, then Bianca, and then Michael. Thank you all very much for taking the time. I know it's been a long day and we're kind of near the end. So thank you for being here with us. And I know you're going to help bring it home. So Mr. Ferrer, I'll turn to you.
All right. Thank you very much. Good afternoon, Chairperson Allen and members of the Committee on Judiciary and Public Safety. My name is Eduardo Ferrer. I'm a Ward 5 resident, a visiting professor in the Georgetown Juvenile Justice Clinic, and a policy director at the Georgetown Juvenile Justice Initiative. Thank you for the invitation to testify today. First, I want to begin by commending the current and former staff of the Criminal Code Reform Commission and the members of the Criminal Code Reform Commission Advisory Group for doing the heavy lifting in this endeavor. A wholesale intentional review and revision of our criminal code was much needed and long overdue. As the executive director of the CCRC noted in his transmittal letter, this effort marks the first comprehensive review and reform of DC's criminal code statute since 1901. To put that into context, when DC's criminal code statutes were first codified, the Wright brothers had not yet flown a Kitty Hawk. There had not yet been 2 world wars. Modern computers, the internet, 8 tracks, cassette CDs, and digital music did not exist. 12 amendments to the US Constitution had not yet been ratified. The United States only had 45 states, and child labor was still frequently used. Additionally, and importantly, in 1901, de jure segregation was still deemed lawful. Indeed, since the original codification of the criminal code in DC, de jure segregation has been lawful for longer than it has been unlawful. Moreover, after March 1901, there would be no Black Congress members for 3 decades, and the first woman would not serve in Congress for another 15 years. As a result, we should not only think about all that has changed and all that we have learned since the foundation of our current criminal code was laid, but also the context in which that foundation was laid, including the applications of both who, in the implications of both who did and did not have a say in the shaping of the foundation of our original criminal code here in the district, and what beliefs those drafters brought to the table when doing so. While obviously many amendments to the criminal code have been made since 1901, it is past time for us, the District of Columbia, to lay a new foundation for the criminal code that not only better reflects the context in which we live, but also the district that we want. And so before I get into the weeds, I want to reiterate my gratitude to those who worked so hard on this effort, state my support for the recommended revisions overall, and urge the mayor and council to lay this new foundation for our criminal code. Now, with that introduction, I'll focus the remainder of my testimony on the proposed DC Code 22E216, minimum age of offense liability. As you are well aware, Councilmember Allen, since 1901, we have learned a tremendous amount about child and adolescent development. Indeed, the nature and length of childhood and adolescence has changed both biologically and sociologically since that time. Based on this research, we have sought to update our code to make it more developmentally responsive in a variety of ways over the last few years here in the district. Establishing a minimum age for offense liability at the age of 12 is a critical component of ensuring that the definitions of criminal offenses are developmentally responsive. Perhaps ironically, prior to the founding of the first juvenile court in Chicago, around the same time that our criminal code here was first codified, the criminal system's approach to defining when children were liable for criminal code offenses was actually more developmentally responsive. In his famous commentaries on the laws of England from the 18th century, Blackstone distills the elements of the commission of a crime to a vicious will, the mens rea, and an unlawful act consequent upon that vicious will, the actus reus. In evaluating the concept of vicious will, Blackstone recognized that a defect in understanding is not something that really should constitute a crime. In evaluating the unlawful acts of youth, Blackstone viewed age as potentially causing a defect in understanding and recognized 3 categories of youth as it pertains to criminal liability. Infants under 7 who could never form a vicious will, adults over 14 who he did not give any special protections to, and a gray zone in between in which he thought or believed that malice was equivalent to the age. Thus, Blackstone proposed that the question for the courts when confronted with the unlawful actions of a youth under 14 years old was to determine whether the youth had the capacity to understand right from wrong at the time of the alleged unlawful act, recognizing that children under 7 could never have that capacity. As a result of Blackstone's formulation of the infancy defense, there was both an established bright line age of minimum offense liability and a defense to criminal liability available to youth above that bright line age that was based on developmental immaturity. However, with the founding of juvenile courts, most jurisdictions eliminated this infancy defense. They did so under the false belief that the citizen building goals of the newly designed court far outweighed the need to determine even whether the young person was guilty of the alleged offense in the first place. As such, whether a young person had the capacity to form a vicious will was less important to the court than whether the court could help the young person. The result of eliminating the infancy defense was harmful net widening. Youth without the capacity to form the necessary criminal intent were now being brought into a quasi-criminal court. Indeed, as the Supreme Court recognized in Kent, there was evidence, though, in fact, that there may be grounds for concern that the child receives the worst of both worlds in juvenile court, that he gets neither the protections afforded to adults nor the solicitous care and regenerative treatment postulated for children. Given this reality, it is time to not only bring the infancy defense back, but modernize it. And the proposed DC Code Section 22E, minimum age for offense liability, would set the minimum age for offense liability at 12 is an important and necessary step in this direction. So I'll answer a few questions. I'll answer one more question in kind of my testimony, and then I can answer a few more as well in question and answer. But why do we need a minimum age of offense liability? I started my testimony by essentially saying that we shouldn't keep doing things just because we had been doing them. And now I'm saying we should go back to this old guy Blackstone from the 18th century and do what he did. And he wasn't right about the age bands, but he was right to a certain extent in that we shouldn't hold folks accountable who don't have the capacity to form criminal intent, who can't, that notion of vicious will is not present, right? What we're seeing in young people, particularly under the ages of 12, 13, 14, is that it is a childish or adolescent intent, not this vicious intentional breaking of criminal law. And so when that capacity is not present, it's critical that we do not get them involved in the court system. If that capacity is not present, no response from the criminal or juvenile system is proportional. And not only is it not warranted, but it's also not developmentally appropriate way to respond to the behavior, and it's likely harmful to the young person and potentially criminogenic. Now, importantly, it doesn't mean that we don't do anything in response to the young person's behavior. It just means that we don't use the juvenile legal system, right? Which comes with sanctions like jails and probation officers to intervene in those instances. In DC, it's actually very easy to visualize what the alternative would be because we have a ready-made program for those who would qualify under the minimum age of jurisdiction. And it's the Department of Human Services PASS program. This PASS program, which is an intensive case management model, is actually what our diversion program, the ACE diversion program, grew out of. And so it's very easy to visualize. It has been an incredibly effective program and would be one example of how we would still intervene in the lives of young people whose behavior is not necessarily pro-social without criminalizing them. And so thank you very much for the invitation to testify today. I'm also available to answer any questions.
Thank you so much, Mr. Ferrer. Next, let me turn to Bianca Ford. Good afternoon.
Good afternoon. Greetings, Council Member Allen, DC Council members, esteemed panelists, and fellow Washington, DC residents. I'm Bianca Ford. I'm a former federal prosecutor and author of the book Prosecuted Prosecutor, a memoir and blueprint for prosecutor-led criminal justice reform. Thank you for the opportunity to testify this afternoon, and also to the Commission for undertaking and completing this laborious but imperative initiative. I served as an assistant United States attorney here in the District of Columbia from September 2015 through December 2020. During that time, I moved through the office's local and federal prosecuting units. On the local level, I investigated, indicted, and tried cases involving domestic violence, fraud, possessory gun and drug offenses, and violent crime, including homicide. I also argued matters before the DC Court of Appeals. I testify before you today as a practitioner, but also as a resident of Ward 8. My testimony today will focus on vagueness and significant omissions in existing criminal statutes in the District of Columbia, which impact practitioners and DC residents alike. I'd like to begin with a short anecdote that illustrates the practical impact of some of these deficiencies. Imagine you've just been recruited to join the U.S. Attorney's Office in DC, the only federal prosecuting office in the country with a local prosecuting division. Your first trial involves one count of simple assault. You recall from basic training that you're required to prove each element of the offense beyond a reasonable doubt. Before the judge takes the bench, you pick up your personal copy of the DC code book. You turn to the relevant code section, expecting to find the elements of the offense you're required to prove. Instead, you find only the prescribed maximum penalty. During the course of trial, the accused takes a stand and alleges self-defense. Before you begin your cross-examination, you turn back to your code book, intending to refresh yourself on the elements of the affirmative defense that you must disprove beyond a reasonable doubt, but no such provision exists. When you return to your office, your colleagues refer you to the DC jury instructions, which we belovedly call the Red Book, and after merely skimming it, you vow to never touch your code book again. While the anecdote is fictive, the shortcomings it highlights in the code are quite real and impact the prosecution, the defense, and our community. We as practitioners can turn to the DC jury instructions to overcome the code's shortcomings, but lay members of the DC community do not have that luxury. A 1995 Northwestern University Law Review article characterized the DC code as one of the lowest ranked codes in the US, failing to provide notice to the public of the conduct it defines as criminal. That should give us pause. And if I'm
candid, cause us shame. And the assault provision is not alone. Other criminal statutes suffer from equally problematic inadequacies. Kidnapping, for instance, is codified in Code Section 22/2001 and makes it a crime to seize, confine, or carry away another person and to hold or detain that person for ransom, reward, or otherwise. The provision is noticeably silent on whether the seizure must last for any specific amount of time, leaving it to the courts and to prosecutors to decide whether or not the legislature had any temporal limitation in mind. While the Supreme Court of the United States, interpreting identical text, concluded that kidnapping requires a restraint that lasts for an appreciable time, the DC Court of Appeals has held that the length of the seizure is irrelevant. The impact of this judge-made law in DC is significant. Just a few months ago, the DC Court of Appeals affirmed a kidnapping conviction based on a split-second interruption of a complainant's movement. There, the defendant had inappropriately fondled a woman he encountered on the street. He was charged with multiple misdemeanors for the unwanted touching and kidnapping, because based on the prosecution's theory, which was supported by the current version of the code, groping the victim equated to obstructing her movement in a way that arose to the charge of kidnapping. For perspective, the misdemeanor counts that he was charged with carried a maximum penalty of 180 days confinement. The kidnapping count, 30 years. As observed by Associate Judge Deal in the concurring opinion to that case, the court's interpretation of the DC kidnapping statute signals that to grab someone is to kidnap them. The Honorable Judge continued, we expect even the most stalwart of innocent persons to plead guilty to those lesser offenses whenever the government dangles this 30-year sword over their heads. The government insists it will keep its newly forged sword sheathed and wield it only when justice demands. This case demonstrates otherwise. The revised code, which requires that any confinement or movement of a victim be substantial, would avoid this absurdity and cure the unconstitutional vagueness of DC's kidnapping statute, amongst others. This is just one example of why this council cannot abdicate its lawmaking responsibility to courts or prosecutors. When the legislature fails to provide minimum guidelines, it gives carte blanche to the executive and judiciary branches to mold the law to accommodate their own predilections and blind spots. By clarifying the elements of charges in DC, the revised code will immediately benefit practitioners on both sides of the aisle, but more importantly, those who have the misfortune of becoming entangled in our criminal legal system. While the revised code may not cure all legal ailments in the District of Columbia, to do nothing when we can't do everything is the surest way to be a part of the problem rather than its solution. Thank you so much for your attention.
Thank you very much, Ms. Ford. And then our last public witness today, Mr. Sirota, I'm going to turn to you.
Thank you very much, Councilmember Allen. Thank you to the rest of the committee. I also want to thank the committee staff and as well as my former colleagues of the DC Criminal Code Reform Commission. So I am a criminal law professor at the Arizona State University Sandra Day O'Connor College of Law. I'm also an associate deputy director of the Law School's Academy for Justice. My scholarship primarily focuses on mens rea and criminal code reform, largely informed by my experience working for the DC Criminal Code Reform Commission. So I'm going to talk to you a little bit about some of the major takeaways and big picture things that I took away from that experience and also now teach my criminal law students about. But before I do that, I just want to take a step back and provide a little bit of context. Right? This is a historic bill. Okay, between 1960 and 1985, about half the jurisdictions in the United States adopted a comprehensive code based on the model penal code. No jurisdiction has, from the ground up, been successful since. So were the district to succeed, it would be of historic significance. And I also think it's of great practical significance for members for folks in the District of Columbia, right? So Mr. Ferrer had given us a sense of how much has changed since 1901. And Ms. Ford talked about the lack of clarity regarding assault. So I'm just going to go ahead and combine those two to tell you that something else that has been in constant flux since 1901 is what the mens rea of assault is, right? And so, you take an offense like an assault, it's about the most fundamental crime you could possibly imagine. And you take a basic issue like the mens rea, right? What mental state is necessary for the government to secure conviction of assault, right? Is an accident enough? Is it enough that the movement was intentional or voluntary, or does the actor need to have mental state as to the harm? And if so, what mental state? Awareness, some awareness, full awareness, a conscious desire. These are fundamental policy issues that the US Congress never resolved in 1901, and which amazingly, in over 100 years, remain unresolved today, right? I mean, courts have given answers, but there's still today is tremendous uncertainty over this basic question. Now, and that's problematic for a couple of reasons. So first, from an efficiency standpoint, right? Asking DC attorneys, prosecutors, public defenders, and judges to struggle through for decades this basic policy question that the legislature has the ability to resolve with a short swipe of the pen is unconscionable. But add to that what the actual impact is, right? Because when the law is unclear, you get unequal outcomes. And who do we think bears the brunt of that, right? It's the poor, the underserved, and people of color. And so what you have is you've essentially, when there's lack of clarity regarding the elements of defense or mens rea, you delegate to prosecutors to the decision as to, who falls within the mens rea and who doesn't. Even the Red Book jury instructions can only go so far in resolving this issue. And so, I think that the District of Columbia has some of the most incredible state, quasi-state court judges, right? The DC Court of Appeals, these are amazing jurists. But the reality is that judges aren't well situated to make mens rea policy or to make any other fundamental policy decisions, right? And so I think it is of the utmost importance that this code be adopted so that we can have a code that does the thing a code is supposed to do, right? Is specify what the government has to prove beyond a reasonable doubt in order to secure a conviction. And so assault is just one of many examples of places where we lack clarity, we lack specificity, and as a result, we're wasting tons of money and resources on litigating basic policy issues through the courts, right? There's also a democracy angle, right? Because at the end of the day, you all, the council members, have the democratic legitimacy necessary to weigh in on these fundamental policy issues. That's why the DC Code Reform Commission was such a great idea and institution. You hire a team, they spend time working through it, and then they present you with proposals. And it's up to you, and you make the call, right? That's how the process should work, not through unelected judges kind of making policy as they go. Okay, so before I wrap up, I just want to address one final point, which is that, if history is going to repeat itself, and I'm almost sure that it will, at some point, right, someone will see that whether it's strengthening mens rea standards or raising other elements of offense, you will hear from a prosecutor that, oh, if we do this, this is a threat to public safety. Okay, I mean, it's just the history of criminal policy reform efforts that anytime you raise elements, prosecutors don't like it, it makes their jobs harder. And so they push back. And the pushback is usually this really basic idea that when you raise elements, public safety is at issue. And I would just encourage members of the council to ask them for evidence, for support for that notion. I've spent years wading through economics and social science research and never found any meaningful support for the idea that marginal changes to criminal law doctrines impacts public safety, right? The deterrence claim behind it doesn't have any support, right? Because for deterrence to work, someone would have to know that you're making that change. Someone would have to make rational cost-benefit decisions and conform their conduct to the output of those decisions. There's no reason to think that individuals satisfy those criteria. Similar analysis could go to incapacitation. And given the uncertainty and how bad we are, judges, prosecutors, all of us together in predicting what people are going to do in the future. So I just want to flag that. And finally, I just want to thank everyone on the council for putting their time and resources into this project. I realize that, they don't necessarily give out political medals for supporting criminal code reform, but it is critical work, fundamental to what the government does. And the District of Columbia is fortunate to have council members such as yourself who are willing to put support and time and resources behind the effort. Thank you very much.
Great, thank you. Thanks to all three of you for your testimony. All right, going to run through a few questions here for each of you. Let me start, Mr. Ferrer, jumping back to your conversation around creating a minimum age of criminal liability. Are there other states? How many other states have set a minimum age of criminal liability at 12 years old? Or are there other ages you might highlight if you have examples.
Sure. So there's a national push right now to make sure that every state has a minimum age of criminal liability. Currently, as of January 2021, 22 states had minimum ages. It ranges from 6 in North Carolina, which is entirely way too low, and 12 in California, Massachusetts, and Utah. And then there are 14 states, I think, that are currently at 10. The United Nations Convention on the Rights of the Human Child, which every member state has signed on to except for the United States, recommended a few years ago that the minimum age of offense liability be 12, and then in 2009 upped it to 14. So the trend of where folks are headed is definitely setting minimum ages of offense liability, and hopefully it'll end up being somewhere between about 12 and 14. Here in the district, I think the recommendation from the Criminal Code Committee itself that it be set at 12 is incredibly reasonable. When I pulled some arrest data that I had from MPD by age for 2007 to 2015, about 1.13% of all arrests of young people, and I suspect far fewer petitions, involve young people who would qualify under this minimum age of offense liability. Even if we went up to 12, it would be about 3, or if we went to a minimum age of 13, so 12 and under, it's only covering about 3.5%. And even if we went up to a minimum age of 14, so 13 and under, it would only be about 10% of arrests in the district. 90% of arrests are 14 to 17-year-olds. And so we could establish a minimum age of liability of at least 12 very easily with little impact kind of or change to the world that we live in.
Got it. You anticipated my next question, which was going to be, can you talk about what our current population of 10 to 12-year-olds involved in the district's juvenile justice system or touched through arrest? So if I heard you correctly, it was, if I'm counting 12, that was about 3.5% in terms of MPD arrests.
That's correct. Yes. But far fewer petitions. I think most of those end up getting diverted, particularly. I have had very few 12-year-olds on my caseload over the last 15 years.
Okay.
Rightly
so. I assumed, that may be the arrest on the front end, but once you get past that, it's going to drop down further. Okay.
Correct.
Also, Mr. Ferrer, so previous panels, we've talked a lot about how the criminal justice system has become the catch-all for problems that went unaddressed by social service agencies. From a juvenile context, just want to give you a chance to talk a little more about how that plays out. What systems haven't worked for these young people that then land them into our criminal justice system? Again, you and I have talked about this probably in hearings plenty of times. Just want to make sure we lay it out for the record here for this hearing.
Yes, absolutely. And not to say this facetiously, but pretty much all of them. It is unfortunate that the delinquency system was in many ways designed as a very poor social safety net. The idea was we can create citizens, we can provide young people with services. And so we're going to have this very wide entry point that is this definition of delinquency, which just about every young person falls into at some point in their life. And we're going to selectively intervene with some kids, but we're not actually going to have the right services or powers to the court to intervene well. And so what you end up seeing most often is more harm is caused by the system. It either doesn't respond in a developmentally appropriate manner, it over-intervenes and turns low or medium risk kids into higher risk kids, making it more criminogenic, or it just creates much more trauma in that young person's life. So I'll say for the young people that I have represented on that younger end, typically falls into three categories of kind of cases. One is just purely developmentally normative behavior that is being misperceived as and treated as criminal. So we're criminalizing normative adolescence. Two is we're doing that in large part because of racial bias. So not only are we kind of treating normative adolescence in a way that we shouldn't, but the driver behind that is racial bias. And then the third piece that often happens is it's a young person who has a pretty traumatic history. And because we're not providing the mental health supports or the right interventions on the front end through schools or through community-based mental health systems, folks feel like the only way to intervene is with the only tool that hasn't been tried yet, which is the juvenile legal system. And that creates more problems than it fixes.
Okay. Ms. Ford, let me turn to you for a minute. I want to follow up on the issue of the Red Book for a second. And I really appreciate the story that you kind of helped highlight, which I hope for a lot of people crystallizes a lot here. So given that nearly every actor in the law enforcement and criminal justice system is going to have to become familiar with a new criminal code, I've kind of been asking this of a lot of our panels. The recommendation from the executive director of the CCRC was that we're going to need to at least create some delay in applicability so that education, outreach, it takes place, right?
Sure.
Do you have a sense, or do you have a recommendation if you think back as a prosecutor, how much would you need as a prosecutor to become familiar with the new laws? We heard that in terms of writing the 6th edition of the Red Book, it would probably take about a year for them to be able to get through and put that forward. They would be really grateful for the opportunity to put that 6th edition together with this, because they felt a lot of clarity. But what's the time frame that you think makes sense? And again, there's no right answer here. It's just more trying to get some impressions of what people think are going to be a right and necessary amount of time.
Sure. You have to remember that the U.S. Attorney's Office in the District of Columbia, and I assume OAG, is divided into sections. So each prosecutor is assigned to a section, and while they're in that section, they usually focus on specific categories of offenses. So for instance, when you're in misdemeanors, you're largely focusing on misdemeanor assault and theft, threats, things along those lines. And then you move up to the next section, and maybe you'll get some possessory gun and drug cases. So you'll focus on those offenses and those charges. And then you'll move to the next section, and you'll focus on burglaries and robberies, and it continues to go on. So I say that to say no one is going to have to digest the entire code all at once. So that's something to think about. And if it adds any perspective, we typically spend any time, and I say we, I'm no longer there, but the prosecutors who are in the office typically spend anywhere between 6, sometimes 3, depending on the needs of the office, but between 3 and 9 months, I would say, is typically the amount of time you spend in any section. So if you think about that, I'd say that in terms of any delay, it's hard to say the delay, but I think that information can add perspective in terms of how much time you all can allot to applicability.
Yeah. Okay. That's helpful. Again, there is no 100% correct answer on this. I'm more just trying to get the impression from a lot of folks as we help think about this. Can you speak at all about the struggles that you would have or colleagues would have when deciding which charge to use when multiple offenses would capture the same conduct? It's one of the things we've heard early on, is like trying to think about how the revised code could help look at and help streamline when we see either, whether you want to call it stacking or overlapping, whatever term we choose to use. From a prosecutor standpoint, trying to make some of those decisions, can you talk at all about just some of the internal struggles that you would have around how to decide for the same conduct, which multiple offenses would be the right, quote unquote, the right ones to move forward with?
I don't know that the decision of when multiple offenses apply, I don't know that there is a decision to not apply all of them. You present them to the grand jury typically, and the grand jury votes. And I think that that's the issue with how prosecutors' offices who aren't guided by really exact codes because it offers just way too much flexibility.
I guess, is it I'm trying to use the example, and you highlighted this and somebody else did as well, on the kidnapping, for example. Is there flexibility or is there not flexibility? And what I mean by that is, if the code is so vague that the judge said, I can't remember the way you quoted it, but that we would expect that, I think I heard the word sheath. So, that would have been not used, but it was. So I hear that, but I could be hearing incorrectly, that there was an expectation from the judge that there would be flexibility about whether or not to move forward with that charge. But then in some cases, to your point, it may be that all the charges are laid out and then you're moving forward. Like, can you help me understand a little more about where there is flexibility, but then where there's not flexibility?
Yeah, I think that at the end of the day, there's always going to be prosecutorial discretion, and every prosecutor should ask themselves with every case and every exercise of prosecutorial discretion, what does the law allow me to do and what should I do? Right now, the way that the code is crafted, it offers the flexibility to add a kidnapping charge to a case that is primarily a misdemeanor assault. That is tremendous flexibility. That is overwhelming discretion. And the way that the revised code is worded based on the statutes that I have read, it limits that flexibility. It limits that exercise of discretion so that it makes it more clear that only certain offenses or certain categories or certain degrees of offenses will apply.
Okay. All right. And then I'm not sure if you were with us at the very end when I was talking to Ms. Fernandez. My assumption must have worked with many victims and survivors as a prosecutor. I'm assuming, is what I hear at least, oftentimes is they want to educate themselves about what the offenses are that are involved in their case. Anecdotally, I guess, do you feel like you ever heard frustration or confusion about the code itself, that it led even victims and survivors to feel a sense of uncertainty about what could and could not move forward? And again, I shared, again, I've been approached many times by folks who feel a sense of, the best way I could describe it is a bit of unfairness. A decision gets made and it's not related to well, I want extreme sentencing. It's more of, I didn't feel like there was a fair process for the harm that got caused, but that there's actually a fair amount of vagueness that probably lends itself to that type of confusion or to that amount of feeling of unfairness and a lack of accountability, if that were the case. Just anything can you share about your own experience with that that kind of helps inform our thinking here?
Sure. I think, again, the lack of clarity allows for increased punitiveness. So when you think about, for instance, the current code, ADW is a violent crime, assault with a dangerous weapon. If that ADW offense involves a firearm, then a prosecutor can also charge possession of a firearm during a crime of violence, which carries a 5-year minimum. You can imagine that there are circumstances where victims and the accused will feel as though that is excessive, right? When I once had an ADW pistol whipping case where when I jumped onto the case, there was a PFCOB attached to it. That's a 5-year minimum for basically an assault with a firearm. And it's interesting. It's interesting to think about. I heard some other members of the panel talk about how that creates this plea coercion, right, rather than plea negotiation. Because if you have this possibility that you are going to be convicted for 5 years, of course you're going to take a plea and things like that. So that case was unique in that regard, but there are a lot of cases where people are strong-armed, I would think, into taking pleas because of how the code allows over excessive charging.
That's helpful. I appreciate that. And then any other, I think you gave a great example, which we'd heard about earlier today as well with this kidnapping statute. Are there any other offenses that you just found particularly difficult to work with that we should be keeping a very close eye on?
I think the argument about the lack of explanation of the elements basically apply to almost every criminal statute I've ever had to prosecute under. I am serious when I say I did not use the code. We all use the code book. So, when I think of robbery, for instance, one of the things I think the revised code does really well is it recognizes that there are varying ways to commit a particular offense. There are varying degrees of harm, and it sort of delineates by degrees in terms of which will apply, which I assume will be translated into how the penalties are assigned to these various offenses. I've seen robberies for Burger King snatches that were charged under the statute because it's so overbroad. It makes no distinction between degrees and harm caused. And one might argue that we account for that with the sentencing guidelines, but there is a benefit to being able to recognize that not all burglaries and not all robberies are the same, right? One size fits all is for t-shirts and baseball hats. It's not for offenses, criminal offenses. So I think that's something that the new code makes very clear.
Sure. All right, that's really helpful. Thank you.
Sure.
And then Mr. Srota, let me turn to you. First off, and thank you for volunteer. I was going to bring it up if you didn't. So thank you for self-identifying as a former, I don't know if we call you CCRC alums. But as with Ms. Sultan before, just really grateful as you've now moved on to other things, but really appreciate the hard work that's gone into that. You and your colleagues spent years working on this project that's in front of us. And as I've said, we still have a lot of work to do on our end now, but really appreciate the hard work that you and your colleagues did to get us to where we are now. So let me, especially with you, focus in, if I can, for a moment on something that we actually haven't spent a whole lot of time talking about today as a part of this, and that is the codification of general defenses. So the district's current criminal code doesn't really define common defenses such as self-defense or necessity. Can you share about why does that end up being problematic?
Sure, I'd be happy to. So I should say that I did many of the general provisions, but my colleague, the esteemed Patrice Sultan, I believe spent most of her time on general defenses in terms of hashing out the details, but I can definitely speak to you in terms of the big picture. And the big picture is something like this, right? So defenses, whether you're talking about justifications or excuses, right, either negate blameworthiness or they negate wrongfulness. So they're critically important. And yet, right, currently under DC law, everything is ultimately been kind of delegated to the courts, right? So the same problems that you heard me speak about when it comes to mens rea of assault similarly exist with respect to general defenses, right? And so because of that, right, I mean, there are just a host of fundamental policy issues that intersect with general defenses, whether you're talking about excuses or justifications, and you just don't have that clarity or certainty in DC because most of it's not codified. And then you just have the problem of, right, DC judges kind of making it up as they go. And so, right, the Red Book in all of these situations does a admirable job of trying to fill the gaps. Now, in filling that gap, one should ask why it is that we have a group of professionals filling in the legislative role. That's kind of a separate question, right? But regardless, it certainly does help in terms of the day-to-day practice. But yeah, because of that, you have that uncertainty, particularly, right, particularly the last 5-10 years, you know, self-defense law has become a real flashpoint in our policy debates and public discussions. And so, yeah, all the more important to have that clarity. Councilmember Allen, there was an issue that you had raised with Ms. Ford, and I was hoping maybe I could just chime in.
Absolutely.
So this was the issue of multiple offenses, right, and charging. And so this was something I myself spent a lot of time on, and I think it's also just something wonderful that our code does is really, me and my colleagues spent a lot of time thinking through these problems because, you know, we would look at indictments sometimes that would come from the U.S. Attorney's Office. And I mean, you know, you routinely see 6 or 7 offenses charged on what strikes you as just, you know, a normal robbery or a normal carjacking. But because you have all of these overlapping offenses, let me also just add as I go, right, you know, Ms. Ford highlighted that in most cases, right, sentencing discretion can fill a gap, but not always. So for example, our carjacking statute has a hard mandatory minimum of 7 years, right? Also, the elements of that offense are incredibly broad. So if you're filling up gas, you have your back turned, someone jumps in your car and drives away, that counts as carjacking. And at least in one reported case, the U.S. Attorney's Office charged that. And that's a 7-year inflexible mandatory minimum, which, by the way, is a sentence that it may be higher than people are getting for severe aggravated assaults or many other more heinous offenses. That's a problem with having a piecemeal code like we do, is you end up with these idiosyncrasies. But back to offense overlap. So what our code does, so first, we spent a lot of time trying to get rid of overlap, right? Trying to not have unnecessarily overlapping offenses. But to some extent, overlap is unavoidable. And so what we did is we took the bite out of it. The way we did that is through a comprehensive merger provision, which if adopted would be one of the most comprehensive, if not the most comprehensive in the nation. What it does is it lays out general principles for how to deal with multiple offenses. So right now under current district law, we apply something called the elements test. And the elements test is an incredibly formalistic analysis that says, you know, if there's any way you could commit one offense without committing the other, well, then multiple punishment is okay. And it works on this fiction of legislative intent, as though you all in the council were thinking that's exactly what we wanted to happen, right? And so what and that's developed as primarily as a matter of case law. What our code does, the merger provision does, is it lays out 6 or 7 common sense principles, which help identify when offenses should merge and how to deal with that. So it still would be the case, right, that the prosecutors could charge multiple overlapping offenses, though there will be less of them under this new code. But what matters about it is how many convictions and the punishment. And under this merger provision, they will all drop out except for the most severe offense. And so there's more, there's a lot more that can be said about that, but I just wanted to highlight because one of, I think, the important innovations that we have in the revised code.
And I appreciate you walking through that. Are there other states or jurisdictions you would point to as successful as examples of that type of merger provision?
So I believe that a couple of these merger provisions, so we worked off of the author of that Northwestern Law Review article, Paul Robinson, who is one of the sort of nation's, if not world's leading experts on codification. So he proposed something similar in, I think, the Delaware and Illinois codes, and maybe Kentucky. Now, I'm not sure which of those, if any, were adopted, but there's also some connection to the model penal code based merger. So I think we improve upon the model penal code based approach, but that's been adopted at least in a few jurisdictions. So we're not in uncharted territory, and we spent an incredible amount of time working with the advisory group and getting feedback from prosecutors, defense attorneys to really think through what the procedures and how everything should work, because we wanted to be able to implement this in a way that not only promotes justice and proportionality, but also efficiency.
Fantastic. All right. Well, it is 5:30. This has been an excellent final panel to help round out today's discussion. We've been going since 9:30 this morning. Let me just say I am deeply grateful for every one of our witnesses that have come forward today to help share their thoughts, their recommendations, their advocacy. In addition, again, as I've said, to the hard work of the CCRC team. So I really appreciate it. I know we've still got our work cut out for us, but I feel like this really laid a really solid foundation. As I mentioned at the opening, I know full well coming months there's going to be a lot of push and pull on different aspects of this, but really today we wanted to really lay out a really strong orientation of our how and why this is necessary, why certain decisions were made, why this package is put forward in front of us, and also why the district has to move forward with this. So I really think we've accomplished that today. And just again, to everybody who helped be a part of this conversation today, my gratitude for helping really have a very thorough examination of this and lay out that foundation as we continue the next step. So thank you all very much. I appreciate it. So with that, this is going to conclude the committee's first public hearing on Bill 24-416, the Revised Criminal Code Act of 2021. As a reminder, public witnesses who wish to testify at the committee's second hearing on the bill, which will be on December 2nd, can register by emailing us at judiciary@dccouncil.us at the close of business on Friday, November 26th. And finally, if you have any written testimony for our hearing on the bill, you can please email that to us also at judiciary@dccouncil.us by the close of business on December 24th. That's right, December 24th. The next meeting of the committee will be on November 18th, 2021, when the committee will consider Bill 24-372, which is the Voter Ownership Integrity, Choice, and Equity Amendment Act of 2021, also known as the VOICE Act. There being no further business before the committee, the time is now 5:30, and this public hearing of the Committee on the Judiciary and Public Safety is now adjourned. Thank you, everyone.